corrections inadvertently 5-6 pages has been left out in the annexes, my lord. I may be allowed to make the correction, my lord, and the matter may be taken up on Wednesday.
Wednesday, yes.
And my lord, the correction may be allowed, my lord. That order. Obliged, my lord.
Corrections allowed. So we made prayer for correction, making correction allowed. Yes. Yes.
May I please, Lord? Lordship, I beg to mention for listing, my lord, of a rate appeal, my lord.
But when did you file? When did you file?
2nd of February, my lord.
Why it is not listed 2nd of February? Call Baishaw. Who is for the registration? I don't know why it is to be mentioned. Call. Our time is taken. Why this time is taken for? Unless if there is a defect and if you mention, you will pay heavy cost. We are telling you. If for genuine reasons is not listed, we'll allow. But if you are defective, if it is found to be defective and you are making mention, you have to pay a heavy cost. We are warning you. But we also not tolerate any lacks on the part of the registry also. Call. Anyway, make a mention. Yes, you wait for some time. Yes, next. Call Boyce. Yes.
May it please your lordship.
Yes.
Lordship, I beg to mention for listing of a petition which was filed on Saturday, lordship. This Saturday.
Saturday.
Lordship, actually, what happened, lordship? The matter relates to surface, lordship.
Correct. When did you file Saturday?
Yes, lordship.
What time? Saturday you
Saturday at about 11:30. Lordship, tomorrow, lordship, because lordship, the bank will take position on Wednesday, lordship, and
what you have been doing earlier?
Lordship, that notice has been issued only. Telephonic information has been given only on lordship 2nd of February. Lordship.
Suddenly the bank issue notice telephonically.
Lordship,
the process must have started.
Lordship, possession notice has not been issued. Only telephonically they have informed, and despite of the petitioner has already deposited, lordship, compromise first installment and second installment of the compromise settlement.
What position will dispose the bank? Any authority cannot behave arbitrarily. We will dispose. They cannot act in this country arbitrarily. Everything has to follow the due process. If the banks tell you over the phone that we are going to possess, sorry, we will come up, we'll dispose. If you say that the notice, the process has not been adhered to, we'll dispose. Yes, you'll come up Wednesday.
If possible, lordship, tomorrow.
We told you we'll dispose the bank. We'll impose heavy cost on the bank.
Lordship, once possession is taken,
doesn't matter. We'll tell the bank people to get out of your house. We have the authority to do so. Yes, if they have acted illegally. Yes.
Obliged, lordship.
Yes, Nick.
May I please, lordship?
Yes.
I'd like to mention for listing of filing number, serial number 810/23, dated 21/23.
What? You want? You wait for your turn. Yes, Nick.
Lordship, for listing, lordship.
What listing?
Listing of writ appeal, lordship.
Writ appeal.
Writ appeal.
Why?
Lordship, private party, actually it's a dispute between railway and a private party, lordship.
Oh, when did you file the
21/23. 20 January 2023.
It has not come up before this
No,
court.
lordship.
Why? Give a list. I want to find out why these matters who have been filed on so many days have not been listed before the court.
Yes, sir.
We'll take care. You just wait. Yes.
Daily list for motion item 1.
Who is responsible? They call that concern officer for filing and all those listing. All those people. Yes. Yes. Next.
Yes, my lord. This item, my lord, actually, this is the case, my lord. This is a Ghosbra Automobile, unit of Ghosbra Electric Private Limited, who is a dealer in Tata Motors. And they have taken a loan from the bank of IDBI. Unfortunately, since the dealership went out, that they have suffered a loss and account became NPA. So, my lord, what happened actually? One of their property, ancestral that residing dwelling house, it was mortgaged with the bank and in the name of her, one of the director's wife, Gita Rani Ghosh. That's why she is the petitioner, and she is the mortgager. She is not a loanee, but she has the mortgage of the property, as described in below. What happened? they have, once they fail the default in, they issued, the bank issued a service notice under section 32. And the 34 they have issued and they have taken possession of the property.
So what can be done?
Well, I'm carrying my lord, just a minute. Just a minute. What happened? Actually, they have taken possession of the property, but at that time we are not there inside the house. We are going outside, have taken possession of the key and they kept the property under lock and key. But there we have certain belongings, very valuable.
But then you must have been given notice that we are going to take possession.
Yes.
You are also aware that the bank is proposing to take possession of your property.
No. Bank suddenly they have taken possession. But at that
Suddenly,
time,
they just suddenly come.
no, they have given notice.
Then
Yes,
you should have taken necessary
Yes.
precaution at a time.
My lord, what happened? That property.
When was the notice given to you?
That notice in India 2018.
2018 notice was given to you.
Yes, my lord.
Then what did you do?
And
2018.
after that 2018 notice they have issued and accordingly they have taken possession of the property in 22nd February 2018. They have taken possession of the property.
2018. That's
2018.
property. Now you.
No, I'm coming. There's certain belongings were inside my house premise. So what happened, my lord? Those belongings they have taken inventory.
Yes.
But when we come and we demanded, they have not given us. And in the meantime, they have tried to auction the property several times. And so many times we have filed a petition there. And so many times they are staying.
Basically, you want those property which have been left.
Yes, my lord, that's what I'm. Yes, my lord, there's valuable property.
Why you are doing this?
I'm appearing on instructions for the bank.
You take instruction, you don't allow this kind of acts. You may recover the test, whatever it is, but you have no business to take more than what is required to be taken. You take instruction day after tomorrow, we will tell, huh? We'll not tolerate all this kind of acts on the part of the authorities. You act according to law, no problem. What is this? Bosho, what is this? They say that one is the file in second of. Huh? When it was filed, they said. Anyway, it will get there, get back. But you find out why they are making mention that we have filed is not being listed. Okay. When you file a petition, there may be defect, genuine or bona fide, no problem. You get it rectified. And if it is not listed, because after that, then yes, you have a right to mention. But just don't mention like that, just because you have filed. Okay. And what about this other one? Check it up. Take it up and let me know. Yes.
For admission, item 2.
Yes.
In this matter, my lord, service is completed, my lord, and fixed date, my lord. My senior will appear in this case, my lord.
The appeal completed. Yes.
I'm
What
praying
is
for
it?
an adjournment today, Lordship.
Okay.
As the arguing counsel, Mr. Ganguly is unavailable.
Okay. List next.
My
week,
lord,
then, huh? Next
on-
week.
on
Okay.
my
On
lord.
the prayer of Mr.
A Dhanuka.
On 27, my lord, on 27, my lord.
Okay, 27. Good. 27.
27 February.
My lord.
Yes.
Item number 3.
What is this? Did appeal? Narendra Gormul?
May it please your lordship.
Yes.
My lord, this is a writ appeal filed against the order dated 19th
What
of
is the
July
problem? Why
2020.
you are yes? You are dismissed from service.
Yes, my lord.
Why?
Removed from service.
Why?
My lord, the petitioner went for a casualty for 10 days, my lord. He
Oh,
could not return on site because he started suffering from neurological disorder, my lord.
okay.
And he could not communicate with the department on time, my lord. And a show cause notice was issued to him, my lord, on 14th of
Any
June.
judgment you are relying on?
Yes, my lord. Two
What-
judgments, my
What
lord.
is that doing?
Well, it was rejected on the grounds of acquiescence, doctrine of acquiescence, and delay and lashes, my lord. Lordship may be pleased
Yes.
to come to page number 11 of the writ appeal, my lord.
Yes.
My lord, in the
Ravinder
case of
Singh.
State of Punjab versus Ravinder Pal Singh Bhullar, reported in 2011-14 SCC 770, my lord, it has been stated that inaction in every case does not lead to an inference of implied consent or acquiescence, as has been held by this court. Meaning that, my lord, there is no finality in the mind of the appellant that whether he'll be filing a writ petition or not, my lord. But it is not a case of acquiescence, my lord. It is a case of inaction, but not acquiescence, my lord.
You are serving before that for how many years?
My lord, for 37 years, my lord.
Before that, when you were appointed?
My lord, he was appointed, my lord, in 1997, my lord, specific
Date.
date.
Do you have annexed the appointment order?
My lord, the appointment order is not there. My lord, the date is given in page number 26 of the writ appeal, my lord, on
Yes.
2nd of June 1977, my lord, as an unarmed branch constable.
2/6/1977.
Yes, my lord.
Then when did you become a good moral character without any blemish?
My
Then
lord.
what happened? Suddenly, when did you suffer? You took leave on
My lord,
6/12/2011.
yes, my lord. It was
6/12.
6/12, he went, yes, my lord. He went for a casual leave,
And you are supposed to join on 16/12.
16/12/2011, my lord.
Then you suffer from this mental problem. For how many months?
My lord, he could not come back on time, my lord.
So he came on when?
My lord, he could not come back on time, my
So
lord.
he came back on when? When did he come back?
My lord,
He reported for duty when?
my lord, he could not report on time, my lord. That,
He could not at all report.
no, my lord, because
Then what
well,
happened?
first show cause notice
Showcause notice was
was
issued on
issued on 14th of June 2012, my lord.
14th of June 2012.
And which was received by him on 22nd of June
Well,
2012.
that means, so after about 6 months, you received the so-called notice.
Yes, my lord, the
Then
first
what did
show
you,
cause
then what did you say?
my lord, he couldn't communicate with the department. In the meantime, a second show cause notice was issued to him on 25th of October 2012.
25th of October 2012, second so-called notice.
Yes, my lord, to resume within 3 days, my lord.
Hmm.
In the meantime, a department proceeding was drawn on 21st of November 2012, my lord.
21st of November 2012.
Department proceeding where
Yes.
the charge was gross negligence of duty and dereliction of duty, my lord.
Did you make any response to that departmental inquiry?
Yes, my
Did you
lord.
take part?
Yes, my lord, a written, my lord, he gave a reply on 31st of March 2014, my lord. My lord, after a long time, because he could not communicate with the department because he was suffering from,
21/11/2012, where is that order?
my lord, 31st March 2014, my lord.
No, 21/11/2012, he was,
My lord, the second show cause notice,
no, we are not second show cause, but the first show cause notice. Sorry, that's a D. The charge was framed against you, D when?
the charge, my lord, this annex in page number 37 of the writ appeal, my lord.
Charge against, it is the first show cause notice.
Yes, my lord, the first
Then
show,
after,
my lord.
if we are asked to submit a written statement, then the second show cause notice. Then this is the charge against you. Then
Yes,
you
my lord.
submitted a reply when?
The reply was submitted on 31st of March 2014.
2014,
Yes, my lord. Because
after
my,
1 year again.
yes, my, because he was suffering from nervous
Okay,
disorder.
now
and-
that you are suffering from nervous disorder, what is the proof?
My lord, a
What is the
medical,
evidence?
my lord, a medical certificate has been, my lord, annexed, my lord, in page number 44, my lord. A type copy, my lord. Just, and it's in page number 44, my lord.
Narendra Burman, 57, was suffering from nerve weakness, neuralgia, and was under my treatment under OPD number, with effect from 10/12/11 till date 2014. Now he improved, advice continued. What is this nerve weakness, neuralgia? What is the neuralgia? I don't know. I am
My
not a
lord,
doctor.
my lord, the hands keep shivering, hands and the legs keep shivering, whole body keeps shivering, my lord. And now he comes from poor background, he could not go to a proper hospital, my lord, like for proper diagnosis, my lord.
So when you file this this reply on 31/3/2014, what
Yes.
did the police tell you?
My lord, on 31st, my lord, after submitting the written reply, my lord,
Inquiry officer D submitted finding Gross, you have the DE records with you.
No, my lord. Record is not.
Can you just produce the records?
Yes,
We want to have a look. Yes, can you have a look? When can you produce?
No, 1 week, my.
Huh? Anyway, then we have issued notice, no, not yet. We have not issued notice. Have we?
The matter can be admitted, my lord.
My lord, lordship,
Yeah,
please to admit.
Our means also.
And thus.
In that for the state. We. The police admitted. Considering the nature of the case, an attempt will be. Considering the nature of the case that the petitioner, appellant. Has served more than 37 years
Yes.
before he was removed from service, and also removed from service on the ground of prolonged absence, which has been explained as explained on the ground of a certain
Unauthorized.
mental illness, neuralgia.
Yes, my lord.
Which prevented him from attending the office. An attempt will be made to dispose of alias. Let the records be, since the DE was held against him, let the records of the DE be produced. This is the matter again on.
Next Monday,
Director video, when can you produce? Give a date.
next Monday. 13th.
13th, okay. Try to produce that, we'll see.
My lord.
We'll see that on that day.
Yes, my lord. Deeply obliged.
Next. Yes,
Item number 4.
what is this item number? Apply and post.
Mayor, please.
What is this?
This arises out of an industrial dispute referred to the labor code in respect of Supply Research Association.
Yes.
And the two basic issues, one was the point as to whether it's an industry or not.
Okay.
And then on the
Some
merits-
order was passed on some.
Your lordship
appeal
saw-
arises, there is a dispute for contentious issues between workers, management. Appealants in the line, there is overlooked therefore the spring management judgment. The fact that the points of reference before payment were considered previous in every appeal issue notice. It is adjourned to. Now, who is for the other side? You are for the other side.
Yes. he is a-
Okay. So what do you say? Anything about this appeal? Mr. Das?
hard.
Yeah, obviously, it has to be hard. Question is when, how, what time? This is the only question. We may have to requisition the records of the tribunal. That will come. Records of the tribunal.
Yes, so possibly there was an order earlier, I don't know. whether-
Personally, or tribunal record, tribunal records is here. Is the record LCR? Okay. There is LCR.
Because
Okay. Then we have to hear it, then we'll go through, we'll hear it.
I was having a suggestion for your lordship's time consideration.
Yes.
Because the basic issue was whether it's an industry or not.
Yes.
It's a very tricky point all through, from the 50s it has started. And to my mind, and which my friend also confirms, after the 7-judge judgment in Bangalore,
This is
which
the Krishna Iyer-
virtually
Krishna Iyer's judgment.
Krishna judgment, which wiped out all previous judgments. It has been referred to a larger bench. So that matter is pending before a larger bench. And we have not, at least I am informed that there has been no judgment.
Till then,
till
Krishna Iyer's
then,
judgment
which-
will continue,
Which
water
my
supply.
friend also is confirming.
Till then, the water supply will hold the field perhaps.
Yes,
Yeah.
and that is what exactly the learned single judge has, after a discussion of the entire issue, he took up that issue. And his finding, your lordships will find at page 143, paragraph 31. Where he says that it is referred, it is pending, but I am bound by Bangalore.
Yeah.
Therefore, as per Bangalore, a research association will also come within the parameter of the definition of one industry.
Yeah.
What I was suggesting, thereafter, he has not gone into the merits of each issue, taking a view that it is open for us to move some authorities and then proceed, which is contrary to the scheme of the Industrial Disputes Act. Your lordships are aware that a dispute is raised, conciliation takes place, then government makes a reference to the labor court or tribunal, which issues they decide, and an award is passed. If the award is passed, two ways, one is 226, the other is 136. Otherwise, by virtue of section 17 and 17A, it becomes enforceable after 30 days. Therefore, I can't, if the award stands, there is no question of moving any other authority to get my relief, because the argument was that it will virtually lead to a closure of the association if this award is implemented. Therefore, what I was thinking, my lord, subject to your lordship's consideration, that let us, for the purpose of this case, assume that it is an industry. In future, it will be governed by whatever the Supreme Court decides. For the purpose of this case, let that question be kept open. Next question is then, the learned single judge has not really gone into the merits of the dispute. Therefore, your lordships can send it back to the learned single judge to go into the issues on which findings have been recorded. The one finding I find that it was not disputed. That's not correct. The written statement and the evidence for both sides are, with great respect, are very unhappy.
Yes.
If I may say, put it mildly.
Yes.
But therefore, one has to decide, go into it, because some of these issues are covered by a statute. For
Yes.
example, the issue is whether pension is you need to have a pension scheme. Now, your lordships are aware this Employee Provident Fund Act was amended, 6A was brought in. There is a scheme operating which covers all industries nowadays, and the association also is implementing. So all this is possibly not brought to the notice of the labor court, and also single judge has not really gone into it. At page 143, as I have said, is the finding that it is an industry. I accept that for the purpose of this case, and keep this case point open, whether it's industry or not, to be finally decided in terms of the Supreme Court judgment as and when it comes. For this case, let us assume it is an industry. And then, your lordship can give a
According to, if it is industry, assuming for the purpose of this proceeding, that it is an industry,
yes.
assuming it is industry, then what are your liability obligation that has to be looked into, which has to be adjudicated?
Has not gone into it.
Yes.
See at page
Yes,
140.
Mr. Dasgupta, what do you say about this? Because what I know point, if that is so, then go
No,
back to
Lord.
the learned singles as if that is so. Of course, we have yet to
Yes.
apply our mind.
Yes.
We'll see that. But if you say so, then otherwise, if you have problem, then we'll of course examine this issue.
Yes, no, that issue has to be examined because.
No,
they
bias,
have-
bias.
Oh, yes, my lord.
I see.
Because all these issues are
Have
the
been-
statutory dues, my lord. And that apart.
No,
they have
examined
not-
by the learned single judge, that's what I'm saying.
No, that apart, my lord, they have not asked this point. Because if your lordship goes through their read appeal, page 20,
No, we have
paragraph
said somewhere.
32, they have specifically stated. It was not asked because of the fact that the issues are covered by the statutory provisions.
No, this is where it has gone wrong.
Okay.
It was pointed out and
Management. This
I would-
Toklai, according to you, has more or less gone, Toklai is still surviving or what is there? Going-
with great difficulty it is surviving, because now the position is, my lord, the funds are coming from central government, routed through.
And what is the grievance of this union? What is the basic,
The issues are, if your lordships kindly have a look at.
what is the demand which led to
Kindly
this
see
litigation?
the reference.
No, kindly tell us, no problem.
My
Just
lord,
in
it
brief,
relates to
non-payment
pension scheme,
pension scheme.
then special duty allowance. And then, my lord, the
Pay commission.
pay commission.
I see.
And then,
They have raised his
Yeah.
demands, then what did you do?
the.
No, I'm just, we are not asking any, see,
No,
this is
I'm just.
what did you do? Once they raise his demands that you must have this pension scheme, you must give this, you must
Milord,
give that. What did you do?
Yes, your lordship is right. For example, let us take the pension scheme.
Yes,
Pension scheme, now, my lord, every industry.
can formulate their own.
No. There is a scheme prepared under the Employees Provident Fund Act
Yes.
pursuant to amendment in 1995. There is a provision 6A, and pursuant to that, a scheme has been prepared, and that we are implementing.
I see.
So the direction that have a scheme is without considering the.
You mean to say that already a scheme exists, it
Yes,
is being
this is
implemented?
statutorily I
Okay.
am bound to implement it.
Then they are still demanding it.
They were making a demand. The labor court, without considering the amendments, has passed an order that have a scheme.
Okay, then Mr. Dasgupta.
I think there is something to be
Anyway,
said on this.
very well. Then we have to hear it, whatever, whatever, we will hear it.
Yeah.
And but otherwise, you are getting your salary and other parts,
Yes,
you want
yes,
to enhance.
In fact, Miller, the salary in this.
They are
because
getting-
Initially, they were.
So far,
It doesn't contain
it is
any
more than
retrenched
is that-
workers
We
or.
we have indicated in a paragraph, it is more than what the state government is paying to similar workers.
Well, so far pension scheme is concerned, there was an agreement between the management and the workers.
All
That agreement
agreements
was
have been
made
set.
in the year 1997.
No,
that
that
they
is
will
all.
promote a pension
That's
scheme.
all agreement,
And
it's all
this pension scheme
superseded.
came in the
This
year
statutory
1995.
Thing has come.
Despite having that pension scheme, their settlement was
No,
there.
that's not correct.
Now they are taking the plea, and no, we are covered by that.
No, that
That is one
statutorily
aspect.
covered.
Anyway, you are getting some pension, but you want a better, that
No,
agreement provides you a better return.
Because
Okay,
as per
fine.
their settlement.
Okay, very
There
well.
was a settlement in the year
Okay.
1997.
So what we are made to understand is that your workers are right getting certain benefits, but you want a better terms as per the agreement or whatever it is, isn't your case?
Only
It is not that you are laid off or something, you are out of job, you are not getting, so we'll hear it then.
Only two issues are recurring.
We'll hear it, we'll hear it.
With the statutory provision. No evidence
Records
is
have been received, matter requires consideration of this court. Let it be heard. This is the matter for hearing. And so,
Your lordship may kindly fix a date.
okay, we'll fix a date at the date of February, March, February, March. We'll see that.
2nd of March.
No, you have it after
After.
15th of March.
Yes.
Yes, Vivo. Yes, next.
21st March.
Uh,
Item 5 to 7.
The interim order will continue.
Early interim order pass will continue till then. What is this NC Das allied? What is this? UK Goswami, yes, what is this? Yes, Mr. What is this?
Oh, the three cases are analogous. No?
Huh?
That is the appellant has.
What is the basic issue involved? What is the basic,
2022.
what is the basic issue involved in this appeal?
Here I am agreed that the appellant has agreed because the direction contained in the judgment matter. Direction is that send the matter back to the authority to verify the matter. Here is a case. What happened? A batch of writ petition were taken up by this learned single judge. On the request of the learned council, standing council for the forest, these matters are all of a sudden came before that batch. I placed my case before the learned single judge. That this is slightly different because here the pleading has already been completed. Unlike other batch of the writ petition, here the railway has filed their affidavit in opposition, two of the cases. And the contract agreement has already been annexed in the writ petition.
Contract about what?
Issue in the
No,
course of
contract for what?
that railway track, double line to double line.
Okay.
They executed some contract. In the course of the contract, apart from the land ballast, they have to carry that ordinary art. The issue involved in this matters regarding ordinary art. So, in the contract agreement, there is a contract agreement. There is no such provision contained that on the the contractors has procured that ordinary art from the individual pata holder, not from the forest. but in the, apart from that, in the contract agreement, there is no such clause specifying that the forest royalty is required to be paid against ordinary yard. I'm not on against the balas and other thing. Balas and other items, they are bound to. There is a clause that is
You are a
they are bound to
contractor.
pay.
You are a
They pay the.
You are a contractor.
I'm a contractor.
Contractor. What the railways have asked you to do?
They are insisting from the forest royalty clearance certificates form
Okay.
me
And
against the
art.
that
This-
procurement and
art.
the work of the ordinary yard.
Okay, and now you say that this I have not obtained from forest area, but from other private land.
Garnet single just deal with the that issue,
Ah.
saying that even though you are bound to pay if it is procured from the or it amounts to forest, but that my contention before like Garnet single just pointed out that railway in their affidavit they has not clarified these things I made in the
Let us see the
petition.
direction. You said you are agree with the direction of Lana single judge. Please tell us what page number of the Lana single
Last
judge.
2 pages.
Yes.
Direction.
Ordinary art is a
Send it
minor
back to the-
mineral
back
and
to the
royalty is
authority.
leviable.
Well, in this similar circumstances, the another base of this honorable court. Well, in the same issues, ordinary yard, it was not made in the contract agreement. There is no specific clause. This honorable court has directed not to insist for forest royalty. This
Rohit
judgment is
Newar
very
and the
lawsuit.
Somdatta builders. So there are two cases, Rohit Newar and Somdatta builders, wherein it has been held that ordinary earth is a minor mineral. That is what Lana single says.
I am in respect of paragraph 19, the direction part. It is sent it
yes.
back to the authority, but our case is before
Direction,
the-
the employer shall verify the contrary petition, and if he is found a royalty is recoverable in terms of Sancho, reasonable opportunity produced, provision will be granted, and if the contract has been paid, no recovery. What is the problem with you in this direction?
My case is that since it is before the land single judge, the pleading is there, railway has denied, but they did not specifically deny that I have made a categorical contention for the in the pleadings that there is no whisper about that there is no clause that for the purpose of utilizing the ordinary art, I have to pay the forest royalty. There is
No, correct. Even if
and division bench.
Mr. Counsel,
Malad,
if the contract is silent on certain issues,
Malad.
but if it is statutorily covered,
No, statute, sir,
that is what we are coming to. Therefore, if the ordinary art,
Malad,
even if there is no mention about payment of tax or tariff in the agreement,
Malad.
if under the normal law, you have to pay.
That is the contention made by the writ petitioner
Huh?
before the land single judge. There
Correct,
is no statutory law in this regard, as well as there is no clause incorporated in the contract agreement.
Forget the
And-
clause. If
Malad-
it is not there, then you don't have to pay.
Malad,
But if there is a statutory obligation
no,
to pay,
that is the statement made by the writ petition in the pleadings, and in the railway,
therefore-
they have not denied it.
no, whether railways deny or not, that is immaterial.
no,
Once
there
it
is
has
no
come
such-
to notice that therefore this Lane single judge says,
Malad.
we will examine that it is leviable on in Rohit Newar case and Somdatta builders. What do you say about this para 18(1)?
Rohit Datta and Sundatta builders,
Yes.
these are altogether different aspects. Malad, ordinary procurement in the Rohit Newar's case,
Yes,
if ordinary art is procured even from the purchaser, then one have to pay the royalty. But here is a case, my contention for lawsuit
yes.
is that there is no statutory clause in, as well as in, there is no clause incorporated in the contract agreement. I am not bound to pay. And following the judgment, there is a division by judgment that
Yes.
is relied by the learned single judge. That
Yes.
is Muslim Ali. And in another case, subsequently, that is judgment dated 4/8/2022, another bench, in view of this fact, that there is no incorporation of the clause in the contract agreement, as well as no statutory law, it is directed the railway not to insist for the
Okay.
forest royalty.
Now,
So
what is
my-
what is the problem right now?
My case is that since the pleadings are already before the learned single judge, I even submitted my written written argument for the learned single judge. Learned single judge all of a sudden, along with the Malad,
Anyway-
that's of the writ petition, direction is suit, but here the direction is required to
Goswami,
be issued that
what-
documents is for that.
Okay, what we are asking you right now is,
Malad,
right or wrong, according to you, the learned single judge did not correctly passed or fine. That we will examine it.
Malad.
As on today, just now, what do
Well-
you want from this court, this appellate court? What do you want? What order you want?
Well, similar to that of the order passed by another batch, Malad, in view of the same favors.
What was that? Have you given a Mr. Gogoi?
Malad, he was the counsel. Before the
But
learned
then
single
he's
judge.
a counsel, but he may have forgotten. He is so busy lawyer. You don't know. You might as well remind him. What is this judgment?
Right on in the.
My lord, the single edifice of his case is that, my lord, there is no, in contract agreement, there's no clause.
Yes.
My lord, he has taken the pleading, my lord, it goes to page number 24. It's one of the ground, my lord.
Page 70 specific clauses there also. Page 70.
24, my lord, he has taken a pleading.
Yes.
It does not
That-
provide any clause, he says, my lord.
Committed fairness and viable and disposition of some project and.
Ground number 3, my lord.
The lawyers have failed to appreciate the contrary as well. Indian legal standard does not provide any clause in respect of payment of forest royalty in respect of ordinary art to the state government. And you said it is there.
Now, my lord, go to page 70.
Page
70, my lord.
170.
70, clause number 13.2.
13.2.
My lord,
Whenever forest produces like sand, stone, timbers are used in the work,
etc., my lord.
etc., used in a contract, we have to file document prove the requisite regularity. Yes, like sand. When you take sand, sand always has some.
It is not sand, it is ordinary art, Malad.
Correct. Sand, stone, timbers, etc. are used in the work. Forest produce.
Forest
Question is, therefore,
No,
if suppose if you take water, water is not forest produce. You can say.
It's related
Now,
to
just a
taxes,
minute.
Malad.
Correct. The water, just because the river flows in the forest, can you say that the water in the river is a forest produce? You may say no. I don't know. I'm just saying. But then, if water is also a forest produce, even if it's not mentioned, then you have to pay. We don't know. So that what do you mean by forest produce?
May I draw your
Therefore,
attention?
this art,
Page 141, Malad. The
therefore,
contract agreement, there is a forest permit clauses incorporated here. Not the pointed out by land. Page
Yeah.
141, Malad.
page 141.
Forest permit. 4.1, Malad.
So it's 141,
Malad.
forest permit. Yes,
Malad, may I read, Malad?
yes, yes.
4.1. Here, the forest permit for quarrying and supply of the holder will have to obtain by the contractor on payment of usual royalties, sale tax, monopoly, fee, so and so levy in the forest department, the railway will, however, recommended to concerning
Malad, can you see the
forest
heading,
royalty,
Malad?
they issue
Heading
the
of the
forest
case.
permit
So,
on
Mr.
payment of
Goswami,
usual royalty sales on the products
Okay.
specify one so and so.
Okay,
Malad,
Mr.
here also
Goswami.
there is no whisper about
Okay.
the
Okay,
ordinary art,
but
Malad.
suppose, while in ordinarily, if you take sand, suppose, you think that sand also will be required,
Malad.
suppose, then you have to pay.
Malad, I am not.
Correct. We are not just asking some questions. to you.
Malad.
Suppose if you are required to sand, for
Malad.
example, sand then as per this forest, it becomes a forest produce. Then
Malad.
you have to pay.
Malad.
Stone also,
Malad.
you have to pay.
Malad.
Okay, very well.
Is there any-
Therefore, you have
I-
not
I'm
mentioned this
denying
earth.
it. I have to
Correct.
bound to pay.
Yes.
Since
Now,
it was
now,
incorporated here in the
yes,
contract agreement.
therefore, according to you, earth, ordinary earth is not described as a forest produce,
Malad.
isn't it? How do you say that ordinary earth is a forest produce?
My lord, there are two statutes covering, my lord. There's Assam Forest Regulations, also notification.
Please
of
tell
last
us.
I am saying is that ordinary art, if it is not mentioned in the contract agreement, it is, my case is that in the
Mr.
CA.
Goswami,
Malad.
there is something called ETC. What is ETC? What is this ETC?
Malad, where?
ETC covers everything. So generous, whatever, whatever something like, stone, timber, etc.,
It's
etc.,
relates to taxes, Malad.
etc.
It's relates to heading, Malad, 13. Page 70, 13.
Anyway,
It's
we'll come
relates
to that.
Taxes,
Yes,
not
yes,
forest permit, Malad.
shows.
Well, I'm handing over. Well, I'm. handing
Your
over.
shows that a forest produce, see, earth is it is treated as a forest produce. Shows.
My lord, it's Assam Forest Regulations, where also we have a notification dated, my lord.
Page number. So go, page number, yes.
My lord, I am.
This one.
Larned single judge has clarified it, my lord. Larned single judge, I am not objecting it, my lord. Larned single judge has clarified the issue. In the Rohit, relying on the judgment of the Rohit Nair. My simple case is that this is admitted fact. Railway even not able to produce anything in their affidavit. My case is that there is no statutory requirement as well as the clause incorporated in the contract agreement. In view of the fact, learned single judge, instead of send it back to the authority to verification, decide the matter. In some cases, same decision is given,
Yeah, what is the decision? Tell us. What is the decision you are relying on?
It is relying on
What decision you want to rely on? Tell us.
clause you are referring.
I'm referring to my lord, page 53.
Mr. Goswami, that judgment.
Notification.
You want that judgment? Okay,
Malo.
we'll see whether you are. Yes,
53,
please.
ma'am.
These are the judgment.
53, my lord,
Okay.
is fine. 53, my lord, page 63, my lord. The forest produce, my lord, there is a royalty also fixed, my lord.
Page 53.
53 is notification, my lord. And page 62, there's a schedule.
This one?
Yes,
This
my
book?
lord. Yes, this book.
Oh, you are a different book.
Oh, very sorry, my lord. Oh, I can hand over my book.
We say, give this. Give the one of this. No, give.
I'm handing over my book. It here 62.
What is this?
Larned single judge judgment in 4/8/2022.
Just
My lord will kindly come to page 3 of that, page 8, my lord, of that book, my page 8.
Page 8.
It is a definition clause, my lord, which forest produce has been defined.
Forest produce includes the following found in a brought-in form of timber, charcoal, and then peat, surface soil, and all products of mine. All products of mines or quarries.
Mine.
Surface soil,
Yes,
rock, minerals. So
Yes.
what is this surface soil?
yes, my lord. And my lord will now go to page 52, my lord.
Page 52.
52, my lord. My lord said there's a
52 or 62?
52, my lord. First 52, my lord. There's a notification. 53 or 52, my lord. Since I don't have a book now, there's a notification, my lord. Notification.
1st September
Yes, my
2009.
lord. In that context, my lord will go to page 62 now.
Yes.
There is a schedule, my lord, which
Yes.
my lord, fixes a royalty rate, my lord.
Clay and earth.
My lord. That apart, my lord, I'm also handing over this book, my lord. This,
What book you are handing over?
my lord, this is AMC rules, my lord, minor mineral concession rules.
All things are dealt with by the learned single judge. I am not against it, my lord. In view of the fact that the clause is not incorporated in the contract agreement, I am not bound to pay, my lord, royalty.
Okay,
Direction
we-
will be issued, my lord.
Okay.
Learned single judge in another case, my lord, same decision has been taken.
Clause is there, my lord, etc. is there. This is my lord, Assam minor mineral rules, my lord. My lord, it is my lord, made under the MMDR Act of 1957, my lord. So, my lord, there's a schedule of tax. Ordinary art is also covered, my lord.
Ordinary clay.
Yes, ma'am.
But perhaps, is it ordinary clay or different clay?
Ordinary.
Ordinary
Maybe
art, my lord.
Ordinary art,
not
not
clay,
any
my lord.
special clay. Okay, ordinary art. When used in cement manufacturing or in any industry other than cottage industry. When used in cement manufacturing or in any industry other than cottage industry. Ordinary clay.
And that apart, my lord, MMDR Act is there, my lord. MMDR Act, section 2E. I provided a book list, my lord. Section 2E, my lord. MMDR Act, my lord, section 2, subsection E, minor minerals, my lord.
Mister, there are two Gogois. You are,
He's K Gogoi, man. D
And?
Gogoi, I'm for the state forest. he's
you are
for
D
railways.
Gogoi and K Gogoi.
My lord.
No, no, D and K.
And
D means what?
my lord,
D means what?
Dikshit, my lord, Dikshit Gogoi.
Okay, you call yourself Dixit. Otherwise, see Gogoi, Gogoi, Mr. Gogoi.
And my lord, I'm also
You are
relying on a
Dikshit
judgment,
Gogoi.
my lord. Relying on a judgment, my lord.
You
2007.
are you have a recipient of Diksha, Dixit.
Yes.
You are a Dixit. Already received, you have already received Diksha. No, Dixit.
Well, I'm relying on judgment also, man.
What is that?
2017 3 GLT 478. Division bench, my lord.
But you said that mine minerals.
It's also covered because the rules, my lord, we make under it, my lord.
Okay.
And thereabout, my lord, only question now what has I have understood my limited knowledge, my lord. The question, etc., covers ordinary art or not. That word. That is
Okay.
the only question, my lord.
Okay. Let us see the judgment.
My lord. 17 3 GLT.
Kora 1730. Yes. So that Mr. Goswami can see also.
Para.
GLT. 173 GLT, which page number?
My lord, 478.
Para number
21, my lord.
24.
21, 23, and 24.
21. In view of so and so, so and so. Conclusion so and so. That particular to earth being a minor mineral is subject to payment of royalty on it being extracted even from private patta land and other lands located in non-forest areas. Para 21 says,
Man.
if he comes to my house, non-forest area, takes it, you have to pay. Whether it's a non-forest area also. So,
Settled by the
okay,
Royal
Mr.
Single
Go-
Land,
so,
but again,
one,
it's
can we
that-
can you answer a question from us?
No,
Let us assume that according to you, it is not in the rule, in the agreement
no,
that you have to pay.
no.
But the law requires you to pay. The law requires, do you agree with the submission advanced by Mr. Dixit Gogoi?
That is
That-
my repeated stand before the Lana Single that
Okay.
there is no state
Mr.
law as
Goswami.
well as the clause incorporated in
Mr. Goswami,
the agreement.
can you answer a question?
No.
This is not interrogation,
No,
just a clarification from our side.
no.
We can't ask the learned lawyers, counsel. You know better than us. Our phone clarification. Do you agree that this ordinary earth is a minor mineral?
No,
Number one. Number two, do you also agree that if that minor mineral is leviable?
no.
Number. Do you also agree that forest produce like sand, stone, timber, etc. The etc. can cover minor mineral, or we don't say no. See,
No,
para
no.
13.2 of your
My-
agreement.
On this issue, Malo, I just draw your lordship's attention. I give a judgment set of judgment.
Yes.
There's a division there because Lanet Singh was rely on this division based judgment that is Muslim Ali. Malo held there.
No, see, para 18. Kindly come to Muslim Ali, para 18. Muslim Ali, para 18. Come to para 18.
Malo.
What is it? We are in agreement with the views expressed by the learned single judge. No appropriation of money from the contractual dues is permissible unless backed by statutory provision or express provision contained a contract agreement binding the parties to the contract.
Malo. Malo.
See, obviously they cannot ask you to pay
Malo.
tax or something on which there is no provision for taxation.
Malo.
They can only ask you to pay tax only in respect of item which is taxable under law.
No,
That is
this
what
is-
para 18 says. Mere absence, therefore, merely because suppose you remove clause 13.2. Suppose you remove clause 13.2, there is no provision. Let us assume for the time being. Now you merely carry this timber
Malo.
for the executing a work, then the forest people say, who are you, Mr.? I am a contractor. Oh, very good. I don't know whether you are a contractor or not. Why you're carrying this timber? Sir, I am bound by, I am executing a contract. I have been given a contract by railways to do so. Oh, I don't know who is given you contract. You are carrying this timber. You pay. Do whatever you want. Can the authority say so? Can the authority say so? Forget the contract.
Malad.
Suppose this 13(2) is not there. There, railway also there. This is not our headache. Why should we bother? It is to be realized by these forest authorities. Railways, we have so many work to do. We have to carry so many passengers. We don't do this work. Okay, let that do whatever. Mineral department is there. Mineral forest department is there. Dixit Gogoi people are there running around the Sinyada forest. So we are not headache. But then you will be liable to pay, even if he is not in the contract. If that is so, what the railway is doing that, they are doing a favor to, maybe I don't know whether they get some commission for getting this, then they transfer. Isn't it the money which railways agree, they will be transferred to the forest department? That says, you are not going to use. No, it's okay. What the railway is doing is that they are doing it for the benefit of the forest department. They are lightening their burden so that the forest people can spend their time in protecting the rhinos and elephants. So these are work they are doing, and they will transfer this money which they have deducted, and it will be transferred to the forest department. That's how the works. Are you still not satisfied, Mr. Goswami?
Malad, my contention for.
No, we have read your, we have read your.
Specific clause in the contract agreement.
Okay, we have heard
There is
you.
no specific clause, Malad.
Okay, we have heard Mr. Lanek.
As held by this division bench of the honorable
And
court.
Mr. UK Goswami
Malad, I am
Lanek.
not bound to pay.
Correct. We have heard you. Yes, we have taken your. Heard you, Lanek counsel for the appellant. House to Mr. D. Gogoi for also and also Shankar.
Malad, just I have already placed a judgment, Malad.
Yes, yes.
Malad,
Ali, Ali.
single judgment is there, Malad. Same view, Malad.
Okay. So give it.
Already there, Malad.
Okay, already given. What is that?
That is 4/8/2022.
Raigans, right?
Raitani
Raitani engineering. What does it say? What does it say?
Same issue, Malad. The Lanet single judge is directed. In
Okay.
40%, Malad.
Okay, very well. Okay, very well. Yes, where is this Somdat and these two judgments?
Somdat is with me, man.
Somdat. Go back to Somdat.
No, 2010.
This one,
2010 1 SCC 311 page number.
para number?
22 to 26, madam. 22 to 26, madam.
You have to row all 22 to 26. You couldn't find a more. Out of this 20, which para you will prefer? 22 to 26, 5 paragraphs. Which one will prefer? 6 paragraphs?
28 and 29. madam.
28
and 29.
28 and 29.
29.
Oh.
And also, madam, 26.
Lawless demand of royalty can be raised only against lessee. Neither lessees nor mining permit is ballpark. How does it help you? Which one? Which one is helping you?
25, madam.
25.
Right.
In the context of section 3, what this is that it must be that ordinary earth is congruent with the meaning of the word any other mineral. We don't know.
26 also.
Now that is the definition of ordinary earth, whether
Yes.
it is covered in the forest act.
That
Now
I
he
was-
says, his case is that fine, it may be covered under the forest act.
Fine.
He says it is not part of the agreement between the railways and you.
Exactly. The word
You-
etc. has to be.
Therefore, you may go after him, but not the railways. That is what the learned single judge also says. Mr. Gogoi, you are the railways. I said, you give the bill, whether I pay income tax or I pay income, that is my headache. I'll take care. You do your duty, you want to, whatever is there in the agreement, you deduct, whatever is there, not mention, I'll go income tax. You don't mention income tax payable, no, they are not bothered about that, whether he's paying income tax or not. Huh? So, but you can't say that now whether you produce how much your income tax turnover, we'll also deduct for an income tax department. That what Goswami's argument is, since it is not mentioned.
The specific clauses there.
But Mr. Goswami, it is not your argument. Is it argument that is payable, but it is since it is not mentioned in the contract, therefore I am not bound to pay. That if the forest department recovers from me, that is okay. Is it your case?
My case is that in view of well, Muslim Ali judgment, and subsequent judgments also for versus I went to talk. There specifically says that if there is no statutory.
Mr. Goswami, just 1 minute. In other categories, it is asked of the that is purchase the statement and binding maintenance to the first one. It's from some. Hard copy আছে আৰু লিয়াব নালাগে এইটো ইয়াৰ পৰা
Is it Krishna Das? Is it Krishna Das?
Even in another case also, Durga Krishna is also unable to decide this.
Well, I'm handing over.
Where is Durga Krishna?
Durga Krishna. We are also abide by the notification issued by the government of Assam Law Forest Department law.
Durga Krishna, yes.
Paragraph 8 law.
Paragraph 8.
It starts from middle portion law on the other hand law.
Paragraph 8.
Paragraph 8 from above 6th line law.
Consider the submission of the Land Council. Mr. Bhatti wants to project that the purchase. He purchased from open market direct NS, the duty cost verified as source from the inmate says the petition is not bound to trust whether vendor on.
Lordships, on the other hand, if the notification dated so and so the government of Assam is considered, we can conclude that Stone Ballet is a forest produce and the notification dated so and so binds the respondent railway and for the reasons clause 2.13 are stipulated in the consider agreement which petitioner appellant is very much aware. Here also Lordship, even 13.2 even same clause Lordship, the respondent railway is bound and to abide by the notification dated 17/6/2000 and keeping the view of the said notification. Here also Lordship, similar issue, same thing Lordship. In order to get it released, the duty is cast upon to the petitioner appellant at least to inform the source from whom to purchase the said materials in order to railway can verify if the materials so purchased by the petitioner appellant was purchased from a source is paid requisite forest royalty as per notification dated Lordship.
Here also there is a specific clause in page 70, Lordship.
Where is the notification?
But
Is it a part of the pleading?
No, my lord, I had given that notification, that book, my lord, forest man.
Lordship. Even Lordship, division bench also Lordship categorically held the Lordship that it's a taxable Lordship. It is not a case of the PT appellant that Lordship, there is no clause Lordship. It is a specific clause Lordship. He is not verifying it Lordship properly. In the contract agreement itself Lordship.
Source of the DC.
Source of the deed is listed. It is paid in the source.
First,
Temporary
royalty
purchase.
pitch, royalty pitch for settlement.
In the impugn judgment, landed single judges, it is supported my case, Page 351, clause 20B9 of the that notification is got to be a part of the contract.
Condition.
Paragraph Roman 16.
Condition আছে। Shall be
Yes, anything else you want?
In fact, just now pointed out by them that Dugak is the division by judgment. Now, I am not against the impugn judgment, I'm only against that I am agree against the direction contained in it. Finding in the landed signatures categorically says that Dugak is not the judgment. Paragraph page 354, para Roman 8. It is not applicable in the present case in view of the fact that OM dated 17/6/2002, the clause is required to be incorporated. Accordingly, the Muslim Dali case Malad, settle the, Malad, suppose the case of the Muslim only, division bench judgment. Malad. Paragraph Roman 8, case 354. Malad.
Effect of incorporation.
Conditions are in the book. Principal with them,
That clause was not a under discussion in the Durga Krishna's case.
See, Mr. Gogoi, you are relying on Durga Krishna.
Lordship kindly peruse.
No,
page
no,
361,
Mr. Gogoi, you are relying on Durga Krishna.
Lordship, Lordship.
But then learned single just say something else about Durga Krishna.
Durga Krishna clarified Lordship kindly peruse 361 Lordship.
No.
Page
Of the judgment, learned single judge judgment.
Learned single the judgment page 361 kindly peruse Lordship. Page 361 Lordship. 361 Lordship, Roman 5 Lordship.
Huh?
361 Roman 5 Lordship.
Yes.
The direction part Lordship, conclusion part Lordship. In those contexts where such conditions are incorporated, the employer shall be within its competence and jurisdiction to recover the forest royalty from the bills of the contractors, from the security deposit, earnest money, etc. as per OM dated so and so, and the principles law laid down in the Durga Krishna stores shall be applicable. Lordship. And Lordship kindly peruse page 70 Lordship. The very specific condition is there Lordship, page 70 Lordship.
Page?
Page 70 Lordship. 13.2 Lordship.
But Durga Krishna doesn't restrict it to conditions.
Lordship.
Durga Krishna says it is backed by a statute.
Lordship. Yeah, statute also Lordship very clearly.
But you are not in appeal against this finding.
Lordship, it is not against us Lordship because there is specific condition is there Lordship. 13.2 Lordship. 13.2. Even statutes also so says that Lordship. And we are
13.2 is not
we are
specified.
bound by the Lordship
ordinary act.
notification issued by the Government of Assam Lordship, Forest Department Lordship.
Okay.
As
Yes.
regards Durga Krishna Malad, the principle laid down in Durga Krishna is very clear, Malad. Even if he doesn't have to pay, he has to at least show the source. He has to show the source. Let us read Malad Durga Krishna's story again, Malad.
Okay.
Concluding part, Malad.
Yes.
The respondent railway, my lord, is bound to abide by the notification dated so and so, and keeping in view the notification, the security of the petitioner appellant has not been released. In order to get it released, my lord, a duty is cast upon the petitioner appellant to at least inform the source from whom it purchased the said materials, in order the railway can verify the materials so purchased by the petitioner / appellant was purchased from a source which paid requisite forest royalty as per the notification dated so and so. Considering the same way, the opinion of the finding and single judge is proper, and unless the petitioner informs the source from which it purchased the statement, the respondent railway is unable to verify from the concerned DFO whether the materials within such construction were duly subject to necessary forest royalty as per said notification dated 6/17/2020. That is the principle enunciated, my lord. He has to show the source. If he says, if he succeeds in showing that he has paid royalty on the source, nothing survives, my lord.
Okay. Anything else, Mr. Goswami? That's all? Okay.
Malad,
We'll hardened part will pass the order on Wednesday, day after tomorrow.
Malad, I am not against this learned single judge. I am only operative person. Malad.
Your
And
case
in
is
the-
that
in
your
the-
plea
in
is
the
that
judgment, the
correct?
learned single judge support my case. Malad.
Your plea is that there is no clause
No.
in the agreement,
No.
contract agreement between you and the railways
Railways, Malad.
for payment of this.
As well as
due-
there is no statutory
there is
provision.
no
in the-
statute.
Earlier, Malad.
Mr. Lane counsel for the appellant.
Yeah, okay.
And Mr. And Mr. UK Goswami Lane counsel for the appellant, also Mr. D. Gogoi. for forest,
Forest.
standing on, and Mr. K. Goy, Central Government Council
In
of India. This appeal has been preferred against the judgment and order dated. Judgment and order dated
36, 2022.
36, 2022,
22.
passed in the number of petitions. Huh?
Common judgment and order.
But you are against, you are in the petitioner in which case?
Three cases, WPC
There are how many cases? WPC 1, then link.
WPC 2860 2021.
How many
WPC
petitions are linked here? There are so many petitions.
so many we have. I am agreeing for 3 petition.
Others have not filed any appeal.
No,
They are
I
not
am
there.
against direction
Only
of
the common judgment and order dated. Common judgment and order dated 36/2022, passed in a batch of writ petitions. Batch of writ petition 1, 2, 3, 4 sub likhi hua. Full stop. The appellant, however, is concerned only with the writ petitions 1, 2, 3. How many writ petitions?
3 cases.
Which writ petition? Number?
WPC 286021.
And number 2?
Number 2, Malot. WPC 301 on 2021.
And number 3?
WPC Malot 2845 to 21.
Full stop. Next para. The other writ petitioners have not made any appeal as on date. Correct? Full stop. However, and only the aforesaid 3 writ petitioners are before us as writ appellants. Since no other writ, since it has been informed us, it has been informed before this court that no other writ appeals are pending, we propose to dispose of this appeal. Though preferred by only 3 writ petitioners. The only issue raised before us is whether the petitioners who are contractors engaged by the railway authorities for executing certain works of double lining, of tracks, in certain sectors in the state, Full stop. Their grievance is that though there is no specific provision under agreement or contract between the petitioners and the railway authorities for deduction or payment or deduction of, what is that? Deduction of
no statutory provision.
deduction of cess or tax in respect of ordinary earth, or what is it called?
Ordinary art.
Ordinary earth, which is required for executing the work. Railway authorities are insisting upon production of payment of cess of ordinary earth on the ground that it is covered by that it is a forest produce.
Well, forest royalty, not says they specifically says
That is a forest produce, and as such, the contractors are liable to pay forest cess, forest royalty.
My lord.
On the other hand, it is the specific plea of the writ petitioners as well as with the appellant before us that neither the contract between the contractors and the railway authorities require deduction or payment of forest royalty for the aforesaid item within quote ordinary earth.
No.
Neither the payment of any cess is required under any statute.
No.
Under the circumstances, the direction issued by the learned single judge to the effect to authorities to verify the contract the petitioners herein is court, page 19(1)(a). And if it is found that first will recover so cannot be is not in accordance with law. Thus, the issue before us is whether the aforesaid item within court ordinary earth is an item which is covered under clause 13(3), 13(2) of the contra agreement as insisted by the railway authorities, and as to whether and or not. If it is not covered, question of payment of question of payment of cess, question of showing the authorities, question of recovering the cess paid, if any, on that item may not arise, and as such, the question of deduction from the pending bills, security deposits, earnest money, etc. does not arise. Even if there may be a statutory requirement for payment of cess on that item as insisted by the railway authorities. This is the case. This is the case. According to Mr. Goswami, neither there is any statutory requirement for payment of forest royalty in respect of earth, ordinary earth. Neither it is mentioned, neither it is mentioned in the contract between the contractors and the authorities regarding deduction of such amount, on account of for such amount which is for payment, showing payment towards the aforesaid item, earth. That is your case. That is your case.
No.
We will pass the order on day after tomorrow. Okay. Hard in part. Hard in part. We'll dispose it of day after tomorrow.
Item number 8.
My lord, in this matter, I appear for the applicants, your lordship. Am I audible, my lord? My lord, am I audible?
Item number? 8. Item number 8. Center for Environment Protection. What is this for?
My lord, in this matter, I appear for the applicant, my lord. This is an appeal.
NSB, appellant, Nair, recorded steps were taken, and status quo as regards forest. List the matter on 6 February. All the respondents are represented?
I'm appearing for the state in this case.
Just a minute. Who are the respondents here? Let us see that. State of Mizoram, you are appearing.
Yes. Today I'm
Chief Secretary also, obviously.
yes.
Secretary Mizoram, Deputy Commissioner. So you will be all. And NEC, NIPCO? Anyone for NIPCO? You are for NIPCO. And Mizoram, yes. So all are represented. Yeah, you are for whom?
I'm for I'm a stranger now. I don't get.
You are a stranger.
Yeah,
Who are you?
Yes, that's right. I have filed today only one application.
Correct. But who are you? First tell us. Who are you?
Leave application. I leave praying for leave to get impleted NSI DCL.
Correct. You
And
may who are you? Are you?
Yes,
See.
NSI DCL is a affected party here.
Okay.
After
NSCI, what is this?
National Highways Infrastructure Development Corporation Limited.
Okay.
Here the question, where land in question, that may be that we are constructing the road.
Okay.
Accordingly, once that after passing the order of the judgment and order by honorable single judge, setting aside that notification, then the competent authority for land acquisition has allotted the land to us. Thereby, we have paid them 280 crores have already been paid. Now, due to this writ appeal pass order, that is the status quo order, this entire work has been stalled. That is why I am praying for leave of the honorable lordships
Mr. Gentleman, in the writ petition, what were you doing?
That time I was not affected. There we are not at all affected. We are not party there. Writ appeal also, because earlier the writ appeal was filed by Mizoram government. That was withdrawn. Now, due to this status quo past the writ appeal, we are affected. That is why we want to be get implemented. That is why we are filing today interlocutory application for allowing to get implemented, but by filing another implementation petition. That is our prayer. But Lordship, today we have filed application. That application not before Lordship. Now my with the learned friends are agreed, senior counsel also, and already been filed list, filing number is there. But today only I could file because of
Why is your work?
that is because it's due to status quo order, last order.
You made a statement that you had deposited 200 something crores.
Crores.
For what purpose?
That land in question
Is in your possession.
No, that is not in possession. That's the problem because we have paid them. But during they wanted to give the possession to us. In the meantime, this status quo order has come. That is why land was not handed over to us. Work have been still 280 crores.
You have paid the money, but you have not got the mithai.
That is the problem.
There is a problem. You have paid in advance, but you have not been delivered in a minute because of status quo order passed by this court.
Leave application, my lord. Maybe taken at 2 o'clock. Because that today already I have filed. Because I could not serve the copy.
Yes, have you got a copy of this application? Yes, you have. Yes, so
Leave application only, my lord.
yes.
Now I have received a copy of the application. My lord, may I apprise your lordship of the matter, your lordship? Kindly bear with me for 1 minute, my lord. Kindly see, my lord. Kindly come to page.
So you don't want him to come before this court?
My lord, he has nothing to do in this court because deforestation of the entire area will cause irreparable damage to the environment.
Correct. But whatever it is, we will examine that.
Yes,
See, whenever you log on nowadays in computer, first of all, computer prompts, are you a robot or human being? If you're a human being, then you will allow, they will allow. So do you consider him to be a robot who has a busybody, whom we should not allow?
My lord, the thing is regarding my lord.
Oh, madam, we'll hear you. All the merit of your case, we'll hear you. But question now in the middle, when we are proceeding, somebody comes up in the saying that I also want to be, he wants to board the train. He said, I also want to go in this train.
Yes.
Will you allow to board the train or not? There is what? If you say no, he is nobody, forget, we'll proceed. Our train will proceed.
He is nobody, your lordship.
He is nobody. Anyway, you said that he has filed an application. Your oral submission may not be sufficient. You file an application, we'll hear it and we'll.
Yes, that is why my today's prayer is.
So we'll come up, matter will come up day after tomorrow or whatever it is.
Maybe a day after tomorrow.
Day after tomorrow. You see that you file an affidavit saying that he is nobody. He's a robot. He's not a he's a busybody. He's just trolling our journey. Yes.
A week's time to file a reply. Your
How long will it take? Tell us. How long will it take?
1 week, my lord. 1 week will file.
Okay.
Come
Okay.
from your lordship.
Yes. When the matter was taken up. Yes.
Kindly extend the status quo order. My lord has passed last date.
Okay. We'll do that. We'll put that train on hold.
My lord.
We'll put the train on hold. We have status quo will continue.
My lord, only one prayer.
Yes. What one?
My lord, the projects of national highway is going on.
We know that it is a difficulty in democracy. There is a problem. Now we have to hear the voices also. Sometimes the development gets delayed.
No, my lord,
But that's the price we pay in a democracy. It doesn't happen in some countries. There is no provision of land acquisition. Nobody is paid any compensation. In some countries, I don't want to mention. It goes on. Work goes on. But then. This is the country we'll see. This gentleman comes up in the middle saying that let me be heard.
My lord, deforestation already had. Money has been paid.
Whatever, we'll see that.
The construction, only what it was not apprised when the matter was taken up by this court.
Learned AG, even if deforestation has come, we can ask for forestation also. Afforestation. So don't worry about that. We'll see that.
Compensation paid for
whatever, we'll see that. Somebody has come up. We'll see that. We'll see that. That will, therefore, this gentleman who is here, busybody, he may be your ally also. We don't know. He may help you. So we'll see that. We don't know.
Construction part, my lord, has been stalled. It is going on ongoing construction.
So, but yes.
That's only, my lord. Your lordship can.
Banerjee, why do you want 1 week time to file this objection?
National Highway says they have not been handed over the land.
No,
Yes.
we are going, the construction work is going on. Work is going on.
That is why. and
Who is
that
constructing it?
Because here the petition is coming, my lord, that is why now.
You're for the state.
I am
Yes.
for
State is executing.
Read appeal was filed by the state. Under what circumstances read appeal was
No,
withdrawn?
no,
It is
who's
not-
constructing the highways?
National highways, we are constructing.
But
I am
state-
saying that work is stalled.
No, but then Mr. See, Das is saying that he's constructing. Who is constructing?
I am. NSI,
Here,
DCI.
NHI.
And then
No, NHI is, my lord, working. NHI is working, my lord, but we will be, let them continue, state will be
see,
affected.
there is a status quo order is there.
Yes.
Yes, that is.
No, if necessary, we'll vacate it. But then before doing that, we have to hear it.
Yes.
So we have to hear, Mr. Also. Let us see. So you'll take 1 week or it is up to you. If you want to take 1 week, you are delaying the process.
My lord, kindly give me, because just now I have received the application. I need to file the reply, your lordship. Kindly give me 2 weeks time. That will be sufficient.
Why 2 weeks time?
My lord, it is-
Why you want to get 2 weeks time?
Only
Nobody will
implement.
give you 2 weeks
I'm
time
not-
for
I have
implement.
not filed for vacating or anything. I want to get implemented only.
My lord, kindly keep the matter on 17th of February, my lord. I shall file a reply.
You have to tomorrow, my lord.
No, it's.
Today is what day?
During implementation petition. they
Today
can
is 6.
oppose. National interest is involved.
Banerjee, what are you going to say? You are going to send some person to verify his credential or what? You say on see the merit. He's saying that he's the one who NSDCI, they're the one who are going to execute.
My lord, question before my lord.
Whether in that context, whether he is a person of relevance or not, whether yes, if he is relevant, then we make, if you say it is irrelevant, we will not hear anybody who is not relevant to the issue.
For that case, my lord, I have to file a written.
What
reply.
file? Because he's the one, NLCCI is the one who executes works.
I'll come up.
National
day after
highway.
tomorrow, my lord. I'll
Only
take
that
it.
you can ascertain.
Yes, yes.
So let it come on Friday.
On Friday, I'll be out of business, 14th, my lord. 14th. Because my preoccupied cases in Arunachal for regarding NSA cases only, maybe on 14th.
Thursday.
No, here, from Wednesday, Thursday onwards, I'll be not available, my lord. Let's say on Monday, maybe fixed on either Wednesday or maybe on Tuesday. On 14th, my lord. Example, because I'll be out of business
14th.
because.
Yes, 14, you have a lot of time given by your proposed opponent. 14.
14th, my lord.
Okay.
Oblige.
In the midst of Mr. Submits that he would,
Tiburua.
Mr. C. Borua, representing National Highway,
Highways and infrastructure development.
NHIDCL,
DCL.
submits that
Yes,
that it is the executing authority of the project
Ah.
and would like to implement himself as a respondent in the present case. In as much as
Already.
the work, in as much as the work which was supposed to be initiated has been stalled because the status quo order passed by this court.
And
Let the matter be, yes,
filing number also can be noted down.
no. Let the matter come up on next week. Which one?
14th February.
14.
14.
14. Okay, 14. और also सब लिखो, सबका नाम लिखो. Yes. That was there, yes, madam.
My lord, kindly extend the status quo order till 14th.
Yes, is there already extended. Yes.
Item
Till
9.
then, status order will continue till next. Yes, 14. Yes. Item 9, Arzu Ali.
Wait, please, your lordship. Here in this case, my lord, actually my service was regularized. But certain area salary is not.
Today for what purpose?
For
And
admission. my
Mr.
lord.
say, so we admit,
Yes, my lord.
we'll admit.
Yes, my lord. Oblige, your
Here we are appealing for all the respondents, Mr. Khataniar. Mr. The appeal is admitted. Matter is ready for hearing. List the matter for hearing. Tariq di devo. Yes, next.
A short time may be given, my lord.
What is a short time? 6 months? In India, what is a short time? Tell us.
There is no.
There is nothing called short time or long time. Your short time may be a long time for somebody else. All relative. List. Yes. Next item.
After 1 month, my lord.
We'll see, Mr. Arzu Ali.
Item 10 to 21.
Are you out of job?
No, my lord.
You are still in job. What?
I am in job.
You are in job. You want what?
I want area salary.
Area salary. Very good. You'll get it in due course. Next. Item number 10, Rathi Traders.
10 to 21.
What is this Rathi Traders?
In this section 16(2) of the GST, it has been put under $7. We have already filed our affidavit.
Lordship,
No,
we
put
are
it-
being led by Dr. Saraf in this case.
So we'll
Lordship.
keep it for, see, you have challenged the statutory provision,
Yes, sir.
therefore it will come up in hearing.
Lordship, for today, we would like to seek for an adjournment. Lordship.
No, we are adjourning.
Let it
We
be
are
an admission
adjourning.
stage, Lordship.
We are adjourning, we are fixing for hearing.
Let
Ah,
let it
Mr.
be an admission stage, Lordship. My senior would like to argue.
How
on
can it be in admission? You're challenging the virus of section GST, like it has to be heard.
It has to be heard. And Mr.
SJ Soikia, Lordship.
And a council assistant, so and so, so and
So
so.
Lordship may kindly keep it for Friday, Lordship, subject to your Lordship.
And also our Mr. KL for the matter, in this appeal, in this batch of petitions, the virus of what has been challenged?
16(2) C and D of
Okay.
GST,
CGS.
Central GST.
Has been challenged. Mr. KL Samizar, he has filed
I will already file affidavit.
he have filed an affidavit. Accompanying matter requests will maybe listed for hearing.
What's it probably admit?
Friday, your Lordship.
It sends to be admitted.
The admitting for hearing, if you don't admit, how can we hear also?
What's if another matter left out, that may be taken along with this one.
List along with so and so on the mention of Mr. SCKR. Yes,
Item 22.
Vinod Sonwal, what is
The
the
matter is covered, my lord.
covered?
The two judgments passed by. this
Union of
honorable-
India,
Honorable
yes,
High Court.
madam, covered.
On the last occasion, my lord, if you.
Yo, madam, I want an answer from you. Is it covered?
On the last occasion.
Who?
I don't, my senior Mrs. Egan is out of station, Lord.
Gayani out
My
of
lord,
state.
on the last occasion, if your lordships recall, my lord, Ms. Gayan was given an opportunity to verify whether the judgments cover the matter, my lord. Today, she gave me a call in the morning, my lord. She said, although the matter is covered, but she wants the order to be passed in her
In
presence.
her place, very
So-
well.
so
When she
lordship-
will be present?
Day after tomorrow, my lord.
Day after tomorrow?
Wednesday.
Okay.
Evening.
Day after tomorrow, then yes.
Item 23.
Because, Picha, what is this? Because. Yes, because.
My petitioner has challenged the order dated 18/3/2022 passed.
What is the problem? Why?
Problem, my lord, the petitioner appellant was dismissed from service, my lord, without
Why?
any departmental proceeding, my lord.
What kind of misconduct you committed?
Misconduct, my lord, the allegation is there, my lord. The petitioner was a, my lord, selected candidate by the APSC and his name was recommended for tax superintendent, my lord. Accordingly, my lord, he was appointed. And during his period of appointment, my lord, one FIR was lodged at Dibrugarh, my lord. And in connection with the APSC chairman and all that person, my lord.
I think some.
My lord, appeal is pending, my lord.
Pending, no?
Yes,
Oh,
my
okay, then if that is so, will be heard, huh?
My lord,
And Mr.
BJ Singh.
And a counsel for the appellant. Appeal list, it has been submitted, similar appeals are pending before this court, being WA number, so and so, so and so.
My lord, 185 of 2021, my lord.
Let this appeal be also heard along with the said. What is the stage? Oh, hearing. the other
Hearing, my
appeal.
lord. It was
Okay,
last listed on 19/1, my
okay,
lord.
okay. And here, who are the respondents? You can take state, only the state,
Finance department, my lord.
finance, who will be appearing for finance? Huh?
Standing counsel.
Yes, who is that? Mr. Any for finance?
D. Gogoi, my lord.
D. Gogoi,
He usually appears, my lord.
Dixit Gogoi,
I'm sorry, B. Gogoi, my lord.
B. Gogoi, B means what?
Buddha, my lord.
Buddha. Where is Mr. Buddha? Buddha Gogoi. Where is he? Council, state
Will-
council.
will
Is he present in the court?
My lord.
B. Gogoi. Yes, Mr. B. Gogoi, Buddha Gogoi. There are so many Gogoi, that's why we are confused. B. Gogoi, D. Gogoi, K. Gogoi, P. Gogoi, Buddha Gogoi. See, will for hearing,
My lord, APSC matters.
APSC matters, you are there, you are handling.
Yes, no, APSC I am not telling you.
But the finance department is there, because he
Well-
was working in finance.
Lordship,
So we'll appear for all, because you're listed.
Lordship,
Ah,
it will-
Mr.
it will be cloud.
Mr. Accept notice on by all the respondents, huh? B.
All right.
Gogoi. Yes.
My lord, SC finance may be reflected in the court.
Okay, so in the, Mr. B. Gogoi, Learned Standing Council, Finance Department appears on, accept notice on by all the respondents. Yes, yes.
Item 24.
Pankaj Bora, Marua, what is this? Why it is listed today?
In 2011, my lord, 19 to 2011, there was an advertisement in the newspaper, my lord, that for appointment of 48 posts of laboratory technicians. The condition there was, my lord, one must pass from the recognized institutes of the government. The private respondents here, who are the representation there in the representation.
Is it required to be mentioned in the advertisement that you must pass from a recognized institute? So is there any issue where some people have been appointed under unrecognized institute also?
Yes,
Huh?
yes.
Okay, anyway, we'll hear Mr. Swami.
We passed out from, my lord, registered institutes.
Huh?
Registered, government registered institutes.
Recognized?
No, they say, my lord, government did not object. We are called for interview, we were appointed, is now.
So government, who is government? Government is all the people who are sitting. Government, there is
No.
nothing called government.
My lord,
So
let
these
me-
official may
let
have
me-
said, okay, they are recognized, they are registered for recognized. Is it a question? You are
Yes,
registered?
Registered.
Then they said later on this is not recognized. Like
No,
that.
they say not recognized by the private respondent. Government didn't say anything. Government appointed us,
Oh.
selected us. And the
Then the private said that you are not recognized.
Yes.
Then what did the court say? Lanet Singhal
Court
said
said.
you are
we
not recognized. Huh?
Yes, we are out.
You are out.
No. Lanet Single just says we inquire. then
Inquire.
pass it. Yes.
Hmm.
Against that order, yes.
Why? What is the problem?
My lord, no.
Okay, you say that
there
there is no need for inquiry because you are already recognized. If you are already recognized, there is no
No.
inquiry needed.
We are not, our institutes are not recognized but registered. There is
Oh,
difference
registration.
between the regist- Now,
Whether that is, that is for the register of society, we are not concerned with that. We are only concerned whether that your association society requires a register or not, that is not the issue here. Whether you are recognized by the government. Recognized means the government recognizes is a human being, a person, not an alien.
my lord, what the law
Recognized as a person,
my lord, what the law
citizen.
My lord, my lord, core issue before the law single judge was there, whether we are from recognized or not. We are not from recognized, we are from registered institute. That has been dealt with. But on that count, since we are not from recognized institutes, so we don't have any care.
Yes. So if you are not from recognized, then you are out.
So my case, my lord, there are 3-4 grounds.
Yes.
One is my lord, delay in lectures.
Yes.
They came after 5 years of our appointment,
Yes.
selection appointment.
No.
Number one. Number two, they failed. They admit in paragraph 7 of the petition, their petition, they failed in the selection.
Okay, they are failed.
Yes, so whether the failed candidate has any right to come to challenge anything.
Then
Number two. Number three, my lord, the difference between recognized and recognition. What would be the impact? Whether we are illegally appointed, no, or whether we are irregularly appointed.
okay,
That
okay,
is
very
the
well.
way. So on that
Okay,
three,
we have understood your 3 grounds. Yes, government. Mr. K. Chaudhary, you
Well,
have no,
I'm appearing-
we will not hear you even. We will first hear the government first. Yes, Mr. Gogoi. What is your
the
stand?
government supported our case.
We'll see that.
Government opposed
After
their
that, we'll
petition.
hear Mr. Chaudhary. Yes, before that, Mr. Gogoi has tell us. What is your stand?
But pursuant to the direction passed by this honorable court, we have, my lord, verified their documents and found that, my lord, they are not from registered institution.
Oh.
Accordingly, they have been terminated.
Oh, they have been only terminated.
Terminated.
Oh, when
That
did you
issue is pending
terminate?
before-
When did you terminate?
Termination is about 3
Termination
months.
is again subject matter of challenge where
Yes.
there is no stay.
In October 2022.
You have been
And
seen
WPC 7106 of 22.
before Durga Puja or after Durga Puja?
After Durga.
After Durga Puja. At least you could celebrate Durga Puja, your service have been terminated. Now what to do, Mr. Sharma?
I admit it and hear it was. That's all. Now we are not seeking for any stay now.
I think, my lord, everything has merged with the order of termination that they have challenged. That way, this appeal has become infructuous.
No,
Because the direction of the learned single judge is at page 163. Please have a look, one paragraph, my lord.
Mr. Sharma, perhaps we can do that. We can still urge is agitate upon because since the matter is before us.
Learned
appeal.
single judge.
Now that can be also urged, that also we can
Uh-huh.
perhaps, we can still urge that issue again, maybe.
One paragraph, my lord, page 163 of the learned single judge. Against that.
Because then
yes.
because then you can argue in leisurely before the learned single judge that no, recognition, registration also can mean
No,
recognition.
once we came before this court, even means we were allowed to go for review, we filed it, but that was not dealt with thoroughly.
Yes,
Please come to page 163, my lord. Third sentence,
Page
after that
163.
comma, this court, page 163,
Yes,
third sentence, this court is of the considered opinion that a chance should be given to the state respondents to verify the certificate and institution from where respondent number 7 had obtained certificate, and if after verification, it is found that on the last date of submission of application by the said respondent pursuant to the advertisement that is so and so, the said institution was not recognized as per advertisement, the appointment of respondent number 7 to the post in question shall be treated as illegal, and respondent number 7 be terminated from service, inasmuch as it was bounden duty of the employer to verify such fact before appointing the respondent number 7. Such exercise shall be carried out by the Director of Medical Education within a period of 4 weeks from the date of judgment, as suggested by the inquiry committee. Pursuant to, prior to this, my lord, there was an inquiry. Inquiry committee also found the same thing. Now, pursuant to this direction, state authority had carried out an exercise. Pursuant to the exercise, when they found that their degrees are not in accordance with the rules and the advertisement, my lord, therefore their rules are also there. That their services have been terminated, and my lord, now against the termination, another writ petition has been filed, where no stay order has been granted, only notice has been issued, my lord. WPC number 7106 of 22 on 7/11/22, my lord, notice has been issued. Of course, an observation has been made.
Learned Senior Council.
Yes,
When this learned single judge passed the order?
yes.
When?
Learned single judge passed the order, my lord. Review, my lord, page 165.
Review judgment.
Huh?
Review judgment is of 26/10/22.
Yes,
Page
page 165.
27/9/22.
165.
Yes, that is review judgment, because this court wanted us to go to review, we want a review.
Then what, when the review order was
My
passed?
lord, initially they
25/11
filed a writ
to-
appeal.
25/11 to 2022.
25/11,
2022.
then what did you do?
Then we are here. We have not gone to a single bench. Ours is, we filed the appeal. That if
You have done December holiday. 25/11, December. They will come or appeal here.
we appeal within time, we can.
But see, for any public employment, unless the only issue to be decided whether registration can amount to recognition,
Yes,
that is the only issue. But then registration by the society.
yes.
See, you go to a registration society, you want to register ourselves. You can even register yourself as a club also can register.
Yes, yes,
But recognition is to be given by the competent authority.
yes.
It cannot be recognized by forest department.
No.
It has to be recognized by the education department. Therefore, if it is not recognized by education department, registration with the registrar of society is of no value. Mrs.
There is two, my lord.
Then, if it is true, then why should we hear this appeal?
No, I'm not that on that. That's so, my lord, because there are a number of institutions running in throughout India, my lord, registered societies are running institutions. And the lawyers and other in their.
Then we'll see I don't know, thousands of things happening in this country. We don't know. We can't make it
One
observation.
more thing, my lord.
We are concerned with you.
Since government has accepted our plea, government is called for.
There is nothing called government, Mr. Again Sharma. There is nothing called government.
Yes.
Your government means that individual who are sitting there. They may not be knowing.
But my
They
lord,
think that register होगा ना कि अपना register होगा. हाँ. See, then this is that government. There is also there another person also.
my lord, kindly bear with me. After all, they failed in the selection.
Correct?
Yes. And we applied. We are called for interview to face the test. We were selected. They failed.
How long you have been working?
10 years.
10
years.
10 years you have been working?
Yes.
When you are appointed?
2013.
2013?
Yes.
And when did they challenge your appointment?
2018. After 5 years.
After 5 years?
There is one ground I've taken. Government also took that ground in the retribution.
Only the fail. Obviously, they will fail. You are successful because everybody cannot be successful. If they are successful, they would have been appointed. Obviously, they are not successful.
Yes.
So you can't take the plea that they are not successful.
Not similar to differentiate between recognition and registered institutions. One.
But
number two, delay and latches is again. Number three is whether the failed candidates.
Even if there is a delay, latches, Mr. Sharma,
don't have any right
if you are
to-
holding a public post,
Yes.
you must always fulfill the basic requirement, essential requirement.
Yes.
If you don't fulfill this one, even if you hold for 10 years, 20 years, somebody will say, oh, That is called quo warranto. Writ of quo warranto can also be invoked by any stranger who is just walking on the street. I say, I don't want to be, governed by this fellow who doesn't possess the, essential qualification. Therefore, yes, if the irregularity in your selection process, one can understand.
Yes.
But it is not it goes to the root of the matter, because you are not qualified, because you are not recognized. If you are not recognized, the matter ends there.
Yes.
Then once it is put to challenge,
Yes,
and one the single judge also has passed an order.
yes.
Single judge could have said, yes, since they have worked for 10 years, that passes over, then you have been terminated from service. The much water has flown down the river Brahmaputra.
Yes. Since my lord.
If you had come immediately after that and approach his court, if you had state order, okay, another 10 years you enjoy the stay, 20, 30 years, then court may say, okay, after 30 years.
Thing for my lord is stay.
Then
Only
kya
for
kare?
admission and final hearing.
What hearing? What is to be
This one.
heard? There is
My
nothing
lord,
to be heard.
Three grounds I have given.
What is the first?
First ground, my lord, they are failed candidate, they do not have a right. Even if
Okay.
I terminated, do they have to get
They
appointment?
don't have a right, then failed
Secondly,
candidate.
delay in lectures after 5
How-
years.
See, if they have been successful, they would have been appointed in your place. Why not?
Failed candidate, how can be appointed?
We never
They
fail,
are
my
not
lord. I think
selected. You will also
based
can
on
go to
imagination,
petition, paragraph 7.
But then failed candidate, but then you must be eligible.
Whether we are, my lord, whether we are eligible or not.
You
It is
see,
not
says-
their
it says a
outcome.
law.
Once they might have
Suppose,
selected
what is-
below and not appointed.
Can a read be can a read of quo warranto be filed against a person holding public office or public post? Can a quo warranto be issued?
Yes,
Quo warranto can be
but there is
moved
no-
by anybody stranger also.
Yes,
Then
my lord, there is no, this is not a rate of.
no.
warranty.
Question is that you must have your own right to stay in that post. You don't have a right to stay because the basic requirement that you must be you pass out from a qualified or is a recognized institute does not exist.
My lord, if
Therefore, you are coming for a non-existent.
my lord, if that was the plea by the government, we had no case. Government doesn't say that.
Even if the government does not say it has come.
Their petition.
You see, Mr. Sharma,
Yes.
we agree that just because the government has not taken the
government-
plea,
my lord,
now
government
matter has
agreed.
come before the court. Now the court has decided on merit. Whether the government takes the plea or not, the matter has come up with the court. Court has given an observation on merit on the basis
My
of
lord,
law.
that's why.
We can't say that no, the court. Therefore, we can't say
My lord,
the
that's why I
government did not
refer
take
to
the
Lordship.
plea. Therefore, to reverse it. I don't think we can do that in appeal.
My lord, that advertisement which prescribes that condition was never put to challenge. That is why Learned Single just said, you verify. Now the authority has verified it and found that it is not there. Therefore, their services has been terminated. Now, my lord, technically, nothing can be given in this writ appeal. If at all, my lord, my learned.
We are
friend
against
can
the
convince
judgment,
learned
my lord.
single judge,
Since
that is a
somebody has
different
filed
issue.
the, my lord, a writ petition against termination, that is, we have been gone. We let him admit it and heard. Finally,
Mr. Sharma,
yes,
just because you file a writ appeal, shall we entertain it?
my lord,
Unless we are convinced that there is some merit in the appeal.
my lord, merit is there.
What, tell us, on what ground? Number one.
Yes,
Number one, what is the merit? Please tell us.
my lord, after all we passed out, we have got certificate of valid certificate and having worked for 10 years because otherwise if you are
But
not.
see,
my
there's,
lord,
you know,
if-
Mr.
if you are-
there's
if-
so many
my lord,
judgment
no,
in this
no, my lord.
Supreme Court also.
My lord,
Even if you have rendered for 5-10 years,
No,
if you
that-
don't
that
have
is
the
right.
essential qualification,
what I-
out.
my lord, let me submit.
Huh.
If we are not yet qualified, we would not be able to work for 10 years with full experience. And we did execute the job given to us. Not that we are not qualified.
To
We are
satisfy, that-
qualified.
to satisfy that you meet the requirement of the advertisement.
You forget
That's
these
what my lord, they
inefficiency
Lordship
or
also-
say inefficiency or overlaps or overlap by or lapse by the authorities concerned. You say that I am a person who is entitled to hold this post because I possess this qualification. You
Because,
do that.
my lord,
If
that's
you are not
why-
able to do it, now it is writ appeal. Lana single judge could have said so. Lana single judge could have, yes, no, government, you didn't say anything, no, we allow, yeah, there for 10 years, we'll allow.
Yes.
Then in appeal, we said, why? We don't want to disturb. There is another issue.
After all, my lord, they have served for 10 years.
Doesn't matter what to do.
Satisfactorily. And my lord, that's
See,
why
law,
this
law does not support. Law says that if you don't hold a requisite qualification, whether you had held it for 5, 10 years.
But whoever the diploma we have got, not that. Only the institutions are different.
Exactly, it must be run by recognized, means by person who was recognized. Otherwise, see, everybody, there's a shop. There's a shop industry is going on. Industry of education industry. Where everybody opens a shop and says, you come, we'll close.
Government doesn't say, my lord, that these are invalid certificates. Who are not qualified, they don't say. Only their lords will differentiate whether registered and recognized. So that's why your lords may at least issue notice, hear me in detail.
Whether regarding recognition, what the Lana single judge say? Regarding recognition.
The rules were not there, my lord, when they was made, it came in 2012 only. After the
Mr. Deka, we are for earlier from whom? Private respondent. Okay.
government it is. 141 page.
The government wanted to do some favor to you, one can understand, because they have not, they said they have belatedly nothing else, but then still, the private respondent is an important issue.
My lord, what I am on, government advertised for recognized.
Mr. Sharma, even if the government keeps silent.
Let me complete, my lord.
Yes.
Government recognized, we are registered and we applied. Government accepted. That means government who have accepted that they could be appointed and appointed after selection. So whether that will count or not.
Regarding this recognition and
Page
registration.
182 in the review judgment, there is a detailed discussion.
182.
Yes. Page 182.
Yes.
This court has given excess consideration to the argument advanced by the learned counsel for the parties. The advertisement dated stipulates the essential qualification to be laboratory technician certificate course or above equivalent. Such qualification is required to be obtained from any medical college of Assam, recognized institute of the government of Assam. Rule 8.1 of the rules of 12, which admittedly came into force subsequent to the last date of submission of the application, stipulates the following. Must have 2-year diploma in medical laboratory technician course from Assam Medical College, Guwahati Medical College and Silchar Medical College. Those candidates who obtain 2 years diploma course or its equivalent diploma from outside the state of Assam, their certificates are to be authenticated by the Director of Medical Education of Assam. If certificates are not done by the Director of Medical Education Assam, those candidates shall not be eligible to apply for the post.
So this is must have passed 2 years diploma in medical laboratory technical course from Assam Medical College, Guwahati Medical College, and Silchar Medical College.
See, if obtained from outside.
Outside, then it has to be authenticated
authenticated
by, and they are from state Assam.
No, they're from outside.
They are from outside. Okay. So they have to be authenticated by the Director of Medical Education.
Yes.
They are outside which state you have passed out?
Bengal.
Say, for example, you are 3. How many of you? Let us see. Let us see your.
We are only 3, my lord.
Yes, let
One
us see
is
your.
my lord. My lord, kindly come to one page, page 184, para Roman 7. They admitted.
184.
Page 184, para Roman 7.
It is admitted by
It
learned
is
counsel.
admitted by the learned counsel for the petitioner that the institution from which petitioners had obtained their certificates are not recognized institute of government. Yes, that is admitted. Such factors not available on record in the proceedings of WPC, and state respondents were silent whether the institution from where the petitioners had obtained their certificates.
Is this institution recognized by the which institute? Just tell us.
Yes.
Which is the institution? It shows that shows the certificate. Shows the certificate. Which one?
Just
Any exam? Yes, you have 3. Just show those 3 certificates from where you pass out.
yes. Just It is, my lord, from Midnapur,
Where is it?
page 162,
162.
para 29.
No, Vidnapur, we want to see the,
No, that's the learned single judge has recorded. my lord.
correct, but why is it? We want to see that
That
Institute of
my
Medical
friend will
Technology, Jhargram, Midnapur.
Yes,
Where is that certificate?
Jhargram.
My lord, Sikka, Midnapur. Also from Guwahati also, my lord.
Tell
Assam
us.
also.
No, if it is from Guwahati, then please get out. Because Assam, you have to be in Assam. We are considering of the non-Assam. If you are from Assam, you are out.
Outwards.
We will not even, out means we will not even hear you appeal. But for those people, for those candidate who has passed out from other state, we'll see. We want to see.
Institute of
How many
Medical-
students? Three, you said 3 candidates.
Yes.
And after
I
3,
want, my lord, see 160,
59, 60, my lord.
164, 64,
page,
yes, 64.
page 64.
Yes.
Let us see. What is this? Noticed?
No,
What is noticed Board of Health? What noticed?
Northeast Board of Health, Allied Health Studies.
Ye Bhagwan, nikla cool ki hai.
Noticed.
Yes.
What is
Yes,
noticed?
my lord, 3 certificates are page
In
59,
Guwahati,
60 and 64.
Guwahati, so you are out. You have to from then who is the other one?
Page 59 and
He's
60.
Alimony Bora.
Ah,
Alimony Bora is out. Because the rule this way says you must be from Assam, this one. Then Alimony
lord-
Bora is out.
Page 59 and 60, other two.
Alimony Bora. Then page number
59.
59.
Kaushik Das.
Let us see.
This I can't even read, my lord.
This is Institute of Medical
Technology
and Research.
and Research.
What is it?
There is
Ganesh
no
Guri.
address. Ganesh Guri.
Who is this gentleman? Kaushik Das also out.
Out. Next page 60, my lord.
62.
This is
62.
Ganesh Guri. Ganesh Guri.
62.
Alimony Bora is from? Alimony Bora is from? Northeastern. He also
Northeastern.
Ambari.
Ambari.
Ambari. Then number 3.
62, page 62.
This is Diplomat Technology. Pankaj
Rural
Barua.
Institute of Medical Technology. Ye Bhagwan.
Pankaj Barua. From
Yes.
where? Rural Institute of Medical Technology.
It's not even indicated, my lord. Which
Seal
place?
is there, my seal is not clear.
Laboratory Technology. Where? From where?
No place.
Where?
No place.
Oh, Northeastern.
Seal is there, seal is not clear. Seal is there, this is there.
What seal though? What is this seal? This seal is the only part. What is the Board of Medical Technology? No. Medical diploma. Which part of the country?
Page 63, my lord.
No, this is a notice that this is for Alimony Bora.
Yes. Let me get the original, my lord. Let me get the original. This one.
In your writ petition, you must have mentioned.
Yes.
In your writ petition, you must mention.
No, I'm not the petitioner. I'm the respondent.
No, in the writ petition. Respondent. You are Pankaj Barua.
Borua.
And how?
62.
Our
Then
country is
in the writ
102.
petition, you know his identity. That's why you said you don't know his identity. You have made him a respondent number 7 in the writ petition.
Yes.
Then what do you say that he's?
But they are not from the, they have not acquired the diploma from the institute as prescribed in the admission.
Laboratory technician, Bora. Is he from outside Assam? Because those two whom Assam, they are out clearly. Because the rule says
Page 60.
we cannot go against the rule. Is that you must pass out from this Assam Medical College, this college. You are not from that. So you are out.
My lord, at page 30, para 11, we have taken clear stand, my lord.
But you don't know this
And you see,
gentleman.
my lord, that the petitioner beg to submit that the bare perusal of the
No,
certificate.
that we have understood, but this gentleman, Pankaj Das, why Pankaj Barua, why he
Barua.
pass out from where?
We don't know.
You don't know.
He himself doesn't know, my lord.
He also doesn't know.
He himself doesn't know because there is no name is indicated.
No, I will bring the original certificate. Why should I not know? Maybe a photocopy only.
Course in medical laboratory here by
When my learned friend does not know. How can I?
Because why he is challenging our appointment, he should know.
no
You should
this
inquire and
Rural
inquire.
Institute of Medical Technology.
Yes.
Rural Institute of Medical Technology. এখন ক'ত আছে? ও জায়গাটার নাম কি?
শিল তো বোঝানো যায় না।
Day after tomorrow, bring the original certificate. Day after tomorrow, we'll see. If you are from Assam, all of you are out. Ambari, Ganeshguri, we know while we pass through Ambari, Ganeshguri, lot of this what do you call tuition centers are there. They cannot be because Assam is very clear. Rule that page number.
Page
No,
46.
rule is not applicable. Rule came later on.
46, my lord. The
That is, that
advertisement.
Assam Medical College, three medical college, that came later on.
Laboratory technician certificate course of
Because the,
course.
That rule 8 something you have read
No,
in
no,
that.
that came subsequently, my lord.
Subsequently,
But this is the prescription in the advertisement, page 46.
Page 46.
Laboratory technician certificate course of the above, equivalent from any medical college of Assam, recognized institute of government of Assam.
yes.
Recognize.
Either it should be, my lord, from the
You
either
are
of
from
the-
any medical college of
Yes,
Assam.
Yes,
You are not from medical college.
or from recognized institute of government of Assam.
Government Assam.
That, my lord.
Ganeshguri is not. Ambari is not. So out. Then well, let us see Ratnakar Barua. Where did he obtain his
Let
certificate?
them Friday, my lord. I'll call him.
Right.
Right.
I think if he comes up with a photograph of the institute, it will be beneficial to us also, my lord.
Then we want to do the rural setting. How that beautiful that India, the rural setting, rural technology.
He will go to the, he will
Go for a picnic one day.
Yeah, Friday.
10th of February. Item 25.
Jorhat. Jorhat, what is this? What happened to Jorhat?
This is not a similar case with your lordship. This is a case, my lord, where the settlement order was set aside and court directed you give settlement for 8 months. That goes beyond the period of settlement as per the NIT.
Ah.
So similar matter, your lordship issued notice and fixed the matter on 22nd.
Why, Nikki? Let it come on to this second.
Lordship, I am in.
And you are for whom? Appearing for whom?
I have instruction for appearing for respondent number 1. Lord.
Respondent number 1. Who are the respondent?
Respondent number 1 is Gautam Boral.
Gautam Bora.
Yes.
Then other are state respondents? No.
No, respondent number 5, 6 and 7 will have to take steps.
Okay, take steps then.
Take steps by registered post as well as by
Dusty. Hard Mr. Anderson accounts assisted by so issue notice renewable, returnable on
22nd
22nd.
of February
As similar matters are pending.
for consideration of the interim order.
For concern, where similar matters is pending as regards prayer for interim order. Mr.
Yes, Teka.
As Deka appears for respondent number 1. And state of Assam? What is that? Appear for 2, 3 and 4. Appellant to take step for service upon respondent 5, 6, 7 by the sub post AD. Ready, Dusty also permitted. Yes. Next.
Extra copy may furnish.
Extra, yes, please furnish extra copy. Yes, next.
Item 26.
Same, my lord, respondent.
Same. You are for?
I'm on KVS, my lord. For the
KVS.
writ petitioner.
So, caveat means respondent number here.
Respondent number 1, my lord.
Respondent number 1. Then similar, yes, but
Yes,
for
respondent
remaining
number
respondent.
5 and 6 will take steps.
Okay, same order, 5, 6 step. Yes, yes. Next.
My lord,
Same order, huh?
22nd
order.
consideration of the interim order.
Yes, yes.
Supplementary list for admission. Item 39.
I'm all right.
39. Muksar Ali, what is this Muksar Ali? Yes, what is this Muksar Ali? What for you have come? Today is for what purpose? Muksar, none appears. Bordoloi, have been duly rehabilitated. Oh, petition number 1 is also having a land. You want
My lord,
more and more and more.
no, my lord.
He said you have been all rehabilitated by the state government.
My lord,
Is it correct?
Yes, your lordship.
Is it correct?
my
All
lord,
these petitioners, how many petitioners are
my
here?
lord, three, my lord,
3.
three, my lord.
3 have been rehabilitated. 1 is having a land of his own. Therefore, if you are having a land, so that question of
Only, my
rehabilitation.
lord,
Yes, tell us.
my lord, before arguing the case, my lord, I have to clear the, my lord, about the law, my lord. My lord,
We'll come to the law.
My lord,
We'll discuss in academy, we'll law in judicial
Yes, my
academy.
lord.
But
What
please
happened,
tell
my
us, please tell us, are you a landless person or not? Petition respondent number 1, petition number 1.
My lord, I got information that a respondent number 1, petitioner number 1 passes 1 kata 5 lesser of land till date. My lord, only passes for the domestic land, my lord.
What do you want? What domestic land? What domestic you want? How
My lord,
many?
only for one, my lord.
And this land is for what? You do business here? What?
No, my lord, I am.
So you have a domestic land, you want to this business land, what?
My lord, as per my lord law, my lord.
Again, you are coming to
entitled
law.
my lord, if I have a land, my lord, 8 bigas, up to 8 bigas, then also my lord, as per law, my lord.
Then you can purchase the entire country, no problem,
No,
if you have the money. Question is not that. Question is that can you occupy a government land? That is what they are saying, that you are encroaching upon the government land. We have evicted them and we have rehabilitated them.
I filed, my lord, Kogula for settlement of the land, my lord. Government allotted my land, my lord, only my prayer, my lord, is that, but only they have
been
evicted.
rehabilitated. You have been given an alternative land.
No, my lord, till date, not given.
No, who is, you tell me first one by one. One is Mr. Muksar Ali.
Yes, my lord.
Muksar Ali, they say you have a land of your own, isn't it? Bodolo?
Yes, Your Lordship. Yes.
How do you say he has a land? How do you say he has a land?
Affidavit dated 23/5/2022.
Yes, yes.
Page, Your Lordship may turn to page number 9.
Affidavit dated
23/5.
5/2022. Para number? Para number?
For Your Lordship, page 3, the second paragraph, Your Lordship. Point number 3, Your Lordship. May I read it, Your Lordship?
Yes.
This additional affidavit is being filed in terms of the order dated 13/5/2022, passed by this honorable court, that as per the report submitted by the circle officer, Vishwanath Revenue Circle, the rehabilitation of the evicted families at Petulabari under Sakumatha Moza has already been proposed and initiated. The process for the rehabilitation of the evicted families has been initiated at number 4, Chalia village, covered by DAG number 94 under the Vishwanath Moja. This is related to this case, Your Lordship. The appellants in this instant case are also included in the said rehabilitation process. The verification report regarding the landed property of the appellants in this instant case has also been furnished to the office of the answering deponent by the circle officer, Vishwanath Revenue Circle. As per the land records, the writ appellant, Muksed Ali, is not a landless person as pleaded in the instant case. The appellant Muksed Ali has purchased a land measuring about 1 katha at Kochgaon as per the report of the Lat Mandal, White such and such, dated 17/2/2022. Lal Mia, the father of Muksed Ali, is the pattadar of a portion of land measuring 4 katha 16 lechas and the DAG number 460 of PP number 4 and 3 bighas 4 lechas of land under DAG number 486. Total 4 bighas of patta land at Karoini village under the Sutia Moza. Regarding the other two appellants in this instant case, there is no record available with the concerned circle officer's office regarding the periodic patta landed property. However, they are also included in the rehabilitation process undertaken by the.
What is that? What is the rehabilitation process for the remaining two? What do you find?
My updated instructions are that the other two appellants, they are the one specific plot of land was chalked out, and these persons are already rehabilitated in that portion of that plot of land.
Do you have the instruction? These are the facts.
No, my lord.
You don't have instruction, then we'll close it. You take the instruction. We are relying on her statement.
My lord, I inform my lord that they are going only, my lord, file this affidavit, my lord, but they are not rehabilitated till it, my lord.
Lordship, it's on.
My lord, only there, my lord,
You then see Bordoloy, in view of his statement that they have not even able to file an affidavit by tomorrow, day after tomorrow, we'll close it. On the basis of your affidavit.
Yes, Your Lord.
Because that is a solemn affirmation made by an authority concerned.
yes, my
Let it come on Friday.
lord. My lord, I approached authority, but.
Correct, Mr. See, once you've been rehabilitated, the matter ends there.
Yes, my lord.
Okay. You file the affidavit, by Friday we'll dispose it.
1 week time may be allotted.
List on Monday. It has been submitted by Ms. Bordoloy that in terms of the, as mentioned earlier in the affidavit of position filed on, additional affidavit filed on 23/5/2022. It has been ascertained that the petitioner number 1 is having a land of his own, and the two remaining the steps have been already initiated for rehabilitating the remaining two petitioners, regarding which Ms. Boduloy seeks some time to file an affidavit. We are also view that if the petitioners have been rehabilitated or is owner of land as mentioned, nothing survives for further consideration. Accordingly, list the matter again on which that the matter can be made, an attempt will be made to dispose of the petition on the basis of the affidavit that may be filed by the state. Okay, file on. Okay.
February. 13th. Daily list for orders, item 28.
Item 28. What is this, Anjali Goswami? What is this IF for? Yes, anybody for Anjali? Though call out, no one appeared. What is this matter about, Anjali Goswami? State of Assam, 2015 matter, very old, 2015 means dinosaur age. Very old, 2015. Many of their lawyers, they are not even lawyers. Huh?
Yes, madam.
Huh? What is the matter? What to do with this 15? What is anything in the matter? What is this matter about? Do you know, Mr.
We have also
What is the matter about? What is the main petition? Who is the real appeal, main appeal? Is there any merit in this? Because she may be lady, she may not be having money to pay this lawyer fees and all these things, therefore she is not present. What is the issue involved? State Selection Board Assam consists senior most assistant teachers of Kuarital to the vacant post headmaster in the selection 2010. A combined selection was published 4 namely Rani Devin and Anjali Goswami remained valid for 1 year. That after Rani was promoted to post, the symmetry was promoted for and the symmetry was superintended. Promoted appellant. This one held there as in the postman was filled out promotion as a promotion. Oh, her promotion was set aside because of Amlan Goswami.
In the meantime, she may retire also, madam.
They were trying to find out whether she has retired because how old was she at that time? Let us see. What is the age of retirement?
60 years, madam.
60 years. Let us see the affidavit. Actually, certificate the grounds for appeal petition. WPC number, violation of Article 14. Anjali Goswami. Actually, the age is not mentioned, no? If she is already, can you ascertain whether? Then we can close it.
Yes, madam.
If she is already retired, because we can't put her back to service.
Yes, madam.
Because it's 2010.
Madam, comment on Friday, madam.
Friday,
Yes,
Friday.
madam.
Just a minute. Assistant Master Urmila, all are retired. Dibbu Jyoti Bora. Anjali Goswami is promoted to the post. Around 12.
Madam, there is an IA for condonation of delay, madam.
No, we'll see. We'll see.
On that, madam, may get the date of birth, madam.
Oh, okay.
Age,
Anjali.
madam.
Yes. Anjali Goswami. $50 years.
50 years in 2015, madam. Then it's 55. 58, madam. Now 58, madam.
Now 58. So you, what is the retirement?
60, madam.
60. Unfortunately, the matter was never heard. B. Sinha. B. Sinha, where is Mr. B. Sinha? Do you have any idea? B. Sinha ke? A. Sinha, B. Sinha ki. B. Sinha mane ki. They just see whether it is approved, whether they are willing to, what is the problem?
These selective reviews considered to be essential.
Hmm.
Is the ground. And selection, also assistant and master is conducted. Person was appointed. Some other person. So select leave got expired. That person retired. Again from that select leave.
Okay, Pisina. Mr. Khotania, can you find out what is happening in that school?
Yes, madam.
When?
Friday, madam.
Friday, very good. If you can find out, because perhaps it may have become infectious, that's why they are not pursuing it.
Yes, madam.
There is no point keeping this 2015 matter in board.
Yes, madam.
Huh?
I'll find it out. Basically, selection to the post of assistant headmaster of that school. What is I'll find it out, madam. Status.
Maybe we can close with the observation that if still she has still grievance, she can revive this IF.
That can also be done.
Because there is no point, because 8 years, she is not bothered, that means something must have happened.
Yes, madam.
Otherwise, they would have come running to the lawyer.
Yes, madam.
So how many B Sinhas are there? Only one, Nagi. There are two B Sinhas. You have called up both the B Sinhas. Huh? Huh?
There is also one D Sharma.
D Sharma. Likho. No one appears for the applicant. From the order, it appears that after this application was moved on 5/6/2015, seeking for condonation of delay of 123 days in preferring the appeal. Notice was issued returnable on 22/7/2015. And the applicant was directed to take steps upon the respondents by registrar post, private respondents to registrar post with AD. When the matter was taken up 23/7/2015, the applicant was directed to take fresh step in respect of respondent number 4. Thereafter, this matter had remained in cold storage. Matter was taken up on 2/1/2, the matter cold storage, and matter was taken up again. And the matter was put up before the Lojima Court on 25/3/2022 when none appeared for the applicant. Since the step was not complete, notice was not complete in respect to respondent number 4. The Lojima Court directed the applicant to take step for take step by registrar post query in respect to respondent number 4, as well as the usual process. It appears nothing has moved thereafter. When the matter was taken up again on 2/1/23, none appeared for the applicant. We have also seen the order by which against which the appeal has been preferred. The learned single judge appears to have set aside the appointment, promotion of the present lead appellant, primarily on the ground that she was promoted to the higher post of assistant headmaster on the basis of a select list which had expired. Full stop. And as such, her promotion was not in accordance with law. We are not making any observation on the correctness or otherwise. We are not going into the merit of the case. However, reference is made only for the purpose to enable to understand the case, the nature of the case. From the above, it appears that direction was issued by the learned single judge to fill up the post, vacant post, in accordance with law by taking fresh steps. We are not aware as to what is the position as to the said post of assistant headmaster. Learned counsel for the state also is not able to assist us without instructions in that regard. Full stop. The fact that the applicant has not pursued the matter, the fact that the applicant has not pursued this matter could be for the reason that matter has already become infructuous, or in the meantime, we full stop. However, we are not inclined to keep this application pending for such a long period. Accordingly, we close this IA application. However, we still grant liberty to the applicant to approach this court and for revival of this IA if cause of action still survives, and cause of action survives, and applicant is still aggrieved by the direction of the learned single judge. With the above observation, we close this IA.
Article 29.
Close the IA for condonation of delay, seeking condonation delay. Acte number
29,
29.
Lordship.
Contempt.
Lordship, this matter relates to the, Lordship, in the writ petition, Lordship, we had challenged the.
What was the direction given by the learned single judge?
Lordship, it was ultra-virus, Lordship, that's why.
Ultra-virus.
Yes, Lordship.
What is the ultra-virus?
In the lip, Lordship.
Huh?
The rule 63.
What has been declared ultra-virus?
Lordship,
Rule,
the rule 63, Lordship.
what is rule 63?
Lordship, you'll find it, Lordship. Lordship will
Accordingly,
find it in
declare
page
a
number 10.
reporting authority district officer shall be the officer higher in rank to that post and member of state police. So it was declared ultra virus. It has not been challenged.
It has been challenged to the Supreme Court, Lordship.
Okay, then what is the contempt?
Lordship is still pending in apex court, Lordship.
In SLP,
We'll close this
4-3.
contempt, Mister. We'll close this contempt petition.
Lordship, let it be.
No, we'll close this contempt petition, and you will be at liberty to file, this closure of this will not entitled to approach this court again, depending on the direction of the Honorable Supreme Court.
Lordship, in my humble submission, Lordship, let the contempt petition.
No,
be filed.
why you want to keep this matter? What,
Because
because,
Lordship, the
but
SLP
because this was in 2018 contempt,
Yes,
all these officials whom we are, and
are
if
IPS
the Honorable
officers.
Supreme Court reverses, then there is nothing, no contempt. We don't know also.
Then Lordship, at that time, Lordship, it will be closed.
No. You file an application at a time. We will ask you to revive it. There is no point keeping these matters like this. Because in any event, the person whom we have alleged to have committed contempt,
Lordship,
they're all out.
Exactly, Lordship, these people are not in the
Number one
petitioning
is
capacity,
retired from
Lordship.
service and respondent number 2 is no longer holding this post.
That's the thing. And therefore, what is the
Yes,
point?
Lordship will file and Lordship, let the.
We'll allow you to make an application on behalf of the petitioners to revive this. The council can make an application.
Some loopholes might.
What
create,
loophole?
Lordship.
No. We'll pass an judicial order now. Then we'll authorize you to file an application on behalf of the petitioner to revive this contempt petition if the order of this court has been affirmed by the Honorable Supreme Court.
But Lordship, in my humble submission, the simple way it will be, Lordship, with this, if you, Lordship, is the contempt petition is kept pending, your Lordship.
Oh,
You will wait
again,
for
we
the
are saying
Supreme Court's
though,
order, Lordship.
we don't have space now. We have
Because
to,
It's a very small file, Lordship.
because this 2018 matter,
Yes,
you file it again, we are giving you the opportunity, because we don't know if the Supreme Court set aside nothing, the matter ends there. If the Supreme Court affirms, then the contempt will arise. In that case, you revive this application. Har Mr. Lane Counsel for the petitioner, also Lane Counsel for the present contempt petition will filed against the order dated 5/12/2017 passed by Lane single judge, passed by this court, by this court in WPC number 4752 of 2015, by which Rule 63 within Roman 3 of what? Of
Lordship, rules
All India
Of Assam Police Manual, Lordship.
Assam
Chapter
Police Manual.
4 of Assam Police Manual.
has been declared invalid in being in direct conflict with section 14(2) of the Act 2007. And accordingly directed that the reporting authority of the district superintendent police shall be an officer higher in rank of that post and a member of the state police. It has been submitted at the bar. The matter is pending consideration that the appeal that this has been appealed against, and SLP pending before the
SLP.
Honorable Supreme Court being
SLP diary number 43671 of 2018.
to 18.
18.
Full stop. We have the view that in the event the said SLP is allowed, the question of committing any contempt of this order passed by this court will not arise. It will arise, it will continue to arise only if the decision of this court is affirmed by the Honorable Supreme Court, in which case the petitioners would be at liberty to apply for in that case will arise. Accordingly, we close this contempt petition with liberty to the petitioners for revival of this contempt petition on an application that may be made by the council for the petitioners. With the above observation, the present contempt petition stands closed.
Lordship, there will be no question of delay, Lordship.
And as such, there can be no question of delay in reviving the said contempt petition upon the decision, depending on the decision that may be passed by the Honorable Supreme Court in this regard.
Much obliged.
Next.
Item 30.
What is this Arun Kumar Malakar?
May I beg your lordship, as per last office note dated, neither unsub notice nor AD card has been received by the sole respondent, lordship, though we have taken steps twice.
You are challenging which order? prayer of the petitioner for dissolution of marriage between so and so is dismissed.
Yes.
That's the,
And Dusty, you want to live with her, with Pratima, isn't it? You want to live with your wife.
No, Lordship,
You don't want to live.
They are
you
staying
want to
separately
divorce, huh?
from 1996. Your
Huh?
Honor. They are staying separately since 1996.
Till now,
Till now.
1996.
And Arun Kumar Malakar has married to another
Another woman.
woman.
But how can you marry? Your decree for divorce is dismissed.
Lordship, the petitioner is
Bigamy, in that case, bigamy, you can be also arrested for committing bigamy. Anyway, the Pratima is, what happened to Pratima? You must be having some idea, where is she? Hmm?
No, Your Honor, we have taken.
Have you, we are married. Hmm. Okay.
is there any other proceeding pending? Maintenance?
Maintenance is rupees 800 per month.
What are you doing, Arun Kumar Malakar? You are doing what? You are a? What are you doing
Preparation.
in the railways?
Yes, Your
How
Honor.
much you get?
In that maintenance is, it was rupees 800 to pay.
When was the 800 rupees? When it was directed to be paid? You have been paying or what? No.
Lordship, for some days we have paid, but
After that, you didn't pay. And Pratima also happy not to get anything from you. Huh? Pratima also not bothered. She must be married to another person also. What to do? Anyway. B.J. Mukherjee appellant notice sent to her has remained unresponded. 6 leave. Fresh steps. Have you taken steps?
yes, Lordship, we have taken steps twice.
Hmm?
One on 17/3/2020 and another on 10/6/2022.
No, thereafter, no unserved edigan have been received. 22, according to restrict to LCR. No, not a minimum LCR not called for. You will take steps again.
Fresh steps.
Fresh steps to be taken. You know where this your wife is still? No, we don't.
No, we don't
You
know.
can-
Actually,
Huh? Can you take by Dusty also?
that is on West Bengal, Lordship.
Oh, she has gone to West
Yes,
Bengal. She's in West Bengal or what?
She is in West Bengal.
You are in
Post Petition District, Kuch Bihar, Lordship.
Kuch Bihar. And where are you? You are now where? You are Bongaigaon.
Yes, Lordship.
You are also residing in Siliguri,
Yes.
West Bengal.
Presently.
Can you take fresh steps? Take fresh steps. Applicant will take fresh steps for service upon respondent by resta post. Dusty also allowed. Take step. Yes.
Item 31.
Renuka Boro. Oh. We'll continue in the second half.
May I please allow?
Yes, what is this Renuka Boro? IA for what?
I is for delay. His delay of,
Why you are filing this appeal?
Lordship, actually, opposite party respondent is my father, though he denied it before the trial court. And they also took the plea that we are tribals and we are not under this act.
Who has, you have filed this application? Why you could not serve notice?
Lordship, we have taken steps twice.
Then what to do? Do you know where father is?
Yes, Lordship.
Where is he?
He is in Bijni.
Can you take by Dusty?
Dusty, Lordship.
This Boro, Phukon Chandra Boro.
Chandra Boro Road. That is his own house. That is the address given in the trial court where he appeared in the same address.
And why it is
But
not,
now he is not appearing before this court.
no, but we had taken steps.
Lordship, twice I have taken steps.
Notice upon respondent number
One
by reserve post has been issued by memo. This in review. Can you find out whether notice register post have been served or not from the postal address?
Lordship, I can take fresh step because that will be again. When it has been long time back, step was taken. I think last year the matter was listed and I had taken steps.
What were the order passed with the learned family court?
Dismissing her petition for maintenance. Lordship.
Maintenance.
Yes.
What was
It
the
was,
ground that you could not
ground
prove?
was that on the page 17, Lordship. That is the order last period. The court in dealing with application of sections subsection 2 of the Adoption and Maintenance Act as follows. Notwithstanding anything contained in subsection 1, nothing contained in this act shall apply to the members of any scheduled tribe within the meaning of clause 25 of article 366 of the Constitution, unless the central government by notification.
You take Dusty?
Lordship.
Yeah, you are in the same village.
Lordship, I stay in Guwahati.
And the father?
Father, he is actually in armed forces.
Where? Armed forces?
CRP. I'm not aware where he's posted now.
You should get it. We can get it, delivered through the CRPF authorities. You are certain that?
Lordship, I'll try to.
Then we can ask the authorities to deliver it because he may be moving around and there.
Yes,
No.
Lordship.
It has Ms. Submits that applicant submits that the respondent is serving in the CRPF. If that is so, let the details of the office service of the posting or service oblique posting be ascertained so as to enable the applicant to take step through the CRPF authorities, as the respondent has not been responding to other earlier process for service of notice upon him. This after?
Any day, Lordship.
Okay, after 2 weeks. This after 2
Much
weeks.
obliged.
Remaining after vacation, after
Or remaining.
at 2 p.m. At 2 will take up the remaining. Next item.
Daily list for orders, item
32.
Yes.
Bharati Day, what happened? Yes, madam.
Yes, Your Lordship, but
Why you have filed this appeal?
we have challenged order dated 22/6 of 2022.
Challenging what? That the decree for divorce.
Yes, Lordship.
Divorce was allowed
Yes, Lordship.
by which order? June 22.
22 June 2022.
So you are challenging the divorce.
Yes, Lordship. Now,
On what ground divorce was allowed? Divorce was allowed on what ground? You don't know. Torture, no, restriction. Anyway, after this divorce was granted, any alimony, something?
yes, Lordship.
How much is it?
2,500, but we are not receiving any maintenance amount.
Why? How do you survive?
Yes, Lordship.
You are not getting, or why
No,
you are?
Lordship, we are not getting any
What is
maintenance.
what is your order? What is the direction?
Mm.
Marriage between twins to dissolve. What is the direction for giving?
Lordship, it's in 39/2023.
What 23?
The order of the maintenance.
Page number Have you taken steps? Fresh
No,
notice to
Lordship,
respondent.
we have taken steps, but since the address is not correct, we may be allowed to take fresh steps upon the respondent.
Respondent, why the address is not correct?
Lordship, presently he resides in Bangalore, so
He is staying in Bangalore.
yes, Lordship.
Care of Central Cell Board. He is working in Central Cell Board.
Yes, Lordship.
Care of Central Cell Board, what? In what capacity? In what capacity? Just saying the Central Cell Board will not help. Like care of Government of India.
Lordship, we may be allowed to take correct steps.
Otherwise, you will continue
Take
to
steps
suffer. You will not get
towards
anything
correct
also.
address.
Okay. Applicant will ascertain the correct postal address. If necessary, the details of the office is stated to be working with the Central Cell Board,
Yes, Lordship.
Central Cell Board, Bangalore, for effective service of notice. When it will come up?
After 2 weeks.
This after 2 weeks. Yes, next.
Item 33.
Sukhomoy Das. Yes, what is this? Why you are filing this appeal?
Matrimonial appeal, already has done, was done it. But
Aware service report.
but we have sent by registered post. Had it not been received, it would have come back because under the cover of the High Court and law, it was sent.
Marriage is dissolved.
Yes.
You want to live with her.
I come against alimony. Alimony of 20 lakhs was granted without representing in town.
Sukhomoy Das.
Okay.
What are you doing?
He was underqualified doctor, right? Originally.
Underqualified doctor? What do you mean
Not
underqualified?
MBBS, Pura.
Huh?
Then finally not MBBS. He was working in the garden, my lord.
What do you mean by underqualified doctor? You are not going to jail. You have treated how many people underqualified?
Now he has left his job and doing in a medicine company. You also kind of see that.
Anyway, what do you want? Anyway, take steps. Take steps. Take steps.
But we have sent by registered post under the cover of the High Court. If they
Okay.
have not received, it would have come back.
Okay, you see from the
They
post
have-
office also find out whether it has been served or not.
They have received him, Confill is not willing to come and contest. They
Okay.
have received it.
Applicant may file necessary certification from the postal authorities of service of notice upon respondent. This after 2 weeks. Yes, next.
Item 34.
South Valley Infracon, what is this? What is this South Valley IFO what? IFO what?
May it please, your lordship.
10 days.
10 days delay in filing the appeal. my
10
lord.
days. You
Basically,
are paying for whom?
I'm happy for the railways, my lord.
Railways. How much will pay?
the
10 days.
ground of delay was because the council on
Doesn't
record,
matter,
my lord,
you are-
his father expired, because
Oh.
of which he couldn't file it on time. Actually, by the
No,
time,
not because of the client, but lawyer.
it was because the lawyers, the father.
Okay, लिखो हर
resigned
Mr.
since
Lani
short.
Senior Council applicant also Lani Council parent is not being objecting allowed. I will let the connected appeal be listed by after registration. Yes, next week.
1 to 7, my lord, not for 8. This phone number 1 to 7.
Oh, who is right? Just a
Eight
minute.
is Standing Council, Punjab National Bank. We had already taken steps. Served a copy. He's in
But
fact,
but then again, see, if he is not sub notice, we can't, then he will.
notice has been served. He was there in the first half.
The name is also shown, my
Yes,
lord.
the name is shown in the cause list.
Mr.
Standing Council, Punjab National
Who is
Bank,
he?
Mr. A.K. Ganguly.
Why
His
don't you
junior
just
was
call,
there in the
why don't you just call him so that otherwise he unnecessary defective, no? Okay. Just
Well,
tell him.
he will inform once. he
Okay.
comes, my lord.
So naam likho har. Then next.
Public.
Item 35.
Krishna Dev, what is this?
But the IA is for condonation of.
How many days?
38 days.
38 days. Who is for the respondent? All are represented. Huh?
1 to 3 only.
1 to 3. All are represented now. How much you are going to pay to the fund?
Let's see, her claim was my lord, for retirement benefit, my lord.
Oh, retirement benefit. She not getting. Oh, there is no point imposing fine. Okay. Okay, her Mr. Lanesan account also assisted by सबका नाम लिखो. The present application filed for convenience delay of how many days?
38 days.
38 days in filing the appeal. The grounds given in the para number.
Para number 13 and 14.
And 14 being satisfied the same, we allow the application.
No objection.
No objection also. Do you have no? Okay, no. Yes, sir. And further, no objection with this. Respondent according to allowed. Delayed condone. Connected appeal be listed. Yes. Yes. Next item number.
For orders, item 40 and 41.
What is this? 40,
Supplement.
41. 40, 41. What is this? 40. Union. Why is union?
I'm looking for 41.
You are for Union of India?
No, mine is 41.
No, we want 40. Who is for 40?
Lordship,
Yes. What is this union? Why you are filing this appeal? Tell us.
Lordship, it had come up 2 days before.
For what? Why you are aggrieved?
This is a matter, if your lordship will recollect, that pensionary benefits for the extra departmental persons, lordship and lordship had inquired whether if the matter can be remanded back to the authorities, they would make a decision on that. There was some 3 months less service.
Oh, that okay, okay. Huh.
Lordship, in fact, I had,
So yes, what is the instruction?
Lordship, I had in fact called a person from the department. In fact, Lordship, that technicality is there, but however, if any order is passed, Lordship, they will consider that.
My humble submission is that
Who are you?
I'm for the respondent, so
So they are going to consider it. Then what is the problem?
No, he expired.
yes, expired.
His legal years are
Legal
also.
hair. The only eligible whether his wife. She is also a heart patient.
That whatever that entitlement as per pension, no, as per the pension rule.
Yes.
But 41,
Who are you?
item number 41, my lord.
Who are you?
I'm also one of the pensioners, my lord.
Ah.
I did not get a order, so I filed a read petition.
You will get also.
It will be admitted also.
You'll get pension.
How many years short?
How many years? How many
Only
short?
Some months only.
Some months. How many months? 10 months, 1 month, 2
No, my
months,
lord, it's about 9 years and 9 months.
9 years, 9 months.
Lordship, what happens is that that fraction of 3 months.
Ah.
There is a fraction of 3 months under the rules that
Yeah.
can be considered as a period of
6 months.
6 months.
But
Now,
here it is not 3 months.
no, here it is not 3 months, therefore can be considered.
Okay.
In the other case, it is a few days.
Okay.
less.
Only few days here.
Okay.
Yes.
Okay. Disposed of. I will get the order after few days. Yeah? 1 or 2 days. Yes,
Lordship,
Nick.
Highly available.
We appreciate your stand, Mr.
Lordship.
Yes, next.
Item 42.
May it please your lordship, the matter relates to enhancement of permanent alimony, lordship. On the last occasion, salary slip of respondent was asked for, lordship.
How much you are getting, Mr.
50.
Huh?
For salary 58,000, my lord, and actual he is getting 47, my lord.
You are getting 47.
Like notice me, this salary.
The family court directed how much?
5 lakhs.
5 lakhs.
Lordship.
And who has calculated this?
Lordship.
You.
Last time your lordship was.
Okay. Have you seen this calculation?
No, my lord.
You don't see. Give a copy, mister. You are the one who have to ask money and you are not showing how much you want also. You think it over. Come up that 2 days.
My
You see, this is a
Salary slip.
salary slip also. We'll see this. Have you got a salary slip? Take a give us copy salary slip. You compare reasonable amount.
Lordship.
Whatever you get reasonable. Everything has.
Lordship.
Let us just
Then the
see
lordship
how
is
much is that? Okay.
Lordship.
Then after tomorrow or Wednesday what? Sorry, Wednesday or Friday?
Wednesday.
Friday, my lord.
Huh?
Friday.
Friday.
Friday. You see, in the meantime, come up with reasonable amount.
Lordship. Lordship.
You also be reasonable
Lordship.
and you lead your own life peacefully.
Lordship.
Don't spend your time in the court. Court is not a good place. It's a place for justice, but you spend so much of time, energy, your resources. No need.
Lordship.
You settle it properly.
Lordship.
Okay. If you can settle it, very good. Yes, next.
Friday, Lordship.
Daily list.
Yes,
for
Friday.
hearing.
List on Friday. Yes, next item number.
Daily list for hearing, item 36.
What is this item? Why it is listed today hearing? It is a hearing day or what?
My lord, it will take some time, this matter.
Why it is listed for hearing? Anyway, yes, Mr. You are for whom?
I am for the. We are the appellant.
Mizoram Good
Gorkha.
Gorkha. Hard so and so interim. So what is this? What is the problem with Gorkhas?
No, whether Gorkhas
Huh?
were given OBC
Huh?
when Mizoram was a part of Assam.
Huh?
Thereafter, there were 3 permanent bodies with the settlings pursuant to Indra Swami judgment,
Huh?
whether they can be recognized or not.
Yeah.
Third permanent body, my lord, they can be recognized so far as the employment, central government employees are concerned.
Yes.
So, my lord, nothing was done in spite of that particular permanent body. They came and filed a writ petition before this court. The permanent body already has said the recognition can be so far as the employee, central government employees are concerned. So now the question which we prefer an appeal is whether a mandamus can be given by the court or not for recognition of OBC. So there are numerous judgment which is cited before this court, my lord. And my lord, a status quo order was passed by this court.
What is the meaning of status quo?
So it will remain because they have filed for contempt of the contempt against the order passed by Lana Singh.
So as a residents of Assam, they are entitled to OBC.
Yes.
When at that time Mizoram was Lusai Hills, no? So now there is in a separate state. So he said now they cannot enjoy. It is okay.
This is what we and in the meantime, my lord, there was direction passed by this court, my lord, that to file an affidavit regarding about social.
But what is the problem if you give them OBC? What is your problem? No, what is your problem? What is the problem, Mizoram? Tell us.
No,
We just want to know what is your
right.
problem. Apart from that, why? Because normally, once Lusai Hills was part of Assam, then they were given all the necessary benefit entitled to OBC in that area, geographical area. Now that it has been separated, correct?
All has been what I mean told, all has turned into Christianity. So they are getting all the privilege which they get it. So no more
OBC, there's nothing to do with Christianity. OBC reservation has nothing to do with your religion.
Let it be fixed, my lord. I will argue this matter, my lord.
You will argue on what?
I'll argue, my lord. Your lordship.
No, correct. We just want to know that point. We are not asking, we are not stopping you. We just want to know what is the point of argument.
First argument is whether a mandamus can be issued
Okay.
or not. That's the first your lordship will decide first issue.
Yes, then second.
If mandamus can be issued, yes, my lord, then the second option will come.
Okay.
My argument before no mandamus can be issued for recognition of Silka. That's my first argument. So, my lord, directly state cannot. It's the central government which can.
Okay.
So that's the point. Another point.
Because classification is for the central government.
Central. Secondly, my which is most
You
important.
may have a point on that.
Yes, my lord, what's more important?
Because the state cannot decide.
Yes, this is
the
what.
status,
This
yes.
is number 2. Number 1 is that, my lord, the number of judgments we cited moving of the appeal.
Yes.
The number of judgments is whether the court cannot, with great respect, my lord, mandamus cannot be issued for recognition is concerned.
Yes.
So it cannot be entertained. Writ petition cannot be entertained, my lord.
Okay.
Additional affidavit file for this. Where is that? Additional affidavit with me. What's in order?
You are aggrieved by the directions of the single judge
Yes.
to accept the findings of the permanent
Yes.
body.
Then what will happen to the recommendation of the permanent body? Then who is the one, who is the authority to act upon the recommendation of permanent body, according to you?
Permanent body cannot be, it has been constituted. It's the only central government minor.
But it was constituted by the state of Mizoram.
I know, that was not,
Then-
I said it cannot be, my lord. Permanent body cannot be, it is only the central government who will recognize.
No, but it is your creation. You said I cannot.
know, that's
Oh,
why I'm saying, my lord, that permanent.
you
body
created
could not
own
have-
house. Said that I can't create my own house. It is your problem. You are creating own house. I said no, I am not entitled to create. If somebody does it anything, that I thought. See, since the present case, the decision of the permanent body duly constituted by the state of Mizoram was taken and recommended Gorkhas, whose parents so and so, so and so. So you are the one who constituted.
Maybe
Your
I
body
think,
recommended.
Yes.
Then you said no. What is this? What is the legal basis for saying denying your own self? This is denial, your self-denial,
My lord will kindly.
your own
say-
body.
First, your lordship will kindly see 149, the judgment part. At 145, paragraph 11.
Paragraph 11.
It's of paragraph 10 at page 148.
Yes, yes. Yes, sir,
Para
please.
11, since 149, since in the present case, the decision of the permanent body duly considered state of Mizoram, Home Department was taken, recovering the Gorkhas in the state of Mizoram, OBC whose parents and grandparents resident in the state of Mizoram. Prior to 26th of January 1950, with a rider that whenever benefit reservation goes in OBC status should solely be for the purpose of employment benefit of the government of India. And in no case under no circumstance in future there shall be applicable for and under the government of Mizoram or any of his undertakings in the state response in spite of our consideration 6 years by now have not rejected the recommendation of permanent body. Dated so and so, and also in terms of decision of the Honorable Apex Court in Indoswami noted about recommendation of permanent body with regard Gorkha state amount to accept and binding upon the state government. My lord, by the permanent body, it is an advisory body, and no doubt, my lord, permanent body has said only it will be applicable to the employees which are working in the central government.
Yes. Then what is the problem? What is
Yes.
your problem? That's why we are unable to understand. In no case, under no circumstances in future, shall the same be applicable for under a government of Mizoram or any undertaking. In spite of consideration for 6 now, I am not rejected. So you accept it. You accept by saying that okay, you get for central government. But as far as central government, that is what the recommendation is. Then why you are agreed?
But mandamus cannot be issued.
Or even whether
That's
mandamus
what
can be.
what you
No, let us correct. Whether mandamus can be issued. Suppose it is issued. In what way you are prejudiced?
No, issued is different. It cannot be issued. That's why.
Okay, we'll come to that aspect, but
Yes.
even if it is issued,
Your lordship will first see whether a mandamus could have been issued by the court or not. That's the law has been laid down very clear. No mandamus.
no, we
A
don't have to
permanent body-
reiterate the law. Here in this case, in what way this order is caused
only-
prejudice to you?
That was the purpose where my lord, the appeal was heard on this point, whether mandamus can be issued.
Oh, we
Yes.
are not the scholars here. We are the jurists here. We are not academicians here. We will pass. What is your grievance? If you have a grievance, we will address your grievance. That leader although will
No, I-
refer to the law college and the judicial academy. for-
There is no question of a law college or.
Because see, what is your grievance? Tell us.
Any law college
You
here.
have a right, you have a locus standard to come here, stand here if you have if you have a grievance. If you don't have a grievance, we close it.
I have a grievance.
What is the grievance?
This is a grievance, my lord, whether a mandamus can be issued. That first your lordship will examine that part, my lord, first part.
That will leave it open to be decided in another case. Here, we don't think any reason to entertain in this area. Because
Then
see,
your lordship will hear me, then I will place judgment. Your lordship reject my contention, no problem, my lord.
okay, you
It's a
argue.
state, my lord, that's why I have to argue.
Hearing will continue tomorrow, day after tomorrow.
Thursday.
Thursday. We go Thursday.
9. Timing 34.
Yes.
My lord, the notice was.
What is this item number?
My lord, this is that delay confirmation application with the.
God really key. What has happened?
Hello, the council for the PNB was served with the notice. However, he's got some back problem, which is why he's been advised bed rest, though he has had instructions to appear in the matter, my lord.
He has no objection.
He said he's not got objection. I spoke to him.
No, objection in appearing, objection is allowing the condonation.
But not be allowing the condonation.
He don't know condonation. PNB.
PNB, my lord. Mr. A.K. Ganguly was served and he's got.
But he
some-
was here.
My lord, and he's got some spinal injury because of which bed rest for a few weeks.
Anybody to PNB on behalf of Mr. PNB, Mr. Ganguly. There is no friend of Mr. Ganguly who can assist him. You are fired, somebody find some
I
friend of.
called up his junior also.
Correct,
he
you-
was
Why
not-
why don't you serve on the bank?
My lord.
You serve on the bank.
My
Tell
lord,
him that the.
Or some junior of Mr. Ganguly,
called
ask him
up
to appear,
junior-
otherwise he'll be empty. They all live stream, empty court, how this court is passing orders, empty.
my lord. the
And
junior
then what
also
kind of
not here.
justice is being meted out in Guwahati High Court principal bench?
I called up the junior, my lord.
Okay, you ask his one of his junior to come and stand here.
I called him up, my lord. He's in DRT, he's not there.
Some other, then some other, see, this empty bench is disturbing us.
You serve on the bank.
Whatever you
Yes, my
want,
lord.
you ask somebody, if Ganguly is not present, some can come and on behalf of Ganguly, we allow adjournment on behalf of mentioning. And we can also allow, if you are satisfied that he really represent, otherwise see, empty bench.
Yes, my lord.
Yes,
13 February.
yes, next.
Item 37.
May it please your lordship.
May
Lordship, on the last occasion, appellant was called in person, lordship. He has not paid a single penny, lordship.
Appellant, Tapan Das.
Lordship, we inform him. But he's supposed
What is he doing, Tapan Das?
Assistant professor, lordship.
Is a professor, which department, where?
Assam University, lordship.
Assam University.
Silchar, lordship.
Why he is not paying? He is not paying. What is the direction of the court? Let us see,
Lordship, kindly produce page 26, lordship.
page 26.
Paragraph 30, lordship.
Paragraph 30. The marriage between petitioner so and so is dissolved.
Lordship.
Respondent party will pay amount of 17 lakhs to the petition permanent. Amount awarded by addition, amount awarded section 25. You have not got a
No,
single
not-
naira paisa.
Not a single penny, lordship.
Why do you
Order
say?
was passed on 17/8, lordship.
You will not get your salary. We'll ask the medical college to stop payment to you. Finish. University. And see, what is the statement that you have not received a single naira paisa? Have you stated anywhere?
Lordship, he has filed the appeal. I have not filed my.
You filed an affidavit saying you have not single naira paisa, we'll stop payment
Lordship,
to him.
lordship.
When can you file?
Day after tomorrow, I'll.
Day after tomorrow you file and come with the affidavit, you have not received a single naira paisa.
Lordship,
I will ask the Assam University to divert amount.
lordship,
Yes.
14 February.
14 crore, yes.
lordship. Oblige, your lord.
Item 38.
Union of India, what is this Union of India?
This is with regard to rental compensation, lordship.
Rental compensation,
Rental compensation in Mizoram.
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 Yes, Mr. Kolita, what is this?
Lordship, what has happened is that, lordship, in the last order, this honorable court has sought for the original records of the revenue department. The record we have received. But only thing, lordship, there is one difficulty in the memo of appeal. Lordship, in the memo of appeal, lordship, the states stand, like lordship states affidavit has not been annexed. So that will be required, lordship, for hearing of this matter. So that may be corrected, lordship, because in the index, lordship, they have stated. that-
Either Mr. You supply or they will get it from themselves, what is?
No, lordship, I in fact inquired. with-
That has to be there in the record, lordship.
They are not in possession of.
Okay, then why should you ask?
The state council.
But that is
They said they are not able to get
Lordship,
it.
that is not there on the record also.
No, correct,
So that
Correct,
has to be there on the record.
correct. It should be there. He says they are not able to get it. So.
No, I can give it to it, but like that has to be submitted to the court because
Correct.
like that.
You give
is-
it, okay. Okay.
Because
That is-
memo of appeal has to
No,
contain
correct,
that.
correct. That's why you'll have all the record. Yes,
Because
in the
otherwise I
list
just
after 2 weeks.
Why
We'll just say only 2 weeks. We will not say what is what, we have no point writing all this.
flush.
My lord, may I also?
Who are you?
My lord, I prefer the private respondents in this matter.
What do you want?
We were the petitioners, my lord.
Huh.
We had also filed affidavit in opposition in that petition. Those have also not been annexed, my lord.
You give it furnished to Mr. Chaudhary. He will
My lord.
file everything for you.
We will.
Bring it by way of an additional.
Additional affidavit? Huh?
I will-
Okay,
Please-
okay. We will not pass only, okay. List after 2 weeks to enable the parties to ensure that the pleadings are complete.
Flush, not.
All
Supplementary,
the pleadings are on record. Yes.
supplementary list for hearing item 43.
What is this 43?
I think your lordship has heard this matter on that. day.
Nirod Kumar Das.
Yes,
What is-
your lordship will just recollect the notice of the private respondent.
Oh, yes, yes. What is to be done?
I've checked it. All notice has been served and it's
Can
on
you just-
record. I made a copy for the court.
Okay,
Your lordship has to take this bulk. That will be difficult.
okay.
So pinpoint I am giving this
Yes.
for lordship convenience.
If it is served, then we can dispose it of.
Because the wakalatnama I have seen.
Fine.
For a respondent number 1 has filed.
Ah.
Wakalatnama. That's
And
I
how
have
many
given you
respondents
copy.
are there?
There are 3 respondents.
And then
There are
about two,
respond number 2, my lord, already it has been appeared. They have appeared, respond number 2.
respondent number 2 is,
Yes,
respondent number 1 is Sanjay Mandol.
yes.
Sanjay
Yes.
Mandol is
I'll-
represented.
My lord will kindly see that's a wakalatnama.
Yes.
Your lordship has seen that wakalatnama? This wakalatnama.
Nirod Kumar Das. Huh?
Yes, that's a respond number 1.
Yes.
That's a wakalatnama of respond number 1.
No, no, just a minute.
I have
It is
given,
Nirod Das and others, no?
yes.
You are the appellant.
I'm the appellant. So
Now,
private respondent.
no, respondent number, just a minute, we'll just check up this.
Yes, yes.
Musharraf Hussain.
Mustab Hussain.
Musharraf Hussain, respondent number 1.
Yes.
Now he is represented. Okay,
He is
fine.
represented.
R1.
Yes.
Then
Respond-
R2 is
Already
Roshan,
represented.
Sayada Roshan Ara.
Yes, he's already, wakalatnama is there.
Huh?
We
What
have
else?
downloaded. From the case record, we have downloaded.
No, this is the respondent number 1.
Yes.
Then respondent number 2,
Respond number
Roshan.
2, kindly see the next page, my lord.
Next page,
Next page.
petitioner advocate, respondent.
Yes, Mosaram, this.
G Assam, Kolita. Assam.
Yes.
What is it mentioned?
Yes. Document details, my lord will kindly see.
Document detail.
Saida,
Page
last-
number?
last page,
20.
28 to 22, history. Orders, you're like, this page, this, last page, 28. 28 to this page, my lord, this page you have seen, the orders of the High Court, orders of the High Court.
Respondent number 2.
Yes, 28 to 2022. Side Rosmanara. His worker, I is Tekya, Wakalatnama. Page mark nahi karta hai apne log. Lordship got it, my lord?
28 to Sayada Roshan Begum.
Yes.
I
yes,
Saikya, Waklanama.
Yes,
And then, so number 2 is also served.
sir.
Then who is number 3?
Number 3, kindly turn to next page I have given, my lord.
Yes.
Kindly turn to next page.
Who is respondent number 3 is Joyanto Bora.
Yes. My lord will kindly see, case taken up at 15 to 2022. Lordship got it last
Okay,
page.
okay.
Case taken up before
Petitioner
Lonala.
says that a respondent is deemed to have been complete.
Incomplete. That's it.
Okay, so 15 to. Okay. Okay, notice is served.
Notice is served.
Now what order was to be passed? We forgot.
Your lordship has heard this better.
Yes.
Because
If
there
you
was
can
a
remind
state-
us.
Yes, I'll remind, my lord. These are the pharmacists, my lord, under ESI they were working. So they initially it was health and family welfare. It was bifurcated. This department was bifurcated, labor and employment department.
Yes.
So they were serving since 2006. Once the labor and employment department was bifurcated, urgently they required this post to be filled up. Not only pharmacists, the laboratories.
Okay,
assistant
okay. So it was advertised
It
through
was
this
advertised
employment
through an
exchange.
employment exchange.
That is only.
Yes, and what we see on record, my lord, there all these fee names also were sent through employment exchange.
Only
they
see
did not-
this
Yes,
person.
yes.
Eight persons.
Yes.
8 appellants.
8. And this also 3, which is the
So
private.
8 appellants also were sponsored by the employment exchange.
All employment exchange.
Is it correct?
No,
Yes.
all these 3, which I am before your.
No, 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 no. Not about you, but other 8. 8, these appellants
Along with the rest-
appellants were not there, obviously, that's what they challenged.
Yes. The petitioners.
Petitioners were not there.
But I have seen.
So
my
the
lord-
learned single judge says that because it violates judgment of the Supreme Court, that judgment, what is that?
Yes,
Which is the judgment of the Supreme Court that, let us see that.
yes. That's 19 Union. That is 1996 SSC 2.
Para number,
Para number 7.
para number 7 in
And the Supreme Court.
1996, volume 6, SCC
They
216.
They said an employment exchange.
Let us see what the learned single, Honorable Supreme Court says,
Yes.
what exactly. let us see.
And my lord, what is most important, which the learned single judge said, that even forget about the advertisement, but there has a selection procedure has to be maintained. Like the learned single judge relied on a pharmacy act, but that particular was not in force because the labor and employment department bifurcated.
Okay, it became
Because there
under
was-
different.
There was no affidavit filed by the government. So in the writ appellate court, the court directed to file an affidavit.
And in
And-
affidavit, what has been
Affidavit-
clarified?
Yeah, they said that urgency is required, number one. That's why true employment exchange was given. Number two, all the procedure was followed. And it was interview was constituted.
And that a rule did not apply. And
They
that
did
was-
not apply because it cannot be applied because they bifurcated.
And let us see what is employment exchange restricted only to candidates from employer held not proper.
Yes.
In any requisition name from a name should also be called for minister to having valid and so. That we would sub. Then in what happened? What is the final direction? Come. We have
Yes.
appealed so then yes, next, the court so then having your so then. Let us see, para 6.
Para 6.
Para 6. Having regard to the respect, we have the view that. Yes, para 6, madam, yes.
Various departments were ordered. They were appointed to company. We were apparent that we were conferred handful of candidates sponsored by employment exchange.
In this case, was the selection process been completed? Can you just tell us?
Yes.
In this, in this particular case.
This
No, in
this
case.
particular case.
What was it?
Yes.
Why was it in the midst of process that it was intervened? Print out, take a
Yes.
print out, fatafat.
Because why the learned single judge, paragraph 8, kindly see. Why the learned, it was connected with para 7 with 8. Even the pharmacies will require issue.
Correct, we have, yeah.
This is what we learned. And learned single judge were right. Because at that time, nobody pointed out. If it was pointed out for learned single judge, the rule is applicable because it was bifurcated. That learned single judge were not aware of it, that it was bifurcated.
So the
So
only issue right now is to whether just because it was not advertised, would vitiate, render their appointments illegal.
Yeah.
That's the only thing.
one judgment I have sold, my Hargopal judgment.
And in the yes, also yes.
That Hargopal, last 4-line paragraph.
Hargopal.
Yes, in a-
Hargopal.
Yes. Kindly see last
Just a minute. Maybe you had
This is
you had
87.
earlier. You had Hargopal.
1987 3 SCC 308. I think I have given a copy to you all.
Let us check up here. Maybe Hargopal is there. Hargopal. Yes, I remember, but then it's not in the file.
Copy.
Just check up. It's a very lengthy judgment.
Lengthy judgments.
How many pages?
It's 9, paragraph 9.
How many pages, Hargopal?
Hargopal will be about 7, 8, 9 pages. Last is important, my lord.
The Hargopal is considered in this judgment.
Yes.
This court in have noted continued consideration exclusion of one and offend equally clause and held that taken it was not open to impose restriction of choice. But in view of the fact that even the paper would not reach many handicapped senses, it was held and responded through would not violate. On the other hand, would advance the right of appeal the restriction to eloquence and so.
The private party, my lord, who were the writ petitioner, their names were also sent. It is not that they did not send.
Who?
They did not, the private respondent, who were the writ petitioner in the case, employment exchange, their name also was sent. It is not that their name was not sent.
I see.
Because I have
That is
seen
what, that is
this-
how, where do you find that?
Page 77 kindly be seen, my lord,
Page
of the
77.
appeal. Of the appeal,
Page 77, yes.
the appeal. This was the list which was sent from different districts.
Oh, they were also sent.
They were sent.
Yes, please,
I
please take,
found one
please
and
take.
three.
No, only one, please
One
take
free. Page 77.
page 77.
77 list, it has been annexed. Serial number 26.
Mohammed Musarraf.
Yes.
Then what about the others?
83.
Mohammed Musarraf is just a minute, MD Musarraf. MD Musarraf is respondent, just
One, responder one.
R1,
Yes.
R1, page 77, serial number 26.
Hmm.
Then
Page 83 kindly be seen, my lord. The Jointo Bora. Jointo Bora is there.
83,
Yes, which is respond number. Respond number 3 as serial number 8.
Jointo Bora.
Yes.
Jointo Bora is respondent number 3,
Yes.
page number 83, serial number 8. Then
Yes. I could not find the other, my lord. But we made a statement that she is working in a
Who?
this Saida.
Saida.
Yes.
Saida is working where?
Yes, I kindly see, my lord, survey of Department of Health and Family Welfare at page 10,
Page 10,
10, 11, para 11,
page 10, 11.
11,
Page 10, para 11
para 11,
of your appeal.
my appeal.
Excellent, just.
I think that is why they have not appeared also. Para 11,
Para 11.
11, kindly see the
Appellant
appeal-
better, petition number 1 is well settled and have his own business
the
in
petition
medicine.
number 2 is presently serving,
Petition
as a
number 1
pharmacist.
is who?
is Musarraf,
Musarraf.
whose
He-
name has been sent.
Okay,
His
very
name.
well.
And
And
petition number 2 is
two-
presently serving.
A pharmacist in the Department of Health.
Health and
Who is it?
Family-
Petition number 2, Jointo Bora.
No, Jointo Bora is number 3. Which is number 2?
And petition number 2?
Saida,
Petition number 2 is Saida,
yes. Saida Rosana Ara Begum.
presently working pharmacist.
Yes.
And
That's
petition
what
number
it is.
3?
3 is also a firm, reputed hospital name is GRC.
Okay, J3.
I think all this, maybe, I don't know there. These 1 and 3, that name has been sent. They did not choose to appear.
Let us see this excise superintendent, para 3.
Yes.
These appeals so and so under Pradesh Administrative Tribunal. The admitted position respondent were not sponsored through the employment exchange for selection to 723 posts sought to be filled up from the furnished sponsored through medium. The respondent independent applied for constitutional claims, but they were not considered. Consequently, they approached the tribunal, sought direction for appointment. Interim direction was issued to consider case and appoint them if selected by the. Though the tribunal held the sponsorship of the candidate through medium was valid and not valid article, since many of the candidates came to be selected in terms of interim order, orders were issued to appoint and select. Thus, there is a difference between, there is a difference of opinion. We have various majority held that in valid article, no matter that there is appeal by Senate. Now, what was the ultimate direction?
Ultimate, my lord.
Ultimate, the fair play equally so and so, but did the court, the Supreme Court disturb? The appeals are according to dispose, no going around to disturb the direction for appointment. See, that is what we want to do because
Yes.
the
They work.
the law was settled, principle was laid down,
Yes, equity was.
but then don't disturb. I mean,
Equity was looking.
correct. That is what we were looking
Yes,
into.
I know your lordship. And here also their services, while deciding it, they said that they will be discontinued after 6 months.
Okay. Yes, Mister. Anything you want to add?
Well, in fact, the affidavit we have filed and we have only clarified the petition. So we said that the selection was done on the basis of merit.
Okay. Okay, Likho. And Mr. Lanet Senior Counsel assisted by Ms.
Yes, sure.
S. Sharma. Also, Mr. Dinar Lanet Senior Government Advocate, no? Senior Advocate for the state. He also there assisting,
Yes, she should.
also assisted by Ms. R. Gogoi. Non-appears for the respondents,
Private response.
private respondents. We have gone through the records. The reason why the respondents are not present before this court. As per the respondent number 1 was represented by counsel whose name also appears, no?
Yes, only name appears. Yes.
Whose name also represented by the counsel whose name appears. Similarly, respondent number 2 also was represented by counsel whose name also reflected in the
yes,
cause list.
yes.
Since they have not opted to appear before this court in spite of their name being shown, there won't be any legal impediment to proceed. As regards respondent number 3, the office note dated 15/2/2022 mentions that notice can be deemed to have been served in respondent number 3.
Yes.
Under the circumstances, we have the view that in spite of absence of the private respondents, the matter can be disposed of at this stage. Coming to the facts of the case, as may be relevant for the disposal of this appeal, it is noticed that the state authorities, that is the respondent number, that is
In the appeal,
you are that is the
4 and 5.
the Department of Labor and Employment, the Labor and Employment Department, Government of Assam, initiated a recruitment process for appointment to how many posts? What is that? Page.
Your lordship will.
Page 81.
Page
Page 81, that advertisement.
63 kindly.
Page 63. Advertisement issued, for appointment to 10 posts of pharmacists along with other posts of laboratory technician, staff nurse, A&M, bursar.
Yes.
Right, advertisement dated
The advertisement is.
4/2/2006.
4/2/2006.
Yes.
2006 for appointment to the 10 posts of pharmacists along with other posts of laboratory technician, staff nurse, A&M and bursar.
Dresser.
And dresser. The said advertisement was issued in respect of those candidates who were registered with the employment exchange.
Yes.
In other words, the said advertisement was not by way of public advertisement to inviting applications from all the eligible candidates, but only those who were registered with the employment exchange.
Yes.
Be there as it may, the petitioners, the respondents, the present applicants who were sponsored along with how many candidates were?
95.
95 candidates.
Yes.
Candidates participated,
Yes.
including respondent number.
No, respond number, they did not.
No.
1 and 3.
They were given
They were
sponsor.
given scope, 1 and 3.
1 and 3. Including respondent 1 and 3.
In the
Yes.
appeal.
He took part in the recruitment process. The present appellants were found to be successful.
Yes.
How many appellants were there?
We have here. We are,
7.
yes. Yes,
8 appellant.
8.
The present 8 appellants were found successful in the said post of pharmacists. What about the 2? 10?
In fact, 10 have been filed.
Huh?
Ten-
But
10
we
have been-
filed 8.
10 have been selected. No? Possibly they are not before this criminal court.
Oh,
Yes.
okay. 8.
8.
Appellants along with 2 others were selected for appointment to the said post 10 posts of pharmacists and accordingly were appointed. What is the order? Appointment order?
Appointment order, your lordship will kindly see at page 40.
Page 40.
40. 40.
White order dated 10 July,
No.
15
It's,
July,
Yes.
15 or 18, I don't know.
It's, yes,
Whether date, Tariq.
13.
13 July,
13
okay.
July.
Right,
41 with your lordship.
okay, 13 July 2006. 6.
Yes.
It appears after these appellants and the 2 others were appointed as pharmacists, it has been also that it appears that not only these 10 pharmacists but other posts were also filled up. Other posts advertised along with the pharmacists were also filled up in the same year.
Yes.
With which we are not concerned with. as the appeal is confined only to the post of pharmacist. It appears that after the appellants have been serving as pharmacists since 2006,
Yes.
their appointment were put to challenge by the private respondents by filing writ petitions in the year
2000 will be. Judgment is of 2006.
or I think they challenge immediately. I
Yes,
think.
yes,
Okay.
2006.
That after they are appointed, their appointments were challenged, put to challenge by the by 3 writ petitioners who are the private respondents herein in WPC number 3619 of 2006. And this court this court allowed the said writ petition by setting aside. What is that?
1310 to that page 99.
Page 99.
Operative portion is page 102.
What is that?
Page 102. 102 on the top. The selection should be made on merit by computer when the exercise company private must state they get selected become eligible for regular service or temporary should be
This allowed the
discontinued.
said repetition by directing that the post should be. Well, it was there. Your appointment was set aside.
Yes, appointment like discontinued. They are saying discontinued. Kindly see at para 11. However,
Okay, declared.
Yes.
This court declared that the appointment the private respondents therein, the appellants herein cannot be legally sustained, and accordingly directed the authorities to, what is the direction?
At page 102, the selection should be made on the merit by
And that
In note 13.
do go for a fresh selection process by
Under-
advertising.
Yes.
Full stop. The reason for in terms of Rule 13 of the pharmacist rules, pharmacist rules 1986. The reason for allowing the said petition can be found in reason for allowing the said petition are as follows.
Yeah.
The learned single judge, while allowing the petition, held that the Assam Pharmacist Rules 1986,
Service rules.
Service Rules 1986, which lays down the method for recruitment to the post of pharmacist was not followed. Secondly, the learned single also found that the the said selection process was confined only to the candidates sponsored by the sponsored by the
Employment exchange.
employment exchange and not open to all the candidates,
Yes.
which was violative of Article 14 of the Constitution. Full stop. While coming to the aforesaid decision, the learned single also referred to the decision of Honorable Supreme Court in Excise Superintendent Malkapatnam, Krishna District, AP versus KBN Vishwaswara Rao, 1996, Volume 6, SCC 216, which declared that restricting the selection only to candidates sponsored by employment exchange is improper, and wider competition should be ensured by publication of the recruitment notice in the newspapers with wide circulation, as to be consistent with the requirement of law under Article 14 of the Constitution. First of all. Next paragraph. The said this decision of the aforesaid decision of the learned single judge rendered on 31/10/2023.
Yes.
In the aforesaid writ petition number so and so 3819 have been put to challenge before this court. Next para. Mr. Digonto, the learned senior counsel appearing for the appellant, has raised the following grounds in assailing the said decision. First of all, it has been submitted that it is not incorrect on the part of the incorrect to hold that the Assam Pharmacist Service Rules 1986 was applicable, would hold a field for appointment to the post of pharmacist. It has been submitted that though the post was advertised was pharmacist, yet it was under the Department of,
Labor and Employment Department,
and not under the,
under the Health and Family Welfare Department.
and it has been submitted that the said aforesaid pharmacist service rules were applicable, were applicable in respect of the Department of Family and
Health and Family Welfare Department.
Health and Family Welfare, and it cannot be. It was not applicable in respect of the Department
Labor and Employment Department.
without there being any decision on the part of the Labor Department to have adopted the same rules.
Yes, right.
Therefore, in absence of adoption of the aforesaid recruitment rule, aforesaid service rules of 1986 to the Labor and the
Labor and Employment
Employment
Department.
Department, there cannot be any automatic application of the aforesaid rules, which belongs to another department.
Yes.
And to that extent, the finding of the single judge cannot be in accordance with the prevailing rules.
Yes.
It appears that learned single judge passed order as the same was not pointed out next para, as there was no affidavit filed by the state as regards the extent service rule which was applicable in the Labor and the
Labor and Employment
Department. This, however, has been clarified by the department in this in the appellate stage after a direction was issued by this court.
Yes.
To clarify as to the applicability of the aforesaid pharmacist rule 1986.
Yes.
In this regard, the state government had filed an affidavit.
Yes.
And it has been mentioned in the affidavit on filed on 17/12/2022, in which it has been clarified in para number 4. Para 4?
Para 4.
Para 4, to the effect that para 4? No, not para 4.
Para 4, 6, and
No, that it is not applicable. That these rules are not applied. You have not mentioned. Para 10.
Para 10, sir.
And that the Assam Pharmacy Service Rule 1986 governs the service conditions of the Health and Family Welfare Department and is not applicable to the employees of the Labor Welfare Department. And that these posts of pharmacists which are filled up comes under the Labor Welfare Department, to which the said rules are not applicable. We are first Mr. Nath Lanet, senior government advocate, also has also mentioned, has also stated that when the said advertisement there was no service rule applicable, nor the said service rule of 86 was adopted in the welfare department. Under the circumstance, we are of the view that the finding of the learned single judge as regards that finding that Assam Pharmacist Service Rule 1986, where provisions were violated, does not appear to be correct. Full stop. We now consider second limb of the reasons given in setting aside the appointment of the present private respondents of the appellants, which is on the ground that though the names and other candidates were sponsored by the employment exchange, there was no wide publication inviting application from other eligible candidates. As regards the decision of the Honorable Supreme Court Excise Superintendent Fenso, there cannot be any dispute about the proposition of law that in matters of public employment, necessary and wide publication should be adopted so as to enable all the eligible candidates to apply for, as it will be in tune with the requirement of Article 14 and 16 of the Constitution of India. However, Mr. Digonto, Learned Senior Counsel, has also referred to the decision of the Honorable Supreme Court in India versus N. Hargopal and others, 1987 3 SEC 308, wherein it was observed by the Honorable Supreme Court that while recruitment through employment exchange, that in absence of better method of recruitment, any restrictions, any restriction that employment in government department should be through the medium of employment exchange does not offend Article 14 of the Constitution. In other words, it has been accordingly it has been submitted that merely because it was not widely publicized as held by the Honorable Supreme Court in Excise Superintendent, and merely because it was the recruitment process was restricted to candidates sponsored by the employment exchange cannot render any such appointment to be illegal in view of the decision in N. Hargopal Supra. We have given our anxious consideration in this aspect. In Excise Department Superintendent Supra, the Honorable Supreme Court reiterated that in matters of public employment, widest publication must be widest publication must be adhered to, so that there will be equality of opportunity in a matter of employment available to the all eligible candidates. However, going through the said decision, we also have noted that in the said case, that the observation was made by the Honorable Supreme Court in respect of appointment to 723 posts or 73. What kind of post is this? No name of the,
This is
what post?
the presenter.
No, in Excise Department.
So Excise Department.
723 posts through the medium of employment exchange. And some candidates who applied independently without the medium of employment exchange were not considered. Accordingly, they challenged the recruitment process for the said 723 posts. Before the State Administrative Tribunal. That State Administrative Tribunal held that sponsorship of the candidates through the medium of employment exchange was valid and not violative of Article 14 and 16 of the Constitution. But the Honorable Supreme Court observed that many of the candidates came to be selected in terms of the in the meantime, and they were also appointed. The Honorable Supreme Court also considered the decision of the decision in of his decision, earlier decision in Hargopal Supra, and held that it would be consistent with the principles of fair play, justice, and equal opportunity if all eligible candidates are considered and not restricted only to the candidates sponsored by the employment exchange. However, the Honorable Supreme Court did not interfere with the appointments already made.
Well, one thing, I'm sorry for disturbing a lordship. At page 101, why the learned singer said the advertisement is required? Because at paragraph 8 is been spelled out. Kindly see at page 101.
Yes.
Even the pharmacy's rule requires issuance of appointment for direct, and it doesn't permit appointment, limiting the committee to only those who are sponsored by employment exchange. So had the rules would have been then this question would not arise. Learned singer said yes,
Rule permits advertisement. You have violated the rules. That's why he said that issues it doesn't permit appointment by limiting of. If this rule is not applicable, my lord, then it is permissible.
So, so though we are only fully in agreement with the principle, principle followed by the learned single judge in terms of decision of the Honorable Supreme Court Excise Supreme Malakam, that Article 1416 demands that equal opportunity be given to all eligible candidates and not restricted to the candidates sponsored by employment exchange. In the present case, what we find is that the appellants have been in serving since 2006 without any continuously.
Yes, sir.
Though their service were held to be declared were legally not sustainable by the learned single judge in his order dated 31/10/2013, the said judgment was state.
Yes, sir. I think
What is that?
on the list.
The impugned judgment was state. Was state on 9/12/2013. And the said stay order continues till date, because by virtue of which the present appellant they have been continuing as pharmacist since 2006.
Yes.
Stop. Under the circumstances, though, full stop. Next, consider. Though under circumstances, though the appellant's appointment as pharmacist may not be strictly in terms of the law laid down by Honorable Supreme Court in Excise Superintendent, yet keeping in view that they have been serving continuously since 2006, we are reluctant to interfere with their actual appointment. Full stop. While full stop. That apart, we also have observed that the learned single judge, while declaring their appointment as not legal, has observed that even the pharmacist rules, even Assam Pharmacy Service Rule 1986 require issuance of advertisement for direct recruitment, and it does not permit appointment by limiting the competition only to those who are sponsored by the employment exchange. If the pharmacist rule were indeed applicable, the said opinion of the learned single judge would be beyond impeachment. Yet, in view of our finding that the said Assam rule will not be applicable in the recruitment for to the post of pharmacist under the
Labor and Employment Department.
Therefore, said observation will not perhaps will be applicable. We also have noted that, as pointed out by Mr. Digant Lani, Senior Counsel for Appeal, that what is that they are serving in para 11 of your appeal?
Yes.
That
yes.
That at pay in even mentioned and so on.
Page 10, para 11. Page 10.
Okay. We also noted that at appropriate paragraph. So we have also noted, as submitted by Mr. Nad Lanet Counsel, Lanet Senior Counsel, Government Advocate, that initially that the department that what is it, page 60.
Page 60 by cabinet memorandum.
That by a cabinet, but this is your case also.
Yes, I have pointed out.
Okay, Mr. Digonto Das, Mr. Digonto Lani Senior Counsel for Appeal also has submitted that by a cabinet decision in 1998.
Yes. Kindly see the scheme bifurcated.
What is it? What is it?
The first he was earlier administered by
in which it was by which the certain dispensaries and hospital and 27 dispensaries
And one.
and one hospital, which were under the state insurance ESI scheme, which was earlier administered by the Health and Family Welfare Department, was subsequently brought under the administrative control of the Labor and Employment Department with effect from 15/8/1984. And a decision was taken by the Cabinet on 5/4/96 to create an independent separate cadre of medical and paramedical staff in the ESI scheme. Following the aforesaid creation of separate cadre, it became necessary to frame service rule for the medical staff doctors to regulate the recruitment and condition of service, and accordingly draft service rules were framed, called Assam ESI Doctor Service Rules 2000. From the above, it is clear that the authorities sought to prepare separate service rules without following the earlier service rule, which are governing the family and the
Health and Family Welfare.
Health and Family Welfare Department.
Yes.
Mr. Nat also, learned senior advocate also, government advocate also has also submitted that. Para, have also submitted that after the bifurcation, para number that you mentioned, that after bifurcation, there was of the aforesaid bifurcation, there was an urgent need to fill up 10 numbers of pharmacists along with other posts under the Deed and Labor and Employment Department, within bracket presently Labor Welfare Department, for which the Deed and Labor and Employment Department wide letter dated 4/2/2006 intimated a Director of Employment and Craftsman Training Assam to notify the vacancies to the employment exchanges in a notice board of the employment exchanges of various districts of Assam. And thereafter, not only the present appellant, but some other candidates, including the respondent number, read petitions number 1 and 2.
1, 2.
1 and 2. 1, 2 appeared.
Yes.
Full stop. We also have stop. Thus, full stop. Thus, though the posts were not widely publicized as contemplated under contemplated as held by the Honorable Supreme Court Excise Superintendent Supra, the fact remains that the recruitment was made through employment exchange by considering all those candidates were sponsored by the eligible candidates, and there was an element of competition amongst the eligible candidates. Be it as it may, we also have noted that, as pointed out by learned senior counsel for the appellants, that the petitioner, writ petition number 1,
At page 10, para 11.
page 77 you mentioned. Page 77.
Well, in the affidavit, Lordship is
Okay.
taking up the affidavit.
Is well settled and he runs his own business of medicine. Similarly, petition number 2 is presently serving as a pharmacist in the Department of Health and Family Welfare in the Tasteful PHE. And the petition number 3 is presently serving as a pharmacist in one of the reputed hospitals, that is GNRC Hospital. Full stop. However, full stop. Having considered all the aspects, and also keeping in mind that the present appellants have been serving as pharmacists since 2006, continuously till now, we are not inclined to disturb their services. However, if there be any further vacancies to the post of pharmacist, let the post be filled up by wide publicity and not restrict to the candidates sponsored by the employment exchange as exchange. Full stop. And as per the rules, you have not framed any rules. Okay. Okay. With the above observation, the present appeal stands allowed. Allowed accordingly to the extent the impugned order dated 2020 of Lana single stands modified to the extent indicated above.
Yes.
May I please, your lordship? Lord, the order, non-compliance, my lord, may be pleased to find. Is that, my lord, page 16, my lord? Page 16 is the order, my lord.
Notice.
My lord, may I pray for an observation that pendency may not be a bar, my lord? My lord. Voice is not.
In contempt matters, we can't pass all these orders. It will create more problem.
Right.
You file a separate application. Yes, next.
Item
Anybody-
2,
Item number 2, yes, anybody for item number 2? Yes, 3 weeks, rest of post immediately. Yes, next. Item number 3,
item 3,
yes, Muzumdar, 3 weeks, rest of post. Yes.
item 4,
Gaurango, yes. 3 weeks, rest of post immediately. Yes.
item 5,
Item 5, what is this?
My lord,
Item 5.
contempt.
Huh? What is item 5?
Petition, madam.
Item number 5, what
It's similar to item number 3.
is item 5? Okay, same.
Same, my lord.
Obliged.
What is the item number 6?
supplementary
Agarwal.
list for admission. Item 17 to 30.
17 to 30. What is this? Oh, please wait. Next.
For orders, item 6.
Item number 6. Yes, what is this? Agarwal store, what happened?
I appear for the.
Remaining amount is there, my lord, balance amount is there, my lord. Calculated.
Principal amount has been paid. There is a balance amount declaring the interest of
69,000 something, my lord.
64 rupees is still due, my lord. Doctor will post it after 3 weeks. In the meantime, we will making an arrangement to release that amount.
Who are you?
I am for the Commissioner GMC.
Why you are not paying?
Well, because this already there is an order to pay the amount. The
Then you
principal-
pay. Why is the problem then? You pay.
Well, I'm
Huh?
Doctor will post it after 3 weeks. In the meantime, we'll.
What will do? What 3 weeks will do?
Doctor will kindly see the order dated 4/1. That is absolutely clear that 6.
Oh, you want to pay or you say you are,
I'm going to pay. I'm
you
going to
pay, you pay.
Not so.
Okay, and Mr. Das, also Mr. Bora. Mr. Bora submits that the dues amounting to rupees
69,064 rupees.
will be paid within
Within 3 weeks, my lord.
3 weeks. Okay, full stop. Next para. Let affidavit file immediately thereafter of the payment, filling which so and so will appear in person. If paid, the contempt may be closed. This one so and so. Yes, next.
13 March. Item 7,
Muslim Ali, what is this? What Muslim Ali?
Last two occasions they taken time, lordship, to comply the order, but not.
What order? What order was passed?
Lordship, order was to pay some amount, lordship.
How much? What did the sum mean?
13 lakhs, 31,000 lordship.
13 lakhs.
Yes,
Who are you?
I am the contractor, lordship.
No contractor. Yes, 13 lakhs you pay, madam. You are not paying.
Your lordship, PWD has already sanctioned the amount and sent to finance.
Very
So we
good.
have done our part. Your lordship.
Okay, very well. You filed, and Mr.
P. Sharma.
Are also Miss,
R. Gogoi,
who submits the PW has,
appearing on behalf of BNAT.
we not submits that the PW department has already,
We have already sanctioned the amount.
Sanctioned the
and sent to
amount.
finance.
the
And
met-
has sent to finance department.
and has been sent to finance department for approval. And accordingly, it will be paid. The list the matter again on when? How long will it take? How long it takes to sanction approval? How much? Do you have any? 3 weeks. This have the 3 weeks to apprise the status of the payment.
Fixed it, no one fixed it.
Mr. You are a contractor. Yes, after 3 weeks.
2nd of
Yes,
March.
Yes, next.
2 feet. Item 8,
Item 8. Arun Saikya.
Yes, Lordship. On the
What
last
is the-
occasion, there was a direction to obtain the updated instruction.
Vitom Saikya, what is this?
Here, my lord, some payment has been made, my lord.
About what?
Some payment, the same statement was given in the last.
Huh?
Yes, my lord. In fact, my lord,
For the remaining amount, we have moved to the finance department, my lord. But
How
from
much?
last session, my lord, they have not given the budget to us, my lord. So we again wrote to the finance department.
Regarding what this is a area of
Payment
salary.
of area
Area salary and this, Lordship kindly say on the last occasion, there was a direction to get this up-to-date status of payment of area salaries.
They have not allotted the fund for last financial year, my lord. For this year, my lord, we are submitting it, my lord.
And the
So we need another 1 month time, my lord.
And the petitioner is also.
If the amount is not, budget is given, then what will you do?
Well, because we will depend on the finance department, my lord. We have already submitted a proposal, my lord. Half of some amount has already been released to the petitioner also, my lord.
How much has been
Around
released?
3 lakhs, my lord.
3 lakhs. And how much remains to be
Around
released?
16 lakhs, my lord.
16 lakhs.
Yes, my lord.
How old are you?
He's still working, my lord.
Working,
Oh, you're
Lordship.
still working.
Yeah, exactly, Lordship. When there was a direction to release the regular salary also, that has not been done to the petitioner. And this is the order which has been put to this contempt.
In terms of this
11/12/2020.
I have filed a review,
Lordship,
my
there
lord,
is a
and my lord was
direction of this honorable court.
against this order, my lord, I
Salary
have
and
filed a review, my
allowances to
lord.
be paid and continue to be paid to the petitioner is admissible under the rules. And that has not been done.
So what will you do? Tell us.
1 month time, ma'am.
1 month is too much.
1 month is too much.
Because
What
for several
job?
location, the same instruction.
What
they can
is
have
the
same
post you
instruction.
are holding?
The same post there,
Post of
senior assistant, Lordship.
senior assistant.
Yes.
I mean clerical job.
Yes,
Clerical
Lordship,
job, my lord, in the office
inspector
of the
schools.
Inspector of school, my lord.
Inspector of school.
Yes.
In the office of the inspector of school.
Toraido Sunari.
In the meantime, give some from some head to borrow some money from some other
That
department.
is the, my lord, thing is that, my lord, we have to raise the budget, my lord. In fact, on last year, we have submitted the proposal. The fund for the area salary, my lord, that has been exhausted, my lord.
You
Yeah,
given to some other people.
Yes.
Yes, my lord.
And the direction of
Only
this
the
honorable court has not
3
been
lakhs
taken into
amount,
account.
3 lakh odd amount was there, my lord. That was paid to the petitioner, my lord. So for this year,
3
my lord,
lakh
we'll
long
definitely
And
back.
this
pay, my lord.
3 lakhs was paid when?
In the
long back,
month of
Lordship.
October, I think.
This last
Last
October.
October, my lord.
Last
October or November, my lord.
Okay. 3 weeks, huh? List of the
Yes,
3
yes, my
weeks
lord.
to enable Mr. Khotunia to apprise this code. As to the
Lordship, in the
status.
meantime, the amount may be released, Lordship. Again, he will come with the same story that this, it has been given to the finance department. Because
In
this
that case, my lord, finance department may be implemented as a party. responsible, my lord.
repeatedly the same,
I tell you, implement finance
Yes, my lord.
department.
I may be allowed to do that, Lordship.
Yes, Mr. The petitioner may implement the concern of finance official of finance department.
Yes.
Yes, sir.
Item 9.
Item number 9.
We have received the verification of the petitioner's documents from the NCT, my lord. A little time and we can make the appointment.
Yes, regarding my lord,
6 weeks.
to the appointment for to the post of principal, my lord. My
Principal.
B.Ed degree was under, my lord.
That was being
said
examined by the NCT. We have received the.
When was the order passed?
My lord, order passed on, my lord. 11/8/2021, 11 of August 2021.
August 21, we are still doing
My
verification.
lord, we have to have his B.Ed degree verified by the NCT.
Ah,
There were
so-
several rounds of litigation regarding those NCT certificates, my lord. Now the NCT has verified and given it to us. We are now.
They have
contemplating
verified
the-
it?
Yes, yes, they have.
That is clear. Then what is the problem? Issue tomorrow, by tomorrow, day after tomorrow. Monday,
No, but-
Monday, this on Monday,
Monday because.
Wednesday,
Well, it has to
one
come through the
Wednesday.
finance
It
department
has
first.
been submitted that the state authorities have verified the credentials from the NCT. Which have been about which the NCT has cleared. Accordingly, there should be difficulty in issuing the necessary appointment order. Let it be issued this on Friday. Wednesday. Next. Item number
10.
Kailash Chandra. Yes, what is this?
My lord, kindly see page.
Tell us, what is your problem?
My lord, petitioner working in MPC.
Who is for the response number 2, resta post? Has it been served?
My lord,
Response number 2,
as per office note.
neither AD card, no answer. Who is response number 2?
My lord, Director of Elementary Education.
I go and give Dusty. Petitioner may serve upon the response number 2 by Dusty.
My lord, I have also submitted the representation before filing the IA, my lord.
No, newly impleted respondent number 2,
Yes,
no?
I had submitted the representation.
Dusty by usual process. Why is that? We have taken steps,
Yes.
but we don't know whether it has been sub or not. Notice, huh? Neither AD card nor unsub notice
But the
have been received back. That was, we are talking of last year. September.
and that was office note 29 to.
Notice was issued by Resta Post on 23/8 August. After that, nothing is there. So you take Dusty, he is available. Petitioner may serve the notice upon respondent 2 by Dusty. This after 2 weeks, yes.
Item 11.
Petitioner.
Mahendra, yes.
Retired from service, they are applying for pension. This court has directed to give provisional pension that has not been released. Till date.
Why?
It will be 1 week time, my lord, to get this updated status.
You pay the provisional pension, what's the
At least
problem?
provisional pension, I'm not getting anything.
You are working as what earlier?
Teacher.
These teachers, they are educating all of us.
My lord.
Without them, you would have been sitting
I
here.
just pray for 1 week.
You will not be standing there. You don't pay these poor teachers.
My lord.
Start paying,
For
start paying.
survival, provisional pension.
Any pension, what is this?
Just a week time, my lord.
Okay, list on so and so, Tariq Dibo next week. On the prayer of Mr. Son.
15 February. Item 12.
Item 12, yes, what is this?
I'm going to press for some time, my lord.
Mr. Khatania appeared as number 1, my lord.
Okay. I want to file anything?
Yes, my lord.
Okay, Mr. Fatna prays for how long?
3 weeks, my lord.
3 weeks time to file affidavit. This after 3 weeks.
And my lord, respond number 2 and 3 by Dusty, my lord.
Petitioner may serve notice of the 2 and 3 by Dusty.
My lord.
Item 13 also I'm appealing, my lord. Here also I'm seeking some time, my lord.
For respondent number?
1, my lord.
1. And other respondents are there? No.
No, my lord. Respond number, only also respond number.
Okay. 3 weeks time?
3 weeks, my lord.
Okay.
My obligation.
Item 14.
Jyotish Chandra Das.
So Lordship, I have prayed for 3 weeks time, Lordship.
Matter relates to non-payment of compensation, financial assistance, Lordship.
What kind of financial?
Lordship, for due to loss of the land in flood edition, Lordship.
Flood.
As per present instruction from Lordship, the Contempt Lordship, the fund is not available for SDIM department, so we are not able to. So Lordship may fix the matter after 3 weeks, Lordship will get it.
What are you doing?
Lordship,
What
I
are
have
you
lost
doing?
I have lost my valuable land, Lordship. Nothing,
Correct,
Lordship.
but otherwise, what are you?
Lordship, I am, Lordship, I have some business in my locality, Lordship. I have land.
Brahmaputra has taken your land.
Yes, Lordship.
There's a problem.
All
Normally
agricultural
your Brahmaputra yearly visits, yearly takes away land of everybody, little bit.
My all agricultural land gone, Lord.
And we can't sue Brahmaputra also. Only Gogoi will.
Yes, Lord.
Okay, 3 weeks. These are 3 weeks.
Item 15.
Pinku Das, what is
Yes,
this?
the petitioner is deprived of his salary, my lord, for the last 3 years, my lord. He
You're
is
working as what?
assistant teacher of a LP school, my lord.
LP school. Hey, why are you giving? Yes, madam. Who are you? Who are appearing? Dr. Vijaya Chaudhary. What happened?
Notice
Yes, notice has been served or no? No.
not served, my lord.
You served then.
Dusty may be.
Neither is a Dusty permitted. Notice upon respondent. Sole respondent?
Sold,
The respondent by Dusty is permitted. Yes, next.
Item 16.
Biren Chandra. Yes.
Here in this case, Lordship, for last 2 years, the petitioner is not getting his pension. So recently on this 3rd of February 2023, one communication has been received from the senior accounts officer pursuant to the direction of this honorable court. He has been implemented. Now that particular direction has been given to the director and stating that I am authorized you to draw and disburse the arrear pay and allowances on the establishment pay bill from as per the rate specified in the enclosed statement of to Chandra Bora retired as additional director. Now in that view of the matter, Lordship, some direction may be given to the director to process the entire release the entire
Who is the director?
Director.
Who is representing for director here?
In this case, Lordship, director and the secretary has been made as a party.
But who is appearing for director?
Nirodha Devi is the director.
I am appearing for the secretary.
No, who is for the director? Who is appearing for the
In the last
director?
election, some person has appeared.
Anyone
Yes,
appearing?
yes, yes, Lordship.
Any
Someone has appeared
vakil?
in this case.
Huh? Who is appearing for Nirodha Devi?
Director SCRT.
Simanto Shantanu Bora, probably.
Where is Samanta Bora? Where is Samanta?
Shantanu Bora.
Otherwise, Lordship, he has got the relief. I have received the instruction. His pay authority already issued, Lordship.
Correct, you have done your job,
Yes.
but the director has not a release.
Exactly. Director has to do the other part.
Lordship, it is only issued
3rd
on
of
3rd of
February.
February, Lordship.
3rd of February, very good. So we'll by next,
Exactly. Lordship. Some
next
direction.
week, what is
Yeah.
it? Director. 3rd of February. You are the retired additional director?
Yes, Lordship. Additional Director SCRT, Lordship. And that was 2 years back.
Or Mr.
SP Chaudhary.
SP Chaudhary. Or also Mr.
B Kaushik for respond number 1.
Who are you?
I am
Response number 1 is the Secretary, Lordship.
Secretary. And also Mr.
R.K. Talukdar for
What?
Accountant General, Lordship.
Response number?
3.
3.
Last occasion he was impeded. Lordship.
And where is this Nirodha Devi? Non appears or what?
Yes, yes, the last occasion this standing council appeared, Lordship.
Who?
I think Mr. Shantanu Bora will appear. He is the standing council.
Where is
of the
Mr.
SCRT.
Shantanu? Where is Mr. Shantanu? Yes, Mr. You call. This is a contempt, serious matter. Otherwise, this lady has to appear before this court. You have been Mr. Talukdar, Land Council for response number 3, submits that necessary steps have been taken from the side of response number 3 by authorizing the director, SCRT Assam,
To draw and disburse.
to draw and disburse the arrear pay and allowances in respect to the petitioner. What communication dated 3/2/2023. Under circumstances, nothing prevents. Therefore, under circumstances, the response number 2 can certainly release the arrear pay and allowances directed to be paid in terms of this court's order. How long normally it takes?
Lordship, it will hardly take few days.
Oh,
Lordship. Yes.
Lordship,
normally this kind of thing, how much takes normally?
I don't have idea.
Suppose, do you have any idea? Suppose once it is released on 3rd, today is 6th.
3 days.
Third means 3rd February, no?
3rd
February is 5 day. Now Saturday, Sunday, holy, Saturday was working day, Sunday was a holiday, today is 6th.
Lordship,
How long it takes
we
normally?
have forwarded the proof post, Lordship. I think it
Oh,
will take time.
post.
Yes, Lordship.
Post office.
Yes, Lordship.
And
Proof
take
post
1
will
month.
Lordship, normal post service.
No, the petitioner can directly give a hand over this communication to the director.
But
Lordship.
this is not the original.
Personal copy was also forwarded to the petitioner.
Exactly,
Lordship.
Lordship.
Okay.
One
Lordship,
copy has been
serial
forwarded to the petitioner also.
Oh, then director, what can director will say, I have not received. You are for a director. You are appearing, Mr. Bora, you are appearing director.
Yes.
They kindly take this, you take instruction. How long? Please take a, Mr. Bora appearing for the director, response number 2, has been, is furnished with a copy of the said authorization letter dated 3/2/2023. Let him come with an instruction
Lordship.
by next date.
May I pray?
So that as regards payment, to be made to the petitioner.
Yes.
My friend will provide me two sets of copy of the petition, the contempt,
Sorry?
2 sets of copy of the contempt petition.
Contempt, in the last occasion he was given one.
You give another, you will get
Yes,
your.
I will get 2 sets.
You are not a peon, you
Yes,
are
yes,
a, that's give.
Yes,
You get some money now.
Yes. will
Mr.
give you
Bora
2
will
sets.
ensure,
Exactly.
otherwise see.
Some
here-
direction may be given to, specific direction may be given, Lordship, within a limited period of time. This.
So they are saying they
Yes.
are asking for the instruction by next week. You
Yes.
will come with the instruction, then
Exactly,
you will
Lordship.
pass order.
Exactly.
Maybe they have already taken by the time. Furnish a copy,
Yes.
whatever required.
Today I will give him a copy.
So you are next week, you come with what has happened. Yes, you do that. Wakalanama, everything. Yes. This again, next week, did you?
16 February.
16 February, next week.
Next week, 16 February, no?
Let it be on 20.
Why so much of delay?
Let it be on 23rd, madam.
There is no reason for dragging this matter because
No,
this person is not
because
getting
letter
pension
is
for-
there.
Exactly, the person is not getting pension for last 2 years.
Warrant is there. You have
Yes.
to execute a warrant.
In the meantime, let me get the instruction. Let it be on.
No problem. Today is 6. List on
16, sufficient time, 10 days time they will
16.
get.
List on 16.
16 lordship.
List 16.
Yes, exactly, lordship. There is a specific direction of this.
Okay, 16. Yes, yes.
Supplementary list for admission 70 to 50.
You said GST because the GST now is over. Huh? Then he says no, in spite of GST, there is a notification issued by the state government.
Lordship, that is,
Huh?
yes, Lordship.
What about notification? Have you challenged the notification that is contrary to divorce GST? Yes,
That-
file his affidavit in opposition. Have you gone through his affidavit?
Yes, Your Lordship, that,
And
that notification will not affect us. That
Why?
notification is in our favor only, Lordship.
in your favor?
Yes, Your
That is,
Lordship, have a look, the notification dated
page
running page 234.
234.
Lordship, in my affidavit.
234. This Gazette notification,
Yes, yes.
29 June.
Yes, Lordship.
Okay.
Lordship,
In exercise the
exercise
power
of-
so and so, so and so, so and so. In the permanent use one, environment council. So environment council, GST council.
Yes, Lordship.
Exempts intrastate supply of services description.
Description as prescribed in.
So 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 and so. Label, so this is what intrastate, huh? Exemption is what intrastate.
Within the state.
Within the state, huh? Now, why you said this is not applicable in your case?
Yes, Lordship.
Why you are saying this is not applicable? Because it is
No.
intrastate.
No, no.
What? Then?
Interstate, that this notification says that now the committee is exempted. They don't have to pay service tax. That is not related to my case, Lordship.
Can you read?
Hereby exempts the intrastate supply of services of description.
Below. So
Below.
Lordship, there, agricultural.
What is that?
Agricultural committee gives services, those are exempt. That means,
What is it? Which number? Serial number?
serial number, Lordship.
Lordship, the second part, Lordship.
Serial number, which has been exempted?
My copy. Page 68, 220, Lordship.
No. In this notification, 26 June 2017. Have you gone through this notification? Annexure H.
Yes, you have an extension.
So exempts the interest supply so and so. Now, in this notification, in which serial number your case comes?
Heading.
Lordship, the next part, Lordship, intra-state supply of services of description as described in column 3 on the table below from so much of the state tax leviable, Lordship. This says our marketing tax is state tax, Lordship.
Exempts.
No, Lordship, state tax is leviable.
Exempts the intrastate supply of services
Is exempted.
from so much of the state tax. Leviable thereunder. So exemption from the state tax. That is what section notification 17 says.
That is the agriculture produce is. Lordship,
Exempts, that is exempted. Exempt means exempted.
Intra-state is exempted, but the state tax is leviable, Lordship. We collect the cess after GST only, that is the cess state tax, Lordship. So that is prescribed in page number 246, running page. It is a headings,
Page
page 246. 54, 98,
246, serial number.
54.
Services relating to cultivation of plants,
Last-
rearing of so and so, food.
Lordship,
Then?
G, Lordship, last,
Eh?
the last part, Lordship,
Huh.
the bottom, services by the agriculture produce marketing committee or board, or the next page, services provided by a commission agent for resale or purchase of agriculture produce. Lordship, they being the commission for resale, Lordship. So they are liable to pay cess.
Services relating to cultivation of pine. No, but then you read, no? Services relating to cultivation of plants and rearing of all life from animals,
Lordship.
except the rearing of horses for food, fiber, raw material, or the material by way of
by
Oh,
way
but
of
then
one.
they are not engaging in cultivation of plants. What is the main heading? Main heading is services relating to cultivation of plants and rearing of all forms of animals, except the
Except-
rearing also, but they are not engaged in that. They are not relating to cultivation plants and they are groceries.
Or other similar produce, Lordship. The raw materials or other similar produces, products or agricultural produce by way of.
Correct, but then it must relate to cultivation of plants and rearing of all life forms of animals. You have seen the principal part. Now these are exemption will come follow. What is that? What is that area of operation of the law or exemption? Services relating to cultivation of plants and rearing of all life forms of animals. Like see chicken and all those hatchery and all those things.
No, so after that, Lordship,
See, their case is that after the GST came into existence, because the judgment you are relying Supreme Court, that is before GST.
no,
Huh?
Lordship, after GST.
After GST 2010 wala, that Supreme Court judgment you are.
21, Lordship.
But this is regarding and what has happened to that decision?
Lordship, in India, the
And
Supreme Court says that.
Here he said, okay, here it says that what is the division bench? I say, and you have not provided with a division bench order. That 2008 or something like that.
2009, Lordship.
Huh?
2009.
No, 9. What is that? It is
That was
reported.
service.
What is it? Have you furnished a copy of that? No.
So
Because the Honorable Supreme Court says you go ahead with that.
After the judgment of 2008.
Earlier, I see. No, not this one, not this one.
Also,
This
is
I have got. Other judgment, 2008 wala.
Also, I have separated.
8 wala. 36. Yes, have you gone through it?
This, which, citation?
2008 for GLT 366.
Not name of the.
Name of this, name is the Assam Roller Floor Mills Association versus State of Assam.
We have a copy.
You have got a copy. What do you say about this? What was directed in this case?
My lord, that case was relating to section 21. So section 21 was challenged that time first. So Supreme Court ultimately said, no, they will not collect at the check gates, but they will collect at the sale and purchase. It was, we had challenged that 21 should be strike down, but that was not done. Supreme Court has upheld that. Supreme Court says, no, cess they can levy, so they will levy the cess. So after cess was leviable, then they brought in how to overcome this judgment, whatever was said not to be collected from where it was asked not to be collected from the check gates. So to overcome this, the legislature, they inserted section 21A. By inserting section 21A, check gates were made available, and at the entry check gate, they were collecting the tax. So that also continued. We agreed to that because they have brought in by legislature 21A to overcome this judgment. So we were bound by it. So we were paying. But after coming of GST, 21A was cancelled, and they said 21A check gates you cannot collect. That is their notifications, which I took your lordship through in their affidavit.
Where is that?
3 notifications, lordship, they have attached.
Which one?
Affidavit in opposition filed by them, lordship, page 52, 53, and 54.
52.
Yes, yes.
The Assam government is pleased to notify that all the check gates so operated by so are withdrawn.
Yeah. From 31st
Annexed
July.
D. It is your.
Yes, Lordship.
Yes.
So it is withdrawn then.
Then 53, lordship. 53 says that 21A is gone.
In pursuance of all check gates in province so are hereby withdrawn.
Yes. Established under section 21A, lordship may kindly see.
Established under section 21, withdrawn.
Withdrawn. So then they say, okay, 21A is gone. Under section 21, that levy we will continue because check gates are gone. 21 levy will continue.
And what is 21?
Now I'll take your lordships to 21.
So then 21A is not applicable.
Not
because,
applicable.
So only 21 will be
Only 21
applicable.
is applicable.
And then 21, what does 21 say? About whatever deeming provision, explanation 2 to 21.
Yes, lordship.
The cess referred to in section 21 shall be paid by the
Lordship, before-
purchaser of the specified agriculture produce.
Lordship,
concern.
before Lordship goes to section 21, Lordship may kindly come to the preamble of the act, because that also has to be seen why this act was at all brought into this state, where it will be applicable. If it cannot be made applicable to a transaction that is happening in Delhi, Lord.
Yes.
Let me
Yes,
read
yes,
the
yes.
first page.
Yes, yes.
To provide for better regulation of buying and selling of agricultural produce and the establishment of market for agricultural produce in the state of Assam as for matters connected herewith. Where it is expedient to provide for better regulation of buying and selling of agricultural produce in the state of Assam and establishment of regulated markets for agricultural produce. So this act was made and it will extend to the state of Assam only. Now they are trying to make this act applicable by section 21 to a transaction that starts in Delhi. Now I have a judgment with me, Lordship, which says according where will be the sale said to have commenced and which transaction will be taxed. It doesn't depend on delivery.
Copy.
I have not 2 copies only because
You copy, array, council, you are very, you become
we'll pass on the
poor.
copy to
Your marketing company, you are become poor over. You can't give a copy to him.
because this case is going on for so long, Lordship. We have not got any fees also. Really, we are poor, Lordship now. He doesn't allow us to take the order. We'll become poor only. Lord.
Agriculture Market Committee,
Yes,
1997.
Yes, your Lord.
Now, before we
come-
proceed, we'll examine that also.
Yes, yes.
So according to you,
Hmm.
suppose according to you, section 21 will be applicable.
Hmm.
Huh? If that is so, when they can levy the cess?
When purchase or sale takes place
Huh.
in the market area.
In the market area.
In the market area.
So, and it has to be paid by the purchaser, na?
Purchaser.
So, if I go and want to buy this wheat from you, I have to pay the cess,
Yes.
not you.
Not me.
That is your case.
That is. Lordship,
And therefore, this market can realize the cess from whom?
from the purchaser.
From the purchaser.
From
How
the
they recognize? Suppose I go to the market
Yes.
and purchase 100 kilos of wheat. How this market wala
Actually,
will?
Lordship, this act is what, Lordship? This is for the local products, like when we buy betel nut or a lot of rice or anything, those things, there is a regulated market area where the local sellers, they sit for that. And
Yes.
so that they get the fair price in that place. That's why this act had been brought down. That some may charge very high money and all from them. So that regulated market area, when they sit and they do the purchase and sale, that time they take the cess from there. And at that time, the purchaser is liable for paying the cess, Lordship. We have other cases also in betel nut
Anyway,
cases all over.
Okay, for example, I want to purchase 100 kilo of wheat
Yes, yes,
from you. So I have to pay the cess.
yes.
Okay.
Yes.
And how this market will impose cess on me?
The market will not impose cess from me.
How they will collect the cess?
When the purchaser and seller is there at the same place, because that time the purchaser and seller is face to face when these things happen. So what happens? The market inspectors are there. They immediately cut the slip in form K and they take the cess.
At that time.
At that time itself.
When the actual.
When
How
the
do you collect the cess? Otherwise,
Before
apart
the-
from your check gates are closed. You can't collect at check gates. Check gate.
After the,
You can't collect in the check gates because you have closed in 2017.
17.
So how do you collect? Suppose you say that I am entitled to. How will you collect the cess? You tell us.
We collect the cess in the railway yards. That is our notified market area. The entire districts are market area, notified market area. As per the act laws.
Railway yard.
Yes, because we have the information that this consignment has been received. Our marketing inspector will collect the cess. Because what happened was it when any delivery took place.
But then that these goods, according to them, were not sent by somebody else, but sent by A, the same person who is doing that. He purchased in Haryana.
in Haryana, they from Delhi.
No, Haryana name some Rewari or what is Rewara? What is it? Or Delhi some name? any name.
Bhivani is there.
Bhivani, suppose he said, I went to Bhivani and I booked this consignment from Bhivani. So it is I who is sending to my own home for sale. So that sending is not part of is always part of but then it is post purchase, not part of the purchase, because I have already purchased, paid the money to this seller in Bhivani. I have booked this consignment in Bhivani railway station to Tinsukia, and where she is going to sell in Tinsukia. So why will you collect the cess?
Initially, we collect the cess in a segregates. Our segregators
They are gone.
They are gone. After that, we collect cess in a market area. The entire district is our market area. We can collect cess in anywhere. Because if any delivery took place, let's say
Okay. This entire district is a market area. There is no dispute.
Yes.
Okay, very well. So it can be railway gate or railway station or bus adda, or wherever these trucks they unload.
Yes,
No
yes.
problem. Okay. When you collect the cess, you collect the cess because it is being brought by this seller.
For delivery in a market area, we collect cess on the point of delivery point.
Delivery
Delivery point is our market area. Their delivery took place in a market area. Any consignment delivered in a market area. We have not collect cess for sale prices.
Now, what is that? On what section you are?
Section Lordship,
Come to
section 21, explanation 1(3), Lordship.
1(3).
1(3).
In pursuance of sale
Sale
or
or
purchase
purchase.
or agreement of sale and purchase.
Or purchase of such produce is delivered in the said area. Said area means our notified area, market area. To the purchaser or to some other person on behalf of the purchaser.
See, this agreement is not the first agreement. According to her, there are two agreements. One agreement from the actual supplier of the goods which she is going to sell. Then another agreement will be in the market which she is going to sell it to the consumer. So two sales are there.
Here when they are telling
There are
the
two-
sale, yes, the purchaser is not there in front. There has to be seller and purchaser, two persons, and then the inspector will collect from the purchaser. So where is the purchaser?
So
There's no definite purchaser.
when the goods has arrived in the railway yard,
Anyway,
railway yard,
in the district.
in the same, very well. So you are entitled to realize the cess in the railway yard. But at that time, there is no seller or purchaser, is the owner. One single person, one single entity. He just brings his goods to by railway. So there is no transaction which takes place at a time. Transaction has already completed according to you, isn't it?
Yes, yes.
Transaction has already completed there in Bhivani or whatever it is, Firozabad. So he only brings the property, the goods in the for sale. When the sale takes place, then you charge the cess. Otherwise, you will be charging twice.
No, let's say we charge only one.
No. Otherwise, you will be charging twice, because when he is going to sell in the market, after railways, he will bring it to his shop, dukan.
Yes,
Now he will sell it. There also your men will be standing. Oh, you are selling. Give cess, he'll purchase. So you have collected the cess in the railway yard. You could have collected if this fellow from Bhivani brings and sells it to in the railway car, this is delivered. According to the petitioner, he had already purchased. He is already the owner. Post-purchase, post-transaction, what he is doing is just that the transportation of a purchased good. There you cannot levy any tax. You can levy tax when he in turn sells to another consumer in that market area. Then you can realize the cess.
For that, let's kindly have a look the rule, the definition of buyer.
Yes, rule. Page number.
Page number 1 of the second part.
Page number. Here, page number. Whose book is this? Huh? Is your book?
Yes, this book.
Whose book is this? Somebody has given? Our High Court book, Niki. Oh, High Court book is torn. Hey, sab kitab gulo bhalo rakhibo.
Page 32.
Page 32. Yes. Page rule number.
Rule the definition.
Rule
2.1.
Yes, 32.
No, Lordship, his definition of buyer, that is
In the rule, in the second part.
Page number 30.
Page number 1, Lordship. Then the second part of the book, Lordship, the rule is the second, in the second part.
Rule. Act is there and rule is,
By Lordship. Bias includes the second.
where is it? Bylaws of mention.
Definition 2, Lordship.
Just a minute, I'm not able to get it.
After 73, page number 73, it will come, rules. Rule
Oh,
will
there are
start.
so many pages here.
Lordship, after page 73.
After page
Lordship may kindly check after page 73. The rule starts after that.
Assam Regular Market Rules 1975.
yes.
Rule number?
Rule number 2.
Rule 22.
Bias includes a person buying any agricultural produce himself or on behalf of any other person or organization or firm as his its agent or as commission agent for resale.
Correct.
So they being the commission for resale, Lordship. So they become passenger when they are delivered to place in the market area. Also, Lordship, kindly have a look the rule 23.
Rule 23.
Rule 23. So they are the
Rule 23, page
33.
Page 33.
Lordship.
Yes.
The accounts transaction and sales to be maintained. Lordship, one
Yes.
Lordship, the petitioner of the licensee.
Mm-hmm.
Every licensed dealer shall submit to the committee a return in Form M showing his purchase and sales of each transaction of agricultural produce within 4 days from the date of transaction. Provided that in case of that is not required, Lordship, they have not submitted any transaction, Lordship, in an M form, Lordship.
But the M form, what is the show of the M form? Page number?
Page number M form is, Lordship. Page number 59. In the rule part. Second last part.
Return of daily
Return of
purchase.
daily purchase and
Sale.
sales.
Date of transaction,
Date of
name of
transaction,
community,
market
name of
committee.
seller, from which purchase, wait, whether cess is levied, and cessable, name of the buyer, sold to whom, wait. No,
M
correct.
form is there in the writ petition. Lot of M forms are there in the writ petition. From the M form only we could ascertain that they have collected it at the check gate.
No, Lordship, we have not collected any second, Lordship. It's to the first submission.
Writ petition, I have annexed the M forms, Lordship.
Purchase, sold. What is this M form?
M form, Lordship, I have attached it in the writ petition.
So what does it mean? Who is this purchased from and sold to? What is the
Yes.
meaning?
Yes. Lordship.
Page number?
Page number, this is 121A is the K form, that is the slip, that is the
One.
receipt. 121A. Page number.
120 is the care form, Lordship.
But then this purchase from in the inside, not in Delhi, Bombay, Calcutta, America.
No, Lordship.
The purchase that has to be inside that Assam. That is what you are saying.
Lordship,
Page 120.
121, then Lordship, then next page, Lordship will see the form M is there, Lordship.
Form M.
From that only I show.
Name community pulses.
Yes.
Jagdish Prasad Bhawarlal.
Naya
Naya
Bazar,
Bazar. Name of the
Delhi.
purchase.
Yes.
Wait. Purchase. Rupees. Whether less. Yes. Huh?
To
Is a
sell
level.
Sifsagar, and then,
Is you amount leviable 7,000 you have paid.
yes, your Lordship. That
And
is the
then?
receipt, just the page before, no, Lordship.
Sold means what?
Sold to self, Lordship, to self Sifsagar, Lordship.
Document submitted by the trader that consignment specify against so and so Saga in the vehicle number for resale.
And it's
For
in the
resale,
vehicle, Lordship, still in the vehicle. Vehicle are for resale in its present form or in its process form within the notified market
Lordship,
area.
What is this says realized in full means who is signing this?
Marketing inspector, Lordship.
But how, you say that cess is not leviable, then why you are paying this purchased from this Bhawarlal in Naya Bazar?
Lordship, they don't allow our vehicles to cross the thing without paying the cess. In 20, he himself submitted so many times. From 20, they are not collecting at the check gate, Lordship. So we are not agree after 20. From 17 to 20, what they have collected in the check gate. This is at the check gate, Lordship. In a truck, when the vehicles signed at this is on the basis of the value in the whole truck, Lordship. It's not one transaction. And it is we have purchased from Naya Bazar, Delhi, and brought it for myself, imported for myself. The delivery note is also in my name. I have brought in, Lordship. And that definition which he has shown of buyer, that is not applicable, Lordship. I'll take your Lordship once again to section 21 and the buyer's definition, because he's changing his stand every time.
No.
Lordship, form M, Lordship may kindly see.
Hmm.
To self it is, to self. Name of the buyer is self, Lordship.
Purchased from Bhawarlal, sold.
And name of the buyer to whom sold.
Sell.
It is, I'm buying it. I brought it for myself.
Now,
keep it
once you, this is pulses, no?
Yes.
Once you sell in the market, then those purchasers will again pay.
Yes,
again.
they'll
So
pay.
there'll be twice.
Twice that one I have paid because I brought in market area of Delhi. So I paid Mandi tax. Then I brought it, it is my goods. I brought it here. Then when I will sell it, the purchaser will pay again. Then I will be the seller. So I'll be exempted and the purchaser will pay.
And this 7,000 which you have paid to whom?
We have paid to the marketing inspector who stops the vehicle at the check gate and they takes the money. And this they have been continuing in 17, 18, 19, 20 till again another notification was given. Central government's notification had come that stopped collecting all this from the check gates.
When did they stop collecting?
2020. Otherwise, criminal proceedings will be there. There is a judgment, Lordship.
No, when they stopped collecting, when, which year?
2020, Lordship.
2020.
Yes.
You are not imposing any tax after 2020.
After 12/6/2020.
Why?
Because for the commencement of a new act, we stop it.
Which commencement? Which
The
act?
Central Act, but it was now it was also closed. After that, the notification was issued, 12/6/2020.
Let us see that 12/6/2020 when you stopped. Where is it? And you are agree for a collection from from which?
From from 31st July
17.
Yeah, 1st July 2017. From the date from which GST has become applicable, Lordship.
And this form M at page 122.
Yes, Your Lordship.
Which date is this?
This is 1/9/2019.
19?
2019.
You said that this also you are not liable to pay.
No, Lordship. From 2017, I'm not liable to pay. They are collecting at the check gates. Then again, an ordinance,
But you say section 21 is applicable.
Applicable.
They are saying that this we collected in by virtue of section 21.
No, they cannot collect by virtue of section 21, there has to be a sale and purchase, lordship. If lordship may kindly come to section 21 once. That is there what he's confusing again and again he's making that submission. That buyer and seller, that definition cannot change according to his wish every time.
Yes, tell us section 21.
Lordship, the
You-
explanation,
Ah.
the explanation if we go
Ah.
to lordship. For the purpose of this section, all specified agricultural produce shall, unless the contrary is proved, be deemed to be bought or sold in the notified market area. And they say the whole of state of Assam is notified market area. So that is good enough. Now such produce is taken out of proposed to be taken out of the said area. That means out of this market area.
So we are
Then
not concerned.
We
This
are
one.
not concerned with this.
Okay.
The agreement of sale and purchase thereof in respect of such produce is entered into such area. That also has not been done. There is no agreement entered into between the buyer and the seller because there is no purchaser at that point. Then the third one, in pursuance of sale or purchase or the agreement of sale or purchase, such produce is delivered in the said area to the purchaser or to some other person on his behalf of the purchaser. So when how will I become the purchaser in this delivery? How it is delivered to me when I am bringing the goods myself for my use, for resale? How I will become the purchaser here? There has to be two identity for a sale and a purchase, lordship. In
But
pursuant,
then how do we ascertain whether it is actually purchased by you in say Ghaziabad, for example, you are bringing from Ghaziabad.
yes, yes.
How do you ascertain that you have actually paid the payment in Ghaziabad?
Yes, the invoices are there, lordship.
Where is it?
The invoices are
That
there
is
in the
only
petition,
invoices.
lordship. Lot of invoices.
That they can verify.
That they can verify,
Yeah,
lordship. That they can verify. I have bought from outside the state, that they can verify. And these
So
acts,
for example, in respect of these pulses which you have sold on 1/9/2019,
yes,
where is the
I
document to show
have
that?
sold, I have purchased.
Correct,
Yes.
that you have purchased and you have paid, that, do you have the invoice in respect of this? Do you have in this, any example to show?
Yes, your lord.
Show us with the invoice, any of the transaction by which you become the owner, which you have already paid. Show us that any example here.
For that,
But
lordship
yet
had
we-
directed us to file another affidavit. We
so-
had filed an affidavit. in
show that.
regard. Lordship, this is affidavit filed on 4/2, lordship.
Correct. Kanpur, Mandi and all those, but regarding which one? You have to show that this is a particular assigned consignment which I have already paid in Kanpur.
Yes, Lordship.
What is it? By showing this will not help you, no. Therefore,
Lordship, kindly have a look there. affidavit
show us
also.
any,
Yes,
Page number
your lordship.
266.
show us any
Lordship,
transaction
yes,
where you have paid in Kanpur. You are showing Kanpur
yes,
and you have brought it from Kanpur to Tinsukia
yes,
or
your
whatever.
no, but lordship, these are birthday traders invoices, lordship.
No,
Lordship.
no. Bhatter traders, whatever it is, you show us
Kindly have a
Bhatter.
look at date
These
also.
also Bhatter trader, no?
Yes,
Now, you show us that already, what is this? Krishi Utpadan Mandi,
yes,
Bhatter Traders Shiv Sagar, Assam.
yes.
कृषि उत्पादक का नाम क्या?
Lordship, there are two
मसूर,
Yes.
मसूर,
Yes.
चना दाल, ना?
Yes,
चनी. This we have purchased. Now he has purchased, correct. Now in respect of this, you have been charged the cess?
This Mandi tax has been collected there.
No, I am not talking of this money. That's correct. Assuming that you have paid in Kanpur,
Yes,
then you become the owner of that.
yes, yes,
Now, when you came to see your Shiv Sagar,
yes.
no, you have been taxed on this particular. How do you show that? That is what I am saying. Then
Lord-
we may say,
Yes.
yes, you cannot levy tax in respect of those which you have already purchased, shown, that you can verify.
Lordship, actually what happened, these are maybe particular names are not matching because the files are in files, lordship. So, and it is so many years, lordship, 17, 18, 19. If so, for verification, lordship, it will take time. They have to verify each and every transaction, whether I paid, the invoices are of outside the state, lordship.
So it is your duty to prove it,
Yes,
not for
Lordship,
the,
that is-
therefore you have to show
Yes.
that this is, I am the owner.
Yes,
Yes,
Lordship.
your lord.
I have already become owner because I have paid so much in
in
Ghaziabad.
Yes.
So I have become the owner. That duty is on you.
Yeah,
But if they are able to show, then you cannot, you have to return the levy
Yes.
then we cannot listen.
Then we-
That is what then.
That is that is the direction that we are seeking from Lordship. If we will show each and every trans.
Directed them that to produce this document that they have paid the cess in Kanpur when they have.
Not says, they are not able to pay says. That they have, no, they have already purchased in Kanpur and become an owner. Whether Kanpur market charges says from them or not, that is not concerned. You know, you are not an agent of Kanpur market. You are concerned only in Assam. Now you have to show if you are able to, if you are satisfied that he is the owner, this Bhattar.
Yes.
And when he brought in Assam, he brought in as an owner of the produce,
Yes,
not
yes.
as a purchaser, in a sense being delivered by the seller in. Suppose the seller says, okay, I am sending this to your destination. Then the sale takes place. Then you are entitled to realize the sales from him.
Yes, sir. This is.
But now, but if they say, no, I am already owner when I send this purchase goods, there was no transaction.
Can you have a look at 266 page number?
Page 2?
266 in the affidavit.
Oh, we'll continue.
Transfer
415.
Transfer invoice. This is transfer.
Page
266, their affidavit.
Two?
Their document, 266, running page.
Running for 266.
Not check.
Annapurna Udyog.
Yes, Gostil.
Ah.
In the top, transfer invoice, Salan.
Okay, whatever it is, we'll say that if it is transfer, if it is, so what this court subject to, just listen to me, if I'm, just also listen. Suppose what direction we can say is that section 21 allows you to levy cess. Fine, very good. When the cess is to be levied against anybody who is either a purchaser or seller.
Yes.
It can be levied to a purchaser or seller also, when the purchase or sale takes place.
When purchase or sale takes place.
So not the purchase seller, but only when there is a purchase or sale takes place.
And the delivery took place, the commodities.
And delivery took place. Now, he says, Bhattar trader says that I purchased before Assam. I became the owner. I am just transferring my property to Sibsagar. So therefore, there is no transaction when I am bringing it. But if the, see from, say Bhattar Traders in say, what Gungunwala, no, Bhawarlal, Naya Bazaar says, okay, I am sending this consignment, we have purchased from me, you pay me, then it is sending. If Bhawar sends, then he is the seller and he is the purchaser. Then perhaps you may realize the cess. But his case is that Bhawarlal is not sending. From whom I purchased, but after I purchased from Bhawan, I became the owner. But I am disclosing to you because this is the one I purchased. I am not a original stock market there. Wholesaler. Wholesaler is a Bhawarlal,
yes,
from whom I purchased. Then I sell in turn in. But that purchase and sale took place in Naya Bazaar, not in Assam.
Lordship, that is.
If that takes place in Assam, then you can levy from me when I take delivery in railway station. That is his case. No,
Lordship,
isn't it?
the Supreme Court judgment also is in reference to market committee only.
Okay,
They
we'll
says-
continue. We'll continue. Hearing will continue. In Supreme Court, why is that market? Which company was that judgment?
Agricultural Market Committee versus Shalimar Chemical. Versus
If they have any demand, according to Act, there are other images there. So Lordship can dispose the
Lordship will dispose is only 21A is not, they cannot enforce 21A.
Any taxes will be levied, Lordship, they can.
21A, if
Concern
after
committee, Lordship.
GST Lordship, no 21A, that is enough for petitioner Lordship. After GST, no 21A Lordship. 21A, they cannot levy. They have levied under section 21A.
Today itself, Lordship.
I can't dictate now, it's too late.
Lordship.
Maybe next week I will dictate. So you are relying on this agriculture,
Agricultural bucket committee.
any other judgment you are relying on?
Lordship, paragraph 42 of this judgment will show when delivery in happens and how,
Para
this is also a
42.
matter relating to cess.
Para 42.
Para 42 will make it clear. Delivery doesn't decide.
Okay,
Delivery doesn't decide the sale.
okay.
He through a state act, he's trying to levy on a transaction which starts in Delhi. That's a new law that he's going to set up.
We are concerned about Assam Lordship.
Okay, okay.
We collected within the state of Assam.
All these judgments are there, no? All the judgments which have been cited, huh?
Yes, your lord.
Or, okay. Are you citing on any other judgment apart from this judgment, Supreme Court, contempt?
Lordship, this notification, Lordship, I may give a copy to, by which in 2020 they were asked to again stop the collection law.
What is that
So I
notification?
have already supplied it. 12/6/2020.
12/6, no?
12/6.
12/6 is there. 12/6 is there.
Notification.
Hey, kitab to rakhibo file out, no?
Yes, sir.
Okay,
On 16 February.
okay, 16.
16, no,
Thursday.
16, not 16, Lordship, any other day other than 16, any other day. 16. 15. 14 also, Lordship.
14.
14 koriye, 14.
14 will.
14.
14. Much of.
Yes, sir.